Hello friends, today we are going to start with chapter number 9. The name of this chapter is Startup and its Registration. This is very interesting topic. Why? Because we are going to learn whatever is happening today. So you are going to learn what actually has happened in the recent past, that is in 2014, until now it will be continued. So our Honorable Prime Minister Shri Narendra Modi ji, he announced Startup India campaign. Okay, this was announced on the Red Fort. When it was announced, after that immediately, basically it was announced on the Independence Day, then within 6 months of that, the action plan was also announced. So we are going to learn what is Startup India campaign, who all are the eligible entrepreneurs. This chapter basically comprises of entrepreneurs and whoever want to start their business, they are called as the startups. So under Startup India campaign, who all are the startups which government will be focusing on? The government wants more and more startups in India. Why? Because if more and more startups are there, we will have more number of goods, services, new products. We may increase import and export because of that, and ultimately our economy shall grow. So before starting with this chapter, I want you to see one short video on this. Okay, let's have a look. I hope you have seen the video. So whatever you have seen, you might not understand it completely as of today. But yes, once we finish our chapter number 9, we'll be conversant with all of this. Now coming to your academics part. This chapter is very important because the weightage of this chapter is around 8 to 12 marks. You may expect 8 to 12 marks questions on this. So without wasting our time, let's start. So as I told you, the name of this chapter is Startup and its Registration. What are we going to learn in this chapter? We are going to learn about what is a startup, who is the regulatory authority of the startup, what is the procedure to register the startup, also what is the action plan of Government of India, who will get benefits under this, who will not get benefits under this. We are going to see what are the tax exemptions available to startup, also exemptions under Companies Act 2013. So without wasting our time, let's start with our chapter number 9. Now, this is an entrepreneur. Mr. A. Mr. A dream is to start a business. What is the dream of Mr. A? He wants to start a business. So when he is thinking, what all things will be required to start a business? So Mr. A has a business plan. What does it have? It has a business plan. Along with their business plan, there are certain other requirements as well. Now, what are the other requirements? He will require a capital, right? Because can you do anything without money? The answer is no, it's not possible. Each and everything requires money. He may also require office place or a place where he can operate, right? So he requires place as well. He shall require with the raw materials. He shall require with the manpower. Manpower are very, very important. Can he do everything himself? The answer is no. He may also require professional help. So many things are required to start up a business. So entrepreneur may have all the things, may not have all the things. If he has all the things, no problem at all, he can start. But if he does not have so many things, then what? Then any person who wants to start a new business, new word is very important. So any person who wants to start a new business or existing is a businessman but he wants to go for a new product, he can approach the Startup India. Now, why the government is doing Startup India? Why our government wants to help the entrepreneurs? Because our government has more money, so it's spending on it. The answer is no. Government of India has some action plan. He wants more and more entrepreneurship. What it wants? More and more entrepreneurship in our country. So when there is more and more entrepreneurship in our country, new products will be there, or they may also deal in new services, right? Because of this, there may be growing demand, okay, for our new services and products. We may receive demands from foreign countries. So when we receive demand from the foreign countries, we are increasing our exports, okay, or we may increase our FDI as well. Foreigners may come to India for investments in India, right? So all this will lead to what? All this shall lead to growth in our economy, okay? All this shall lead to growth in our economy. I hope this is clear. So this is the main plan of Government of India. So now the campaign which we are talking about, that is Startup India campaign. This Startup India campaign, as I told you, it was announced on Independence Day. Startup India campaign was announced on 15th of August 2015. It was announced on 15th of August 2015. Our Narendra Modi ji, the Prime Minister, announced this by standing on the Red Fort. And the action plan on this, was announced on 16th of January 2016. The action plan was announced on 16th of January 2016. Okay, so please remember the dates, very, very important. So before going ahead, I would like to tell you what is a startup. Okay, they are talking about startup. So can everybody get advantage of this? The answer is no. Only whoever is a startup that can gain the advantage. Now who is a startup? So we are going to learn definition of a startup. Now definition of startup is given by one authority, earlier known as DIPP, now known as DPIIT. Please remember the name of this authority. The full form of this is Department for Promotion of Industries and Internal Trade. Okay, what is the name? Department for Promotion of Industries and Internal Trade. This is the regulating authority of our startups. So definition of startup is given by whom? DPIIT. So as per DPIIT, who is a startup? First, when we talk about entity, okay, the startups have to be either a private limited company or LLP or a registered partnership. Okay, so when anybody wants to do a startup, they want to be recognized by DPIIT, they either have to incorporate private limited or a LLP or a registered partnership, not any other entity. Understood? Now as far as your entity is concerned, the entity has to be new entity. Okay, entity has to be a new entity. New entity means what? Your private limited or a registered partnership or an LLP should not be a consequence of merger, demerger, amalgamation, split up. It should be a new entity, a fresh entity. So it is not formed because of merger or demerger or split or amalgamation. It should be a fresh entity, a new entity. Okay, this was a second criteria. An entity shall be a startup, or entity will be called as a new entity for first 10 years of incorporation. Okay, so once a private limited is formed, it is startup for first 10 years. After 10 years, it is no longer a startup. Understood? So entity shall be treated as a startup for 10 years from incorporation. Very, very important. So once 10 years are completed, your entity is no longer a startup. Clear? Understood? After that, fourth one. In this 10 years, if any entity which is a startup, the turnover exceeds 100 crores, it is no longer a startup. Okay? So, the turnover of the entity shall not exceed rupees 100 crores in 10 years. Okay, it is not clubbed. Okay, in every year it will be taken differently. So every year, that is an individual year, none of the year turnover is exceeding 100 crores. If any point of time turnover is exceeding 100 crores, it loses the status of a startup. In the next year, even though it has a turnover less than 100 crores, still it is not a startup now. Once you lose the character of startup, again you cannot get it. Clear with this? It is not like a small company. Simple. Okay. Yes. After that, the main object of a startup or main object of an entity should be dealing in some goods or services. Okay, so they are dealing in what? Goods or services. This goods or services has to be new or innovative, something new, or there has to be some value addition. That means in case of existing goods and services, there has to be some value addition that is important. If the goods and products are not new and there is no value addition, it is not a startup. Clear with this? Because government wants new goods and services to come up. They don't want the existing goods and services. Fine if it is existing, but there has to be some value addition to it. Got it? Clear? Great. So now we will revise all these points one more time. What is a startup as per a DPIIT? First, what is the DPIIT? Department for Promotion of Industries and Internal Trade. It has given definition of a startup. What is a startup? An entity, either a private limited, LLP, or a registered partnership. It is new only, not because of merger, amalgamation, demerger, or a split up. It will be startup for first 10 years from the incorporation. After 10 years, it loses the character of the startup. After that, in those 10 years, none of the year turnover should exceed 100 crores. If it exceeds 100 crores, we are losing the status of a startup. Also, the goods and services we are dealing in should be very new. If they are existing, some value additions has to be there. This is the definition of a startup. I hope you have understood. So let's end our introduction video over here. From the next video, we shall be learning what are the strategies or what is the action plan of the startup. So let's begin with the next topic, that is strategic plan for Startup India campaign. I hope you have understood what is startup, what is the definition of a startup. That is very, very important. In your books, we have given you definition little later. But when we start studying, we should start it first, right? We should know what is a startup first, and then only we can know the action plan and all. So let's begin with the action plan. The action plan is little big. Okay, so you have to learn this. So basically you might get a straightforward question on this, or you may also get a case study on this. So let's begin. The very first action plan given by our government is fund of funds. What is the action plan? Action plan first of all is fund of funds. Means what? Government of India has allocated around 10,000 crore for startups. So is Government of India giving those funds like that only? No. Because whatever we get for free, we don't have value for that, right? And this 10,000 crore, ultimately it's a money of a taxpayer only, right? So government have to utilize those funds nicely. On the other hand, they also want to encourage the entrepreneur. So they have taken a middle way. So what they have done, Government of India has corpus of 10,000 crore. This 10,000 crore corpus, it has given to Sbec. Now what is the Sbec? Small Industries Development Bank of India. So Sbec shall be looking after the 10,000 crore surplus of a Government of India for the startup. Now is Sbec going to invest in the startup? The answer is no. Sbec is also not going to invest. But Sbec shall give these funds to various AIFs. What is AIF? AIF are your alternative investment funds. These alternative investment funds, these are SEBI registered funds. Okay, so all of these are your SEBI registered funds, and they are also expert in the investment. So Government of India wants to give money to the entrepreneurs, but also want to make sure the 10,000 crore is not wasted. So if I say to Government of India, I want to start a business, please give me money. Do you think it is so easy to get money? The answer is no. Okay. So what has Government of India done? Allocated 10,000 crores for the entrepreneurs, but given that to the SIDBI, SIDBI will allocate the funds to AIFs because AIFs are very, very expert in knowing the business. They may forecast also at which business will be stronger, which business will not work. So wherever AIF thinks fit, AIF will invest in the equity of the startup, or if it is a partnership or LLP, the contribution of a startup. Okay, so what this AIF shall do? All this AIF shall invest in startups. How? Equity, or they may also invest in the contribution. So I hope you have understood how this fund is allocated. Government of India given to the SIDBI, SIDBI to AIF, AIF to the ultimate startups. Okay, so AIF shall be allocating these funds only to those startups which are recognized by DPIIT. So recognized startups may come to AIF, okay, where the allocation of fund is given, and if AIF thinks fit by looking into the business, the structure, the plan, they may allocate the funds. Okay, so this was the first one. Now going to the next one, second. Second talks about the credit guarantee fund. Credit guarantee trust fund. Now this credit guarantee trust fund is started by your Government of India. So what will Government of India do? Government of India shall allocate the funds into this credit guarantee trust fund. This credit guarantee trust fund, it shall give guarantee, or it shall give guarantee on behalf of your startups. Okay, what it shall do? It shall give guarantee on behalf of the startups. To whom? Someone called as banks. Okay, so when any startup comes to the bank, when any startups come to the bank, the startup may get a collateral free loan. What kind of loan it will get? It will be collateral free loan. That means startup need not put any of his asset as a mortgage with the bank. Okay, so bank may allot or give collateral free loan to the startup. And who is giving guarantee to the startup? Credit Guarantee Trust Fund. Who has created that? Our Government of India. So Government of India will be funding this CGT fund. CGT fund, with the help of those funds, will be giving guarantee to the bank. If startup failed, we shall be giving money on behalf of the startup. Clear with this? And every year 500 crore fund is given for this. Okay, so every year Credit Guarantee Trust 500 crore fund is given to them. So this is a Credit Guarantee Trust Fund. Please listen to this. By this, what is the help to the startups? Startups may get a collateral free loan on this. Okay, how much they can get? They can get loan up to 1 crore rupees, collateral free. Great enough, right? So now we'll go to the third one. Third one talks about relaxation in government policy in public procurement. Now what is this public procurement? a government of India also requires various goods and services. Like we have income tax department, that is ministry, that is a government. We have MCA, that is a government. So even they require the goods, air conditioner, office space, staff, the services. So even government of India is a buyer of goods and services. So from whom it may buy? So whenever, suppose government of India requires 200 air conditioner for its new office, so it shall publish an advertisement in the newspaper saying that we are accepting tenders for supplying air conditioner to this ministry. Okay. So any interested party, okay, any interested party who is eligible to send tenders, because eligibility criteria is there for sending the tenders. What is there? Eligibility criteria. Eligibility criteria is divided into various things. They should have experience, they should have turnover, they should have capital, they should have the no default system, all these things are there. So this eligibility criteria is relaxed when it comes to the startup. So startup, those who don't satisfy certain criteria, even they can send tenders to the government. Because startups are new, they cannot have experience, right? So for startups, if they want to give tenders to the government, they are relaxed two criterias. What are criterias? The turnover criteria and the experience criteria. These two criterias are relaxed. Okay, relaxed means what? Any startup who does not comply with the turnover criteria or the experience criteria even can give tenders to the government, and government may accept that also. Why? Because they are the startups. Simple? Yes. After that, fourth one. Now there are certain tax incentives given. Certain tax incentives are given to the startups. Now, to which startups they will get the tax incentive? Only and only which are recognized by DPIIT. Okay, so tax incentive shall be given to startups who are recognized by your DPIIT. The startup which are not recognized shall not get any of the tax incentives. Okay, so very first tax incentive they have, it is under section 80 IAC of your Income Tax Act. Please remember this tax incentive along with the section numbers. So section 80 IAC of your Income Tax Act. What does it say? It says 100% tax exemption, total tax exemption for consecutive 3 years out of block of 10 years. What does it say? Once you are recognized startup, if you are eligible under 80 IAC, out of the 10 years, for any 3 years, you can claim 100% tax exemption. So you don't have to pay a single rupee tax on your income. Okay, but it is for 3 consecutive years out of total 10 years. Clear with this? So this is applicable to whom? There are various conditions for this. Conditions to be satisfied for 80 IAC. The very first condition says that this product, that is goods or services, it has to be new or there has to be some value addition to it. It has to be new or some value addition to it. Along with that, the entity, the startup entity. Now tell me, who all can be a startup as per definition of DPIIT? The answer is correct. Private limited, registered partnership or LLP. But 80 IAC is applicable only and only to private limited and LLP. It is not applicable to the registered LLP. So if any startup is a registered partnership, it shall not get advantage under 80 IAC. Okay, so for 80 IAC you have to be either a private limited or an LLP. So we will write the conclusion, therefore 80 IAC is not available to registered partnership. It's not available to the registered partnership. Clear? The first condition and the second condition. There are other conditions as well we are going to look into when we learn detail of this. But I think you have understood what is section 80 IAC. Complete 3 years exemption from block of 10 years. Now let's proceed with the next exemption. I hope you have understood the exemption of 80 IAC. Okay, now we are going to the next exemption, that is exemption number 2B. This is exemption under section 56 to 7B. How do you read 56 to 7B? This is also called as angel tax exemption. What it is called as? Angel tax exemption. Okay, so I'll give you an example on this. There is a company called as ABC Private Limited. Okay, ABC Private Limited issues its shares. So when the shares are issued, okay, we will take out what is the market price. So if market price of that particular share is around 100, but ABC Private Limited issues share at rupees 110. So basically they are issuing shares at premium. What they are doing? Issuing shares at premium. So whatever is our premium amount, in our example it is 10. On this you have to pay angel tax. Which tax you have to pay? Angel tax. Okay, so whatever is the difference, whenever any company issues shares at premium, that is more than the market price, then they have to pay tax on that. Now why will anybody subscribe to that shares at premium? Because company is having very strong capital structure along with the business plan. Okay, so everybody will take benefit of that in future. So everybody is ready to subscribe that share at premium also. So whenever any company is issuing shares at premium, whatever is a difference, whatever is a premium, on that angel tax is applicable. So now coming to your startup, whenever any startup is issuing shares more than the market price, that is at premium, they have to pay the angel tax. But exemption can be there. Okay, exemption can be there. To avail exemption, they need to do two things. First, they have to apply for exemption. Now how to apply for exemption, we are going to see that. They need to apply to the DPIIT for that in form number 2. In form number 2, they have to apply to the DPIIT saying that I want to take angel tax exemption. Along with that, they need to comply with certain conditions. Now what are the conditions? This all we are going to read in detail in upcoming videos. Okay, so this is a angel tax exemption. I hope you have understood. First exemption was about 80 IAC complete tax exemption for 3 years. Second one 56 to 7B angel tax exemption. Now we are going to the third kind of exemption. This is exemption under section 54EE. 54EE talks about exemption in LTCG. LTCG is long term capital gains. Long term capital gain, and this exemption is available to the startup. This exemption is available to the startup. We will understand this with the help of an example. Assume there is an asset of a startup. There is a asset of a startup. Now startup sells the asset, and company was holding this asset quite long. So now startup is selling the asset. So LTCG shall apply. So on profit, what shall apply? They have to pay long-term capital gains. So on these long-term capital gains, they can claim exemption. How they can claim exemption? By fulfilling certain conditions. Now what are the conditions? Conditions are as under. First of all, whatever is the amount of profit, okay, that they need to invest in government securities. Where they need to invest? They need to invest in the government securities. When they have to invest within 6 months. 6 months of sell transaction. They have to invest within 6 months of sale transaction. And maximum exemption limit under this section is up to 50 lakhs. So LTCG will be exempted only up to 50 lakhs. So someone's profit is 60 lakh. So will they get exemption of entire 60 lakh? No. They will get exemption up to 50 lakhs and they have to pay LTCG on remaining 10 lakh rupees. I hope you understood this. So to sum up, whenever any startup sells its asset and long-term capital gain is applicable on that sale, they may get the exemption if they invest the amount on which LTCG is applicable in the government approved securities within 6 months of transaction, and maximum exemption limit is 50 lakhs. Clear with this? Okay. Yes. Few more things are there which we will look into little later. So these are the 3 important things. After that, the 4th one. Again, this is a LTCG but little different. The section is 54 GB. It is LTCG, so section number has not changed. 54 GB. So it is capital gains exemption. Now it is not to a startup, but it is to the investor. Even this we will understand with the help of an example. There is a person called as Mr. Ramanik Lal. Who is that person? Mr. Ramanik Lal. Mr. Ramanik Lal sells his house property. What does he sell? He sells his residential property or he sells his house property. So when somebody sells his house property, capital gains is applicable. Yes, they have to pay capital gains tax. Now if someone wants to avail exemption on this, when somebody wants to avail exemption on this capital gains, they have to fulfill certain conditions. Now what are the conditions they have to fulfill? Condition number 1, whatever amount they receive on sale, amount received on sale, that is to be invested in equity of a startup, where they have to invest equity of a startup. So if they are investing the amount received on sale in the equity of startup, they will get exemption and they don't have to pay the capital gains tax on it. Don't get confused between these two sections. Earlier section was an exemption available to the startup when it is selling the property, and this exemption is to the investor. So any person who is selling their property, if they want to avoid the capital gains, they can invest that amount into any startup's equity. So two benefits are there. One, it will lead to funding to the startup, and secondly, for an individual or an investor, you're saving the taxes also. So two benefits are there. I hope you understood. So till now we have seen 4 tax exemption: one 80 IAC, second 5627B, third 54 EE, and fourth one was 54 GB. Now we are going to the fifth one, or E point, carry forward of the losses. Carry forward of the losses. This is section 79. Which section it is? Section number 79. Now let's take an example on this. There is a company called as ABC Private Limited. ABC Private Limited incurred losses in 2019. How much loss it was? Suppose it was loss of 1 lakh. Okay. In 2020, it had a profit of 10,000. So what was the profit amount? 10,000. So this loss of 1 lakh can be carried forward to the next year. So if we carry forward the losses to the next year, what will happen? It is plus 10,000 minus 1 lakh. So coming to minus 90,000. So in this year 2020, do they have to pay any tax on 10,000? No, because earlier loss is standing and you are carrying forward that losses. So till how many years you can carry forward? You can carry forward. Like in 2021, you had a profit of 50,000. So in 2020, you have adjusted 10,000 of losses, remaining 90,000 is there. Again, you carry forward it to the next year, and over here you are adjusting how much? 50,000 rupees, correct? So you are adjusting 50. So out of 1 lakh, you have adjusted 60,000 till now. Are you getting? So on this 50,000 and on this 10,000, company need not pay the taxes. This is called as a carry forward of the losses. Now for doing this, for carrying forward the losses, they have to fulfill certain criteria. Now this criteria is for startups. Now what is the criteria they need to fulfill? The criteria says that first one, whoever is a original shareholders. Okay, so 100% original shareholder should be there, or second criteria talks about at least 50%, at least 50% should be voting rights of promoters. Now what is this? Listen to this very carefully. In 2019, whoever were the shareholders, original shareholders in 2019, when loss occurred, those shareholders have to be same. That means they have to be continuing shareholders till the time what you are doing, carry forward your losses. Or whoever has the original promoters of the company, out of them at least 50% voting rights belong to them. Understood? Clear with this? So what is the rule? Whenever loss occurred, at that point of time, whoever were the shareholders, they are continuing till that year when you're carrying forward your losses, or at least 50% of the promoters are having voting rights till now in the company. Promoters means the first people who have incorporated the company. Clear with this? Understood about the carry forward of the losses? So this is a fifth exemption. There are 5 total exemptions. 1 80 IAC, 56 to 7B, 54 EE, 54 GB and section 79. Okay, so what we are learning till now, I hope you are getting it. This is a fourth point of startup initiative or a strategic plan of a startup. The first one was fund of funds, second one was credit guarantee trust, third one was government procurement policy, and the fourth one was a tax incentives. Right, now we are going to the next one. Tax incentives are done. We are going to learn tax incentives in detail. Before that, we'll be starting with the next plan. That is a fifth one. Fifth one talks about legal support and fast tracking of patent examination. I hope everybody has heard what is a patent. Patent means it's intellectual property rights. When any scientist, any engineer does an invention, if he wants to protect his right, he gets it patented. So entrepreneurs or startup also uses these patents, okay, to boost their business. Okay, so anybody who has started with the startup, if they want to take a patent registration, government has given lot of reduction of fees in patent. So if normal fees for patent registration is around 50 to 60,000, but government has given 80% rebate on the patent fees. So how it is, we will write that when any of the startup want to register the patent, okay, any startup want to register the patent, first of all they will enjoy reduction in fees. How much? Almost 80%. How much reduction of fees is done? 80% reduction of fees. Second, it will enjoy fast track examination. So first priority shall be given to the startup patents application, and after that the other application. Also they have set up panels. These panels shall be helping the startup, those who don't have the legal knowledge how to apply for the patents. So they will be giving them free of charge services. Also, not only for the patents but for other intellectual property rights. Okay, for startup when they want to register any other intellectual property rights, so for them there is a scheme called as a SIPP. SIPP is nothing but a scheme for startup IPR protection, intellectual property right protection. This scheme is set up by Government of India. Okay, so startups will get legal support under SIPP, 80% reduction of the patent fees. Please remember, panels are there to help them, and fast track application of patent. In this point, these are the highlighting things you have to remember. After that, sixth one, it talks about self-certification based compliance system. Self-certification based compliance system. Now what is this? I hope you understand the difference between the audit and the self-certification. What is the meaning of audit? Audit means where company or firm has to appoint an auditor. Okay, auditor shall check the balance sheet, P&L, accounts. Okay, so they will be checking it. and after checking they shall be making a report on that. That is called as a audit. But what is a self-certification? In self-certification, no auditor is appointed. No auditor is appointed. Over here, the promoters or the officers of company, you call it as a company or LLP, company self-certifies that we have done this compliances. So apart from your accounts audit, there are various kinds of audit like environmental audit, factory audit, labor law audit, secretarial audit, so many, even cost audit, so many kinds of audit are there. So when we talk about a startup and so many audits are applicable to them, it is going to add the cost of appointment of auditor. Auditor takes handsome fees for that because he needs to release a report which is signed by him. So his liability is there, so he will charge you more. So for reducing the cost of the company, in certain kinds of audit, only self-certification is there now. Startups need not do audit on that. Okay, so now on which cases they need not do audit? Now there is a ministry called as Ministry of Environment and Forest. Okay, the short form is MOEF. This Ministry of Environment and Forest, they have taken out 36 white category industries. How many? 36 white category industries. Now, when any of your startup is in this 36 white category industry, white category means they do not do pollution or have least pollution. Like the software companies, they don't have any pollution, right? So those industry which do not emit any pollution, this may be named in this 36 white category industry. They just have to do self-certification. So this industry, they need not do the audit, but only and only self-certification for 3 environmental laws. How many? 3 environmental laws. Now what are those laws? We are going to write the name of that, otherwise we can also underline it over here. So as I told you, 36 white category industry, they will have to do just self-certification. Okay, this self-certification is for 3 environmental acts. First one is Water Prevention Control of Pollution Act 1974. Second, Water Prevention Control of Pollution Cess Amendment Act 2013. And over here we have Air Pollution Prevention and Control of Pollution Act 1981. So these are the 3 environmental laws on which self-certification can be done. No need to appoint an auditor, no need to do audit on this. To whom? All kind of industry? No. 36 white category industry which is given by Ministry of Environment and Forest. I hope this is clear. Okay, so this was the first self-certification. Now second self-certification is given by a ministry called as Ministry of Labor and Employment. For all your labor laws, this ministry is very important. Short form we write is at the MOLE, very important ministry. This ministry looks after your labor laws. So as I told you, there is something called as a labor audit as well. Okay, so it said that on the labor laws, on 6 labor laws, on 6 labor laws, only certification, that is only self-certification, no audit is compulsory to the startups. Now what are the 6 labor laws? We are going to underline it over here. The Buildings and Other Construction Works Regulation of Employment and Conditions of Service Act 1996, State Migrant Worker Regulation of Employment Condition of Service Act 1979, Payment of Gratuity Act 1972, Contract Labour Regulation Abolition Act 1970, Employees Provident Fund Miscellaneous Provisions Act 1952 and Employee State Insurance Act 1948. Okay, so self-certification regime in this 6 labor laws and 3 environmental laws. 3 environmental laws only to the 36 white category industry. Now whatever is a decision of your Ministry of Labor and Employment, they have said that it will depend upon the state. So they have not done compulsion on all the industry throughout the India to have only and only self-certification. It has just put a suggestion, and if their state government agree to it, then they can take up this. The exemption will be available or not, this is last decision will be that of a state government. So till now for this 6 labor laws self-certification, these 9 states have confirmed the compliance. So which 9 states? In the state of Rajasthan, Uttarakhand, Madhya Pradesh, Chhattisgarh, Delhi, Jharkhand, Gujarat, Chandigarh, Daman and Div, only and only self-certification is okay. In other states still they have not confirmed. In that state they have to take the audit. Clear with this? Understood? This was your self-certification and compliance based regime. Now going to the next one, 7th one. 7th one talks about incubator. Now what is an incubator? See, whenever a baby is born, if baby is not able to breathe or not able to drink milk, then baby is put in an incubator, right? So by that idea of incubator, over here name of incubator is given. Whenever business is very small and it requires support or help in one or the other way, these incubators shall help them. Okay, so incubator is that kind of an organization. Okay, this organization can be public organization, public sector or a private sector, no worries. Even individual can be incubator and they shall support your startup. What will be the motive of an incubator? To support your startup. Okay. So incubator shall be providing any of the facilities which startup require, right from the funding to the market, to the office space, to the manpower, to the expertise, anything. Clear with this? So now let's understand this. So incubator may give them various helps. Your incubator, it may give various help like financial help or office space or setting up industry or market, that is your customer, or manpower or fundraising. Any help, any of this can be given by your incubator. Now who can be incubator? I told you, private enterprise, public enterprise, even individuals who has any of this can help the startup in making the business. Then what is the benefit of incubator? If it is recognized incubator by the government of India will give them various aids, various incentives. Also, if the business of startup grows, it is ultimately the growth of the incubators only, right? Okay, so let's see what is the plan of our government of India. Our government of India, okay, it has a mission called as Atal Innovation Mission. What is the name of mission? Atal Innovation Mission. Under this mission, it is going to set up various incubators. Under this mission, it is going to set up various incubators. Okay. So whatever incubators will be set up will be called as Atal incubation centers. Okay. Now Atal incubation center is nothing but it will carry out the registration process of your various incubators. Okay. Now what is the eligibility criteria? Eligibility criteria for an incubator. I told you it can be private or public institution, no problem at all. So it can be private institution or a public institution. For example, Sri Ram College of Commerce, it is one of the incubator. Understood? After that, once you are a private or a public institution, you have to make an application. Where you have to make an application? You have to make application in Niti Aayog for becoming incubator. Where you have to give incubation? Niti Aayog for becoming an incubator. So who will approve? Approval will be given by Atal Incubation Center. Okay. So once approved, you will be called as a recognized incubator. What you will be called as? A recognized incubator. You will be receiving the certificate as well. Okay, so let's revise till now what we have seen. There is a mission of government called as Atal Innovation Mission. Under this, it needs to set up many incubation center. Government itself may also set up an incubator, and it also encourages the private enterprises to come up who have extra money, extra space. They can help the startups to grow. So they will want them to make an application under Niti Aayog, and Atal Innovation Incubator, that is Atal Incubation Center, shall do the verification. If approved, the incubator will be recognized incubator. Understood? And then they will receive various aids, incentives from the government. Clear with this? Any doubts? So once you are a recognized incubator, we will write it in the next page. Government of India shall grant, okay, for the period of 5 years, Government of India grants rupees 10,000, rupees 10 crores for period of 5 years. This 10 crores for period of 5 years is given to the recognized incubator. Now why this 10 crore rupees is given? This 10 crore rupees is given for supporting whom? Supporting your startup. Okay, and secondly, for running your incubator. So once you are a recognized incubator, Government of India shall give you 10 crores for a period of 5 years just because you are helping the startups. Along with that, for the administrative and the other expenses required to run your incubator. Clear with this? Understood? Great. Now you'll wonder, what is a benefit to incubator? See, I'll tell you what is the benefit. You might have seen the show Shark Tank India, right? In that show, why existing entrepreneur used to put their money in the new startups? Because they want to make profit on the money, right? So whenever any of the incubator, it invest in the equity. It invest in the equity of a startup. When this startup grows, don't you think the incubator's money is going to grow? The answer is yes. So this is the idea behind it. Okay. So it is just that it is not so easy to get help of an incubator. Okay, the process for getting into the incubator or getting admission into the incubator is that much difficult, like we have difficulty in getting college admission. So it's a very rigorous process of the incubator. They will take your various interviews, okay, various examinations will be done. Understood? Clear with this? So let's revise the topic. We have revised the Atal Innovation Mission. So once we are a recognized incubator, Government of India shall provide us with 10 crores for a period of 5 years. And what is the benefit to the existing incubator? Benefit is that wherever they have invested, if startup grows, they also grow. If startup fails, that is okay. That is okay means their money will go away. That's why entrepreneurs or the incubators will look into the idea first and then only invest. Okay. Now we'll go to the next. This incubator was point number 7, I guess. Now we are going to the point number 8. Point number 8 talks about, I'll write it on the next page. Government of India also plans to make various startup centers, and they also want to make technology business incubator. Okay, Government of India plans to make both of this. One is startup centers and another one is TBIs. TBI is nothing but Technology Business Center. Now, who is looking after startup centers? The making or promotion of the startup centers is taken care by your Ministry of HRD, that is Human Resource Development. Who takes care of that? Ministry of Human Resource Development. And as far as TBI is concerned, it is taken care by Ministry of Science and Technology. Okay, you can also write Ministry of Department of Science and Technology. Okay, so now it aimed at making total 14 startup centers. How many they wanted to make? They wanted to make 14 startup centers, and totally they wanted to make 15 TBIs. 14 startup and 15 TBIs. Out of this 14, 10 are already approved. Okay, and 4 are work in progress. Out of this 15, 9 are already approved and 6 are work in progress. Understood? Clear with this? Startup centers and technology business incubators. After that, going to the next point. 9th point. Government of India also plans to make various research parks. Now what is this research park? Research park means any scientist, any of the engineer, they want to do any invention, they have to make their own research park. Now research require different types of appliances depending upon your invention. Somebody is going for the space equipment, then you require the space apparatus. Somebody is looking into any of the scientific invention, then you require the scientific products. So the research park has to be set by the Government of India. So if any startup want to do research, they need to invest in constructing the research park. Already Government of India will be making the park, and whoever wants to do the invention, they can just use that by paying the fees. Okay, so this is a main concern of government. So Government of India, they have plans to make 7 research park. How many they want to make? 7 research park they want to make. Okay. Now out of this 7, one is already ready at IIT Kharagpur. It is already ready, IIT Kharagpur, so I can call it as existing. Okay. Remaining 6 are going to be made. So another one will be made at Gandhinagar, IIT Gandhinagar, then IIT Guwahati, then IIT Delhi, IIT Kanpur, IIFS Bangalore, and the last one is IIT Hyderabad. Okay, so these are the 6 research parks which they intend to make. Out of this, one shall be made by your Department of Science and Technology, and remaining 5 shall be made by Ministry of Human Resource Department. Clear with this? Understood? This is your research park. I hope you have understood the strategic plan. There are 9 points in strategic plan. Okay. The very important in this is tax incentives. So let's revise all of them one more time. First we saw fund of funds where government will be giving 10,000 crore to SIDB. SIDB shall give it to the AIF, and AIF wherever found correct they will invest in the startup equity. Second, we saw credit guarantee trust fund. Over here government shall be making guarantee on behalf of startup, and startup shall get loan of up to 1 crore collateral free. They need not give any security for that. Then we saw that for the public procurement, even startups can make the tenders, give tenders to the government, and startups have the relaxation as far as their turnover and experience is concerned. So even they don't have experience and turnover, they can make tenders to the government. Then we saw about the tax incentive. First one, ATIAC, 100% tax exemption for 3 years out of block of 10 years. Second, we saw about 5627B angel tax exemption. Third, LTCG to the startups, 54EE, 54GB capital gains for the investor, and the last one was carry forward of losses, section 79. After that we saw legal support and fast track for the patent, where important points are 80% reduction in the patent fees, then panels which are free of cost, SIPP. After that, self-certification based regime, it is by the 2 ministries. One ministry is Department of Environment and Forest. It has given out the list of 36 white category industry where they will be giving self-certification for 3 environmental laws. Audit is not required. Ministry of Labour Employment, they have given a provision for states which agree or confirm this. They can have only self-certification for 6 labor laws. So 3 environmental and 6 labor laws, please remember. After that we saw what is an incubator. Incubator is under Atal Innovation Mission, and whoever wants to be incubator they have to apply in the Niti Aayog. So once it is approved, you are a recognized incubator. Government shall be giving you funding for running your incubator, also for supporting the startup. Okay. After that we saw government aims to start startup centers and the TBIs also. 14 startup centers and 15 TBIs. Startup centers will be looked after by Ministry of Human Resource Department, and TBIs will be promoted or governed by your Ministry of Department of Science and Technology. After that we saw government also plans to make 7 research parks. One is already existing and all others are work in progress. One will be made by MHRD, 1 will be made by DST and rest 5 will be made by your MHRD. So this is all guys, this is how you have to revise the important question answers. If you do it again and again and again, revision, it will be remembered throughout. So let's begin with the next topic, how to be recognized as a startup. First, let's revise who is a startup. The definition of startup is given by your DPIIT. So who is a startup? Okay, first entity is private limited or LLP or a registered partnership. The entity has to be new. It cannot be because of merger, amalgamation. Third one, it can be startup for a period of 10 years only. From incorporation post 10 years, it would lose its status of a startup. They should be having business of new products, new goods, or if they are existing products and goods, then there has to be some value addition to that. Okay, after that we saw that the turnover cannot exceed 100 crores in those 10 years. If turnover exceeds 100 crores, then you lose the character of a startup. So these are the very important things, the definition of a startup. So when you are complying with all the provision, okay, the conjunction used between all these provisions is and. So all of the provisions you have to comply. So once you comply with all the provisions, you have to apply for registration of a startup. So when you want to be a startup, you have to apply for the registration. Now, who is the regulating authority? Where are we going to apply? The regulating authority is DPIIT. Who is DPIIT? Department for Promotion of Industry and Internal Trade. Okay, so this is complete online application. No offline application is there. That's why we have to go on the website www.startupindia.com. We have to go on this website and we have to apply. This application can also be done by downloading the mobile app. Second option is by downloading the mobile app. Okay, what are we going to put in the application? In the application, we are going to apply for DPIIT, and what documents are we going to file? Certificate of incorporation we are going to file. Okay, along with that we have to put an idea. So you have to showcase your business idea. Nowadays we all are so conversant enough to make the video, so it's always better to attach a video of a business idea that looks really pretty and good. Okay, so this application will be on the website, or you can download the app of Startup India, and you can just certificate of incorporation to be attached. If you are an LLP, then certificate of incorporation of LLP. If you are a registered partnership, then certificate of registration issued by your registrar of firms. Along with that, you have to make a video. Now, once you attach the documents, once application is done, if DPIIT is satisfied, if DPIIT is satisfied, then what it shall issue? It shall issue a certificate of recognition. Okay, so once you receive certificate of recognition, you are a recognized startup. Okay, or if DPIIT is not satisfied, it may also happen it is not satisfied because you are not fulfilling any of the criteria. It may reject your application. So if it approves, it may give you certificate of recognition, Once you are recognized startup, then you can avail various advantages given to the startup. I hope the application process is very simple. Yes, okay. So now let's begin with the next. Now, once you are recognized startup, do you think all the tax exemptions which we have studied, the 5 tax exemptions, they will be available to you automatically? Answer is no. They are not available automatically, but you have to apply for that. Okay. So now what we are going to learn, registration of recognized startup. Registration of a recognized startup for claiming tax exemptions. For claiming tax exemptions. The very first tax exemption which we had seen was under section 80 IAC. I hope everybody remembers this. What was the exemption amount? 3 years complete tax exemption in the block of 10 years, and also we saw the conditions on that. So if we want to avail this, what is the first requirement? We should be a recognized startup. So how to avail, where to avail this? This exemption is to be availed by applying to the IMB. What is IMB? IMB is Inter-Ministerial Board. So we have to apply to the Inter-Ministerial Board, but before applying to the Inter-Ministerial Board, we have to comply with the conditions. So application to IMB in form 1. Okay, so in which form we have to apply to the IMB? In form number 1. Who can apply in form number 1? Only and only who is a recognized startup. Okay, in that recognized startup, can registered partnership apply? Answer is no, it cannot apply. So only and only when the recognized startup is a private limited or an LLP. Clear? Understood? So if IMB is satisfied, it shall give you a registration, and after that you can claim the tax exemption under section 80 IAC. Clear? Understood? So this was tax exemption registration under 80 IAC. Now we are going to the next one, registration under section 56 to 7B. I hope everybody remembers this. 56 to 7B, this talks about angel tax exemption. So let's revise this one time. Whenever any startup who is a recognized startup issues shares at premium which is above the market price, whatever is the premium, on that angel tax is applicable. Startups can claim exemption if they have registration under this and if they comply with certain conditions. Now what are the conditions, how to take registration, we are going to learn over here. Okay, yes. So for this there are certain conditions to be fulfilled. Now what are the conditions to be fulfilled? The first condition says that you should be a recognized startup. So for application, we have to be a recognized startup. So we should have received certificate from the DPIIT. Okay, after that, our aggregate of paid up share capital plus share premium. Aggregate of paid up share capital and share premium. This is post issue. Okay. So once shares are issued, okay, after that you have to take aggregate of paid up share capital and premium at which you have issued the shares should not be exceeding rupees 25 crores. So if post issue is exceeding 25 crores, you cannot claim the angel tax exemption. Now there is one more twist over here. What is a twist? In this 25 crores, few things or few investments are not to be counted. Few investments are not to be counted in this 25 crore. And what are those? We are going to learn. Following are not counted for rupees 25 crore. Now what all, whose investment are not counted for 25 crore? First of all, any investment done by NRI. So if any of the non-resident Indian invest, the investment is not to be counted in the 25 crore. Second, investment by venture capital fund. Investment by venture capital fund not to be counted. And the third one, investment by some specified companies. Listen to this very carefully. Okay, investment by some specified companies. Now what are these specified companies? Specified company means companies which are listed companies. Okay, companies which are listed companies, and such other companies whose net worth exceeds rupees 100 crore. Okay, net worth exceeds 100 crore or whose turnover exceeds rupees 250 crores. So any companies whose net worth exceed 100 crore and whose turnover exceed 250 crore. If such kind of company invest in our startup, the amount invested is not counted for the 25 crores. Clear? Okay, so let's revise one more time. What is the condition for angel tax? It should be a recognized startup. Second, the post issue aggregate of paid up share capital and share premium cannot exceed 25 crore. In counting that 25 crore, what all things we are not counting? Investment by NRI, investment by venture capital fund, and third, investment by specified companies. What are specified companies? Listed company and other companies whose net worth is exceeding 100 crores, whose turnover is exceeding 250 crores. Is it clear? Got it? Great. Now, along with that, they need to follow certain condition. Now, before going to certain condition, if startup complies with this, okay, then they have to apply to the DPIIT. For angel tax exemption, I am talking in form number 2. Okay. DPIIT shall forward the application to CBDT, that is Central Board of Direct Taxes. And once approval is given, you can claim the exemption. Now, exemption shall be given if again you follow certain condition. Exemption shall be available if you follow certain conditions. So this is a third condition. First two condition we saw, recognized startup 25 crore. Third, startup has not invested in the following asset. Now where they have not invested, I hope everybody has taken the notes. So startup has not invested in any building or land appurtenant. Now this building is a residential house. So startup has not invested in any residential house unless it is used for renting purpose. It is used by startup for renting purpose, or startup itself deals in real estate. So the residential property becomes asset or a product for them, right? with which they are dealing into. So when there is a stock in trade, that is allowed. They are using it for rental, it is allowed. But it has not invested for any other purpose. Okay, then you can claim angel tax exemption. Again, startup has not invested in any building or land. Now this being non-residential house. This is a non-residential house. Unless startup is using it for its own business, it is owning its own office, that is okay. Or it is using for renting it, that is okay. Or it is using it for stock in trade, that is also okay. Apart from that, investment is not allowed. After that, startup cannot give any loans or advances to any other entity, okay, where you're lending substantial part of your business money. Basically, you have to concentrate on your business first and then only you can give loans and advances. Startup is not allowed to give any capital contribution to any other entity. They cannot invest in other company shares or securities. They can purchase motorcycle and any other vehicle up to the actual market price of 10 lakh. So if any vehicle price is exceeding 10 lakh, I'm talking about actual market price, they cannot purchase that. If they are purchasing, they cannot get the angel tax exemption. But what if they are dealing in those, they are having a car showroom, they are having a bike showroom, that is okay. That is stock in trade which is allowed. So, motor vehicle, aircraft, yachts, any other mode of transport when actual cost exceeds 10 lakh, other than held by startup for flying, hiring, leasing, stock in trade, that is allowed. After that, startup is not allowed to invest in the jewelry also. If it is in stock in trade, it is allowed. If not in stock in trade, it is not allowed. Or any of the above combination. Basically, startup is not allowed to purchase any of the asset class. Okay. So asset class investment is not allowed. If you take asset class investment for first 10 years of incorporation, you have to give back your angel tax. If you want to avail angel tax, all three conditions are to be fulfilled. First one was recognized startup, second one was 25 crore post issue, and third, all this investment. If you comply with both, you may get a tax exemption on this. Clear? Great. Now, I have given you explanation on the specified companies. We have underlined that. Okay. So, startups have to fill the form in form 2 to DPIIT. DPIIT shall forward that to the CBDT. Right? Clear with this? Okay. So, this was your recognition of startup. Along with that, we also saw registration for the tax exemptions. I hope it is clear. Now you have to learn some theoretical part. Okay, till now we have seen the technical part. Now little rest to our mind. So relax and listen to this as a story and even remember it as a story only. See, our government of India, it announced the basic plan for Startup India mission or Startup India campaign. So this plan which Government of India has given out, it's a basic plan. Okay. And now our Government of India expected from various states, it expected from its various states and all of its union territories. Okay. Government of India expected from its various states and union territories to make their own startup plan, to make their own startup plan. Okay. So this startup plan, whatever it is made at the state level, will be based on the basic plan. So it just gave a skeleton and it was expected by all the states to take the initiative. But we know that in India nothing happens without the motivation. So initially only 4 states had joined. But only with 4 states is Government of India would able to comply with its mission, to reach its mission? The answer is no. All the states have to join hand together, then only it will be a successful, achievable event. So, to motivate them, to motivate the state, Government of India came up with various initiatives to motivate states. In each particular state, they came up with hackathons. Hackathons means people who are into software techniques, making learning new techniques, providing free seminars. These are the hackathons. Then they also conducted various boot camps at every state level to spread the awareness that we have started this campaign. Please states, please join us. Also they started with giving pitching sessions. Pitching session means pitch is nothing but the way you present your business proposal before any of your investor. That is a pitching. If your pitch is very good, your investor will be very happy with you and he may be ready to invest. That is a pitching. So all this requires a expertise. So Government of India started with this motivation. Okay. Then it also started with something called as a state ranking policy. It was announced by Government of India that whichever state will have best action plan, best implementation, best incubator. So basically for this competition, 7 pillars were there. So if a state is very good in this 7 pillar, they will be ranked number 1 state, number 2 state. Okay, so this was also an impetus. Every state would be willing to be number 1, right? So states also started joining. State also started making their own action plan. Okay, so I will make you underline few things very important from your exam point of view. So earlier only 4 state government were taking active participation. So for national priority across the country they started up various movements. Presently 22 states have joined this along with the union territories also. Now what did they do? Important role was reduction of regulatory burden, simplifying labor, taxation, land laws, other laws. Other state also organized hackathons, boot camp, pitching session. Okay, then they came up with state startup ranking, that is your DPIIT, Department of Industrial Promotion, that is earlier known as DIPP, now known as DPIIT. DPIIT came up with the startup ranking, and on this 7 broad pillars are there. What are the 7 broad pillars? You have to remember. First, startup policy and implementation, the first pillar. Second, how they are supporting by giving the incubation. Third, seed funding, we will learn. Angel and venture funding. Seed funding is the capital with which the business is started, and after that the capital comes in, that is the angel or a venture funding. Then simplification of regulations. We have seen that now companies can be incorporated through Spice Plus, and Spice Plus gives bundle of 10 services, right? So this is a simplification. Easing of public procurement, awareness and outreach. So these are the 7 pillars. Your state will be judged by that 7 pillars. Okay, so there was a healthy competition among the states. So in this, various workshops were also conducted, that is knowledge workshop at 3 leading incubators. After that, they also paired the state for intensive mentoring. There was also international exposure visit to US and Israel. Many states, few startups were given the opportunity to meet US entrepreneurs and the Israel entrepreneurs. They were also doing the video conferencing with many of the states, and also helped the various startups across the country. The total 27 states and 3 union territories participated in the event. evaluation was done by an independent expert. Okay, almost 3,200 calls were made in 9 different languages. So it came out to be a major event. Because of this, the state which had not participated, they also participated. So from 4, now 27 states came up and they made their own startup plans. Okay. Now, what are the startup plan? We are going to see some highlights of some states. Over here, whatever I am marking, only that much you have to do. We don't need to do PhD or any of it. So first one is a West Bengal. Only we'll be remembering the highlighting factors in this, nothing else. So West Bengal launched its plan on Jan 2016 and it had launched a website. So very important point about West Bengal plan, they have launched a website called as startupbengal.in. Okay, in this startupbengal.in, there is a medium where entrepreneurs and the investor will meet at one particular place. Like we have a matrimony, right, where girls and boys meet. So over here there is a same like that. There is a startup Bengal. So what West Bengal has done, it has created a meeting place for entrepreneurs and the investors. So investors want to invest, they can just go through the category of industry that are the startups, and their plan will be up to December 20. Now the next one is Uttar Pradesh. Uttar Pradesh basically looks into the IT investment more. So it want to get more and more IT investment and more startups in this particular field. After that comes Odisha. Odisha has a very big mission. It want to be top 3 investment destinations in India. So it has started its 10-year plan, which has started from 16 up to 2025. After that, Rajasthan comes. Rajasthan started its plan in 2015. It wants to have 500 startups in next 5 years. It wants to set up the incubators also, so 50 incubators. For that, he has arranged a fund of 500 crores for next 5 years. Then comes the Karnataka. Karnataka also has a 5-year goal. Basically, they will also look into the technology, but whatever is a problem in the technology, like the hacking things are going on. So it's a problem based technology. On problem based technology, it needs to have 25 technology startup on the problem based or the social problems. Apart from social problems, it needs to have 2000 startups on the technology and rest 600 startups on the products. So in this way, it has divided 25, 2000 and 600, and in next 5 years, it wants to create 18 lakh job opportunities in the state of Karnataka. After that comes Gujarat. Gujarat has a fantastic plan, threefold strategy it has, okay, where there will be a combination of an investor, government and your startup. So your innovator will be there, the startup, institution will be there, the investor and government committee. So inventor will have a startup plan, institution will be investor and government will be giving you the help in building up your business. This is a 3 form of chain where your startup can grow very easily. Then Jharkhand. Jharkhand came very late, but it has done a very good job. So it has facilitated 10 crores for innovation and incubation sectors, not only the Jharkhand but also other states also. So it want to set up a lab with IIM Ahmedabad. Also, it also look into various sector. It is not into the technological oriented, but 6 different sectors it look into, like IT, health, tourism, agriculture, biotechnology and alternative energy. Okay, so these are the initiatives by the startup. Now start with exemptions enjoyed by the startup. I hope you have understood what is a startup, what is a strategic action plan of our government of India. Very important 9 points are there you have to remember. Also we saw what are the tax exemption given. So as a startup, it enjoys various exemptions and privileges. Why? As discussed earlier, Government of India want to encourage the startup, more and more entrepreneurs coming in, more and more products coming in, ultimately our economy is going to grow. So now in this video we are going to learn what are the general exemptions available. Tax exemptions we have seen, so now general exemptions available. After that we are going to see what are the exemptions available under Companies Act 2013. This exemption, students, you can also write benefits or privileges enjoyed by the startups. So if such kind of question comes, then also you can write all this point. So let's quickly begin with our first point, that is simple process. As we have seen how to be a recognized startup, we have to apply to the DPIIT online by going to the website startupindia.com, or you can also download the app. Just you have to upload certificate of incorporation or certificate of registration, along with that your business idea. That's it. If DPIIT is happy with you, it shall grant you a certificate, means you are a recognized startup. So the registration process is very easy. No cumbersome procedure, no documentation, etc., etc. Everything is online only. So no need of cost. Clear with this? Understood? So they have to just upload the document and entire process is only online, no offline process is there. This is going to reduce your cost. After that, there is also reduction in various cost. We have seen that intellectual property rights, okay, Government of India wants more and more people to come forward and register the intellectual property rights, especially the patent. So they want more and more invention happening in India. So with this idea, they have reduced the patent registration fees by 80%. So reduction of 80% of cost of filing of the patents. Also, they have set up the panels. So those who don't have a legal knowledge, a layman who does not know how to file a patent application, the panels will be helping them with the patent application, and that also will be free of charge. Also, they have a scheme called as SIPP, that is Scheme for Protection of Intellectual Property Right for Startups. Also, they have also done with the fast track application. So application of startup shall be taken on the fast track basis. So these are the advantages available as far as intellectual property right is concerned. After that, we have seen that Government of India has set up 10 crore, that is 10,000 crore fund. This fund it has given to the SIDBI. SIDBI shall invest in the various AIFs, and AIF ultimately shall be investing into the equity or the contribution of the startup. So this is a scheme of your government. Already we have seen. Along with that, it has also started with the Credit Guarantee Trust Fund, where every year Government of India has dedicated almost 500 crores of fund. So this will help startup in taking the collateral free loan. After that, we have seen the tax exemption under section 80 IAC of Income Tax Act, where continuous 3 years tax holiday is given out of the block of 10 years. We have seen this. Also, whenever any startup want to apply for the tenders to the government, there are certain relaxations also. Relaxation is there on the basis of prior experience and the turnover. So even though startup does not fulfill with the criteria of prior experience and the turnover, then also it can apply for the government tenders. Then research and development facilities are also provided by the government, as government aims to establish 7 research parks. One is already existing, 6 are work in progress. Also, there is no time consuming compliances, because instead of audit, they have done a self-certification as far as your 6 labor laws are concerned and 3 environmental laws are concerned. You can change this, students, to 6. Okay, 6 labor laws and 3 environmental laws. Is it applicable to all companies? No. For labor laws, it is depending upon the state. For industry, for environmental laws, if it is a white category industry, then only it is applicable, otherwise it is not applicable. This all things we have learned. After that, there are also tax saving for the investor. They are talking about 54 GB, not 54 EE. So where investor has sold his residential property and he wants to claim exemption on the capital gains, he has to invest that money into the startup. So once the startup it has invested, then he is no longer required to pay the capital gains on the amount received. Then startup can also choose among various venture capitalists. So startup can choose their own investor. So as there are more number of venture capitalists, startup has lot of options and it can see where he is having a good deal. Okay, so he need not compromise on his deal, but he can choose the best venture capitalist. After that, easy exit option is also given to a startup. So once you close down the business, okay, once you are closing down the business within 90 days from application of the wind up. Okay, so once wind up application is given, within 90 days of that you can close down. Even this is a fast track exit only for the startups. Also, Government of India aimed at doing various fest. Okay, recently means before the COVID, there was one fest which was a Make in India fest. It was at the domestic level, but India wants to do at domestic as well as international level at least 2 startup fest annually at national and international level. I hope you have understood what are the benefits available to the startup. Now in the next video we are going to see what are the exemptions available as far as tax point of view, also as far as Companies Act 2013. So let's start with our next topic, that is tax exemptions and the exemption under Companies Act 2013. Now we are going to look after the applicable tax exemption to all the startups. So first exemption we have seen under ATIAC, 3 years tax holiday. That means 100% rebate on the tax. They need not pay a single rupee of tax on their income. But when this is applicable, when you apply in form number 1 to the DPIIT, also you fulfill various conditions. Now what are the conditions? First we have seen the entity can be either a private limited company or a LLP. So this is not available to the registered partnership. Also, second one, they should be dealing in new product and new services, and if they are existing services or existing goods, then there has to be some value addition to it. Along with that, very important, the turnover, okay, turnover of your entity should not be exceeding 25 crores. This is for ATIAC. Okay, when you go to look into the definition of your startup, over there the turnover not exceeding 100 crore is there. But when you want to avail exemption under ATIAC, your turnover should not exceed 25 crore. Is it clear? So this was as far as your ATIAC is concerned, 3 years complete tax holiday. After that, when we talk about the minimum alternate tax, when we talk about the MAT, now the applicable rate of MAT is 15%. What is MAT? Minimum alternate tax. So even though they have 3 years holiday, they have to pay the MAT at 15%. Clear with this? Understood? After that, they also have exemption against the capital gains. So whenever any startup sells its property, any property it can be, they have to pay LTCG if applicable. They will be exempted from paying LTCG if they have invested into the government securities. Within how many months? Within 6 months from the sale. And what is the maximum amount they can claim exemption? Up to 50 lakh rupees, right? 50 lakh, 6 months. This is which section? This is section 54 EE of your Income Tax Act. This we have already seen. Whenever startup puts an investment in any government security, they have to lock in there. So lock-in of 3 years will be applicable. So whenever startup invest there, they have to keep those funds there for 3 years. If they take out the funds within 3 years, they have to pay the LTCG. Clear with this? Understood? This provision is kept just to reduce the fraud, because just for claiming the LTCG, many startups may put investment and immediately after a month take out the investment. So this should not happen. That's why the lock-in period of 3 years is there. Clear with this? Then also, whoever is holding 50% equity, okay, then company can utilize that amount immediately for buying the asset even before filing the return, no problem at all. Okay, so this was about your LTCG 54EE. After that comes taxation for our domestic companies. Now details of this you will be learning in your tax. For now, here you remember, whenever they have any turnover which is less than 5 crore, the turnover is less than 5 crore, how much tax they have to pay? 29% along with surcharge and the cess. This is for the domestic company. For foreign company, the rules and regulations are different. When we talk about the domestic manufacturing companies which are very new, they are startups, okay, they have come right now. So for them the applicable rate is 25% of tax plus cess and surcharge. These are the tax rate. The detail of this you will be learning in your tax. For now you remember this much. Now we are going to exemption provided under Companies Act 2013. We'll be writing notes for this, that would be very easy for us to understand. So the very first exemption which is available under Companies Act 2013 for the startup is relating to the annual return of the startup. Every company has to file an annual return, yes, but the signing of the annual return as far as a startup is concerned, the signing is to be done either by a company secretary or a director. So over here we are using conjunction or, we are not using and. As in various companies other than startup, in annual return, both the parties, that is company secretary as well as director, both of them have to certify. But when you are startup and you are filing annual return with the ROC, you need certification of either or, either a company secretary or a director. Clear with this? So this was your annual return. After that comes your board meeting. Board meeting compliance is same like OPC. We are going to revise that one more time. So we are talking about startup board meeting. Startup shall be required to hold only 2 board meetings in a year. Okay, how many? Only 2 board meetings in a year. That too each and every half year. So what is your first half? First half is 1st of April to 30th of September, and the second half is 1st of October to 31st of March. So each and every half we have to hold one board meetings. Very important, the gap between the 2 board meetings. The gap between the 2 board meetings should be minimum of 90 days. So here we require minimum of 90 days between 2 consecutive board meetings. Let's revise this again. Startup is required to hold 2 board meetings in a year, each and every half, and the gap between 2 board meetings cannot exceed 90 days. And the gap between 2 board meetings should be minimum of 90 days. Clear with this? Great. Now we are going to the third one. It's about the sweat equity shares. Sweat equity shares. What are the sweat equity shares? Whenever any director, any employee does any value addition to the company, like it brings a contract for a company, cracks a deal for a company, or it brings any patent, any achievement which is remarkable, which is value addition to the company. So for honoring them, okay, along with the salary, company issues them a sweat equity. So sweat equity is given to those employees and those director who does value additions. So now we are going to see provision for the startups. Can startups issue sweat equity shares? Yes. In startups, we require more motivation, right? So when we have more motivation, employees will perform very nicely. So startup can issue sweat equity not exceeding 50% of paid up equity capital. Okay. So how much startup can issue? Not exceeding 50% of paid up equity capital. So if your equity capital is 1 lakh rupees, how much sweat equity startup can issue? Not exceeding 50%, that is not exceeding 50,000 rupees. Up to 50,000 it is allowed. Clear with this? Because for other companies the limit is less. So this will be valid, basically all these exemptions will be valid up to 10 years of incorporation. So till the time you are a startup, this exemption is valid. Otherwise, this exemption after 10 years shall not be valid. Clear? Understood? So this is about your sweat equity share. Now going to the next, the fourth exemption, talking about the ESOP. What is an ESOP? Employee Stock Option Scheme. Now ESOP is basically for motivation of employees. There is a difference between the sweat equity and an ESOP. Sweat equity is issued whenever any director, any employee does a value addition. But over here there is no value addition. Over here, company is issuing ESOP to its employees just to have sense of an ownership. Suppose I am employee of ABC Private Limited. I get salary, but as company grows, definitely my salary increases by 5% etc. in a year. But do I get any entitlement if my company grows? The answer is no. So I don't have the sense of belongingness or the sense of ownership. So it is duty of company and the board of directors to always keep their employees motivated. Because if employees are motivated, they will do very nice work. Why? Because if I am having shares of any company and if my share value is increasing, it is my benefit. Yes or no? This is to create a belongingness or a motivation among the employees. So the ESOP are issued. Okay. So what is an ESOP? It is issued to all the employees at par and company cannot do the discrimination in that. Okay. So there are certain rules for issuing the ESOP. ESOP is only to be issued to the employees and we cannot issue ESOP to any promoter or any person connected to the promoter. But when it is a startup, startup is allowed to issue the ESOP to the promoters and any person related to the promoter or any director who is holding a loan or in consort with some other person about 10% or more in the company. See, basically the idea of ESOP is just for the sake of employees, those who are not connected to the company. But any person who is connected to the company will not get the ESOP. But when we are a startup, ESOP can be issued even to the promoter or any person related to the promoter. So for a startup, we can issue ESOP to promoter or any person who is related to the promoter. Even ESOP can be issued to any of the director or related to the director, any director or related to the director who is directly or indirectly, okay, who is directly or indirectly holding more than 10% in company. When you will learn the section of ESOP in your Companies Act, you will see there is an exclusive definition of an employee. An ESOP can be issued to only those employees. So in that definition, promoter is not there. Any person who is director holding more than 10%, he is not an employee of the company. But just because it is a startup, so ESOP can be issued to promoter also, relative to promoter also, director also who is holding more than 10% in the company. I hope you have understood about the ESOP. Now going on to the next, even very importantly, this exemption, above exemption which we saw, is available only for 10 years. That means once you are not a startup, you lose all these exemptions. Got it? After that, the fifth one, this is relating to your deposits. Deposits is governed under section 73 to 76 of your Companies Act 2013, right? Everybody loves this deposit. What is a deposit? Company takes small loans. That is a deposit. Company takes loan. So the general rule says that private limited can accept deposit only from its members, and public limited, who are eligible companies, they can accept deposit from the public at large. So our startup is a private limited company. So it can accept deposit only from its members. That is correct. Apart from that, it has other exemptions also. Now what are the exemptions we are going to see? So whenever any startup, it issues any of the convertible instrument. It issues any of the convertible instrument, mostly it's a debt instrument or any of the preference issue instrument. So it issues convertible instrument. It is convertible into what? Convertible into equity within 10 years of issue. So this is convertible into equity within 10 years of issue. So when any startup issues convertible instrument into equity within 10 years of issue, so it is issuing instrument, so people are going to give them a loan. Okay, so when anyone subscribes to this, or takes this. So whenever we are subscribing to the debt instrument, the person is giving loan, right? So, and that person is paying rupees 25 lakh or more. How much they are paying? Rupees 25 lakh or more in single tranche. Now what is a tranche? I'll give you an example of a tranche. Suppose there is a loan of 1 crore and you have made 4 parts of that, 25 lakhs each. 25 lakh each. Okay, so 25 lakh is a single tranche. So when you have loan of a particular amount, you make various parts of that, that is a single tranche. Okay, so when any startup issues convertible instrument to any person and person makes payment of minimum of 25 lakhs or more in a single tranche, then such issue is not considered as a deposit. Such issue is not considered as a deposit. So it is not deposit as per section 73 of Companies Act 2013. So when it is not a deposit, company need not comply with any of the rules regulations of section 73. Clear? Understood? I'll repeat one more time. Whenever any startup issues any convertible instrument which is convertible into equity within 10 years of issue, and To person whom it is issued, he pays at least 25 lakhs or more in a single tranche. Such issue is not a deposit under section 73. Okay, but any amount less than 25 lakhs, it will be termed as a deposit. Clear? Understood? Great. After that, sixth exemption we have, it is same relating to the deposit only. Exemption under deposit. Now under section 73, there is certain procedure which every company have to follow when they are issuing the deposit. So procedure is given under section 73, subsection A to subsection E. What is that procedure? A part talks about issue of circular for deposit. What does it talk about? Issue of circular for the deposit. Second, it talks about we have to register this circular, right? Register circular with whom? With ROC. C talks about we have to give advertisement whenever we want to issue the deposit. D is omitted, and E talks about we have to maintain reserve. How much reserve you have to maintain? At least 20% of your outstanding deposit. This all you will be learning in your Companies Act. If you have not learned, don't worry. These are the general procedure which every company has to follow whenever they are issuing the deposit. Issue the circular, register that with the ROC, maintain the reserve, etc. Okay, so this compliance, okay, any startup, whenever any startup is issuing deposit, any of the startup issuing, rather we can say any of the startup is taking deposits, okay, and this deposit is within the limit. Which limit? This deposit is within the limit. What is the limit? The limit is up to 100% of paid up share capital plus free reserves plus securities premium account. Okay, so what is the limit? 100% of paid up share capital plus free reserves plus securities premium account. Up to this, if limit is there, okay, then startup need not comply with the procedure. Then startup need not comply with the procedure. I'll repeat this one more time. Please remember this very carefully. Whenever any startup is taking deposits up to 100% of paid up share capital plus free reserves, it need not follow the procedure given under 73A to 73E. This we have also discussed in your exemptions to the private limited company. But very important thing, even though it is not following a procedure, but it needs to always file a return of deposit. What they have to file? A return of deposit to be filed with whom? They have to file a return of deposit with the ROC. In which form? We file it in form DPG 3. So even though you are not complying with the procedure, but this you have to follow because you are accepting the deposit. So you have to file the form with the ROC. I hope it is clear. So these are the exemptions available under Companies Act. Also we saw the tax exemptions. So I hope you have understood. If you are not understood, you can re-watch the videos and take down the notes. So let's start with the next topic, that is formation of a startup. In India, when we want to form a startup, as DPIIT has given us a definition, who is a startup? Only a private limited company or a LLP or registered partnership can be a startup. So when we want to form a startup, we'll always go for either of these three. When any entrepreneur wants a limited liability, also wants to scale up the business, so we can recommend them a private limited company. So basically for a startup, they should start up with a private limited company. So in Companies Act, we have learned that for formation of company in India, we have three basic kinds of company: private limited, public limited, and an OPC. But can we go with the public or a OPC if we want to be a startup? The answer is no. We only have to go with a private limited company for a startup. So we chose a private limited. After that, we have to make the charters of the company. So what are the charters of the company? The memorandum and articles are the charters of the company. Along with that, we have to complete various other legal formalities. Legal formalities can be pre-incorporation and the post-incorporation. All this we have already studied in our chapter number 2, but we are going to revise it quickly over here. So first of all, if we want to incorporate company under Companies Act 2013, chalo tell me which form is there? Spice Plus, right? So Spice Plus is a form with which we incorporate our company, be it a private, public or OPC, does not matter. And who is our regulating authority? Registrar of Companies. And everything will be done online on mca.gov.in. This we have already seen. Then along with that, we have various types of companies in India, and as per the types of company, they have different characteristics. Like when we talk about a private limited company, very importantly, we have few points in the articles of association. So by looking into the articles of association, we can justify whether particular company is a private or not. Because private limited companies articles has three very different points. First of all, prohibition, and two, restriction. So prohibition talks about prohibition to go for public issue. Second, restriction talks about restriction as to transferability of share, and third restriction talks about restriction as to number of members. So number of members cannot exceed 200 in a private limited company. Also, it enjoys various privileges and exemption under Companies Act just because it's a private limited company, a small held company. When we talk about a public limited company, it has a stricter legal compliances, but over here the transferability of share is free. They can go for public at large. There is no limitation as to number of members, but exemption privileges are not available to the public limited company, and it is largely held, widely held company. When we talk about an OPC, a single person doing business with the limited liability and along with a separate legal entity status, it's a OPC. So there cannot be more than one shareholder in an OPC. Got it? Understood. But yes, there can be more than one director. The different thing in OPC is about the nominee. It is compulsory to nominate a person called as a nominee. So if something happens to the sole owner of the business, nominee shall take over as a member of the OPC. Now, as far as minimum number of members in private limited company, we require 2 members in private limited and maximum cannot exceed 200. Number of directors, minimum 2, maximum can be 15. It can be increased beyond 15 by filing special resolution in the general meeting. As far as your public company is concerned, public company minimum number of members required are 7, and this can have n number of shareholder, no problem. So such public companies can be listed companies also. Then minimum number of directors required are 3 and maximum 15. Even over here it can be increased by passing special resolution in the general meeting. In few listed companies there is a compliance as to independent directors requirement. Few other public company which are not listed, when they require independent directors. When we come to the OPC, minimum and maximum number of shareholders required is only 1. It cannot exceed 1. But directors, minimum 1, maximum can be 15, no problem at all. Okay, so these are the very, very important things. And is there any share capital requirement? No. For any type of company, there is no minimum or paid up or authorized share capital requirement. So it will be very easy for entrepreneur to start the business So this is an advantage for the startup because there is no minimum paid up or share capital requirement. Now when anybody wants to register a company, they need to make memorandum and articles. Memorandum is a basic charter of a company, very important charter of the company. It is like a constitution of the company, and company cannot go beyond this memorandum. Any act done ultra-vires to the memorandum will be void ab initio, right? Now can you tell me what are the clauses in the memorandum of association? I hope you can recall that. So let's recall together. First one is name clause, where we write the name of the company. Second one is a registered office clause, where the situation of the registered office of company is there. Are we going to write the entire address? No. We are not writing the entire address, but only we are going to write the state in which our company is registered. The third one comes is object clause. Here we'll be writing the main object of the company. Along with the main object, we also write the ancillary object, the important other things which are important to be done to give effect to our main business, right? Can we go beyond our object clause? The answer is no. We have seen this in chapter number 3, right? Remember Ashbury case? Yes. Okay. After that, the fourth clause is a liability clause. Over here, our company is either limited by guarantee or limited by shares or unlimited liability. This will be identified. After that, the fifth clause is your capital clause, where what is the share capital of the company is given. Okay, so over there we write the authorized share capital. Also we write how the shares are divided into. So this is how we write it. The last clause we have is a subscription clause. Subscription clause is in both the charters, that is memorandum and articles. So if anybody wants to become member of a company, they have to subscribe when we are incorporating. Also for becoming members, the other way outs are also there. Okay. So subscribers are the first subscribers, are the promoters of the company. With them we are going to incorporate a company. Okay, so these are the 6 clauses of memorandum. All 5 can be altered. We cannot alter the subscription clause. This we have already seen. Now what is your articles of association? It talks about the internal working of the company, internal rules and regulations of the company. If any act done beyond articles, can we ratify that? I hope you all got your answer right. We can ratify that. If all the shareholder or if shareholders give consent, we can ratify the act given under articles. But if the particular act is beyond the memorandum, can we ratify? The answer is no, we cannot do that. So all these things we have already learned in your chapter number 3. Now quickly we'll go to the legal formalities. Now first one is your pre-incorporation formalities. Pre-incorporation means what? Till now your company is not registered. So before that, what all formalities we need to do are called as pre-incorporation formalities. Very important, we need to take DSC of all the directors because we are signing form digitally. So we are not filing any form offline, so all the forms will be digitally signed. Also, if any person does not have DIN, we have 2 options. We can take DIN from Spice Plus. I hope you remember how many DINs we can obtain from Spice Plus. 3 DINs, right? We can obtain 3 DINs from Spice Plus. And if any person does not have DIN and if maximum number of directors are there 7, none of them had DIN, we have to first apply for 4 DINs or for 4 directors because we can apply only 3 in Spice Plus, correct? So we have to attach ID proof, address proof and PAN for taking out the DIN, which is the form number apart from Spice Plus for the DIN. I hope you got it correct. It is DIR 3. Then we have our incorporation form Spice 32, that is Spice Plus. It is also called as INC 32. Even memorandum articles are also electronically filed. So INC 33 is memorandum INC 34 is Articles of Association. Okay, tell me one thing. How many subscribers can digitally sign the form, that is memorandum and articles? I had told you the limit in chapter number 2. I hope you remember. Yes, only 7 subscribers. If more than 7, you need to attach memorandum articles by scanning that, and you have to take the signatures of all the subscribers. 9. Once your company is incorporated, once ROC issues a certificate of incorporation, there are various post-incorporation contracts also, formalities also you need to take. Spice Plus gives us bouquet of services like from PAN, TAN, opening of bank accounts, EPF, EPFO, everything is done under Spice. Even GST we get it under Spice only if it is applicable to us. So it's a separate legal entity doing the business. But apart from this 10 services, you have to take various other registrations and licenses. What you need to take? Various other registration and licenses. Now this registration and licenses will be depending upon the business you are doing. Number one, what kind of business you are doing. Like you are doing import and export. For doing import and export in India, you need to take IEC, that is Importer Exporter Code. Only then you can do import and export. So we need to take IEC. If you are doing food business in India, you need to take FSI license. Have you seen, buy any product from the market, the packed one, you can even check with your Maggie. Okay, backside of the cover, you will get in block letters FSI, FSSAI, FSI. So they have a FSI registration number. So be it a small vendor up to the large giants, everybody is supposed to take the food registration, FSI registration. So depending upon the type of the business, okay, you have to take the registration. This is all we are going to learn in your part B in chapter number 13. Also, where you are doing business, the locality, because to every state there are certain particular laws applicable. So you have to take the registrations under that. So this all are your post incorporation formalities. We are not learning right now over here, but we'll be learning that in your part B. So all these things we need to do. Along with that, under Companies Act, you need to comply with various other compliances like maintaining the statutory registers, holding the required number of board meetings, general meetings in a year, also filing the forms with ROC and other compliances. If your company is a compliant company, then everybody would like to be invested in that. But if your company is not a compliant company, nobody will like to be invested in that. I hope you have understood. So this was regarding a brief on formation of startups. Most of this part we had discussed in chapter number 2. This was very easy peasy video for you, right? So let's start with our next topic, important points relating to the startup. This you may get as a direct question or it may be asked in the form of a case law. So let's start with the first point in that is choosing the right legal structure for a startup. This we have also seen in chapter number 1. Right from chapter number 1, we are discussing about various types of organization. So whenever any entrepreneurs want to start a business, it may come to a professional for asking for what is the right form of structure for me, because entrepreneurs knows only and only business. But we as a consulting professional, we know each and every formalities, right from the incorporation up to the pre-incorporation contracts, post-incorporation formalities, tax structure, everything we know. Okay. So whenever any of the entrepreneur comes to us, we have to guide them properly. We have to tell them what are the advantages, disadvantages of each and every type of organization. Once he knows everything, as per his business, as per his risk taking capability, as per his capital, as per his further plan like scalability of business and all, he must decide upon what is the best kind of structure for him. Like if he wants to do business at very large scale, can he opt for a partnership? Answer is no. He cannot opt for partnership because in partnership there are many disadvantages. The first very important disadvantages is the unlimited liability. So when you have an unlimited liability, is entrepreneur able to take more risk? The answer is no. Whereas company in comparison to that can take more risk. Why? Because the liability of directors and members over there is limited liability. I hope you understood this. That's why choosing a right structure is very important. If somehow without taking much pain an entrepreneur ends up with an organization, after 2 years of business he really understands that how mistake he has done by not taking pain in deciding the form of the organization, because after 2 years his business is stable but the kind of entity under which it is doing a business, it's not perfect for that. If he wants to take loan and he is having a registered partnership, what's the use of that? Banks don't prefer unstable kind of organization. So there he would realize I would have formed a company or at least an LLP. So that's why choosing a right structure of business is very important, and it's most crucial decision for any of the startup. So what are the factors which determines this? The factor, very important factor, is the nature of your business. If it's a small scale business, we can go for a sole proprietor or a OPC. If you want to be a startup, and even though you are having a small business, you have to go for either a partnership or LLP or a private limited, because OPC does not come under definition of a startup. Then what is a business trajectory? How you want to explore or you want to expand the business. It is at much higher level. Your business is scalable business, then you have to always go for a company. Then what is a regulatory? Tax considerations you have to do. Also you have to consider the cost of formation and ongoing administration. What is a external capital requirement? External capital requirement means how much borrowings you will require. If more borrowings you will require, always company or LLP is preferred, because your foreign investors and along with your bank, they always prefer the stable form of an organization. Then which type of funding you are sorting? Legal liability, that means whether limited liability or unlimited liability. How many stakeholders you can keep? Balance required. If you require a balance between the ownership management, you want to do everything on your own, then LLP is better. If you don't want to go for any of the management, you only want the ownership, you want management to be dedicated to the directors of the company, we can go for a company then. What is the mechanism for profit sharing and also distributing the same? So all these factors will determine which is the best kind of activity. Right now the most preferred ones are your LLPs and a private limited company. Why? The reason being both have limited liability, and second reason, ATIC is available only to this both. Is it available to the registered partnership? Answer is no. Okay. Then second starts with the registration and the business licenses. As I told you, there is a requirement of a post incorporation formalities, like with Spice we are going to incorporate. We can apply GSTIN in that only. We can also provide for ESIC in that only. Along with that, we can file a JIGL for GST, also opening of the bank account. Memorandum articles can be filed online. So once all formalities are over, once incorporation is over, we get everything together. Once we are done with all the formalities, then we have to take the business licenses. Business licenses will be depending upon the type of business and the locality where we are operating, right? Then you have other determining factors like number of employees, location of business, form of ownership, etc. On the basis of that, different licenses are there. So this was the second point. Third point talks about the intellectual property protection. Whenever there is any startup is relating to any of the invention, you have to register that invention. Just because you are a registered private limited company, it does not give you protection under intellectual property right also. For example, I have invented this pen, the first pen which can be written on the laptop or any of the surface. So this I have invented. Can I assume that I have incorporated a private limited company? Now automatically I will get protection under IPR laws also. It does not happen like that. You have to register. Okay, so you have to register under intellectual property right law. Law does not give you protection without the registration. So if my invention is there, I can register under the Patents Act. But this registration under intellectual property right law has to be done in the name of startup only. Okay, it needs to be registered in the name of startup. Then only we will get that 80% reduction on the DPAT, that is on the fees of your patent. If you are taking registration in the name of director or any of the shareholder, it is not a patent or any of the trademark or any of the intellectual property right of that of a startup, but it is that of an individual. So registration of IPR has to be done in the name of startups only. So any of your IPR should be registered in name of entity and not in the name of promoters or founders of that. Also important line, registration of company does not by itself give protection against others who might commence using identical or similar mark. So when you want to protect your logo also, if I am doing business by name of Vandita Doshi, I don't want anybody using my name. So when I have registered the company, does it give me automatic trademark registration or protection? The answer is no. People can use that. People can form Vandita Doshi sole proprietorship. They cannot get the identical name. No. Okay, they have not incorporated a company, fine, but they can incorporate the sole proprietor. They can take the partnership also. Okay, so if I want to protect my logo, my trademark, my business name, so what I have to do? Take registration under Trademarks Act. Clear? Understood the third point? Going to the next point is a founder equity split and vesting. Now what is this? Let us understand what is a founder equity first. Founders equity. Then we are going to learn the split up and wasting of that. Okay. Now for example, we have an innovator. Vandita Doshi is an innovator. I have invented a pen. Now I want to do business of that. I have taken a patent on this and I have obtained a patent. So I have patent. I have taken patent in name of Vandita Doshi Private Limited. So I have incorporated a company and taken name in that. Okay, so myself innovator, along with that I have one more founder who gave me capital called as Mr. X. So Mr. X bought capital. So both of us, we incorporated a ABC Vandita Doshi Private Limited, and that we also registered the patent. So patent is in name of our startup. So now the innovator and Mr. X. So there are two members. These two members, okay, these two members, don't you think they are the founders? Yes. So the equity will be split up among the founders on the basis of the contribution they are doing. So Vandita Doshi is giving patent because she has invented, and Mr. X is helping her with the capital. So founders equity means nothing but Mr. X is holding 50% in the company and Vandita Doshi is holding 50% in the company. Both are holding some amount. So what we did, 50% is nothing but we did split up of our equity. The split up of equity happens among the founders. Who are the founders? Vandita Doshi and Mr. X. Vandita Doshi bought a patent, Mr. X bought a capital. Okay, so this is called as a equity, founders equity, and the split up of that equity. Now we need one more thing. So one of our friend joins us called as Mr. John. Mr. John has expertise in the market. He knows how to do the marketing. So he is going to bring in marketing expertise in the company because this is what is required for growth of the business, right? So earlier there were only 2 people, now there are 3 people. One, Vandita Doshi, second, Mr. X, and third is Mr. John. Earlier the equity split up was 50-50, but now we have to give some part of equity to the John as well. So what we did, from our portion we give some part to the John. Now initially how it happens, even though this 50-50 belongs to the founder, still all the equity share do not vest upon them completely. So what does that mean? Example, Vandita Doshi Private Limited was incorporated on 1st of Jan 22. When was it incorporated? 1st of Jan 22. Now it has 3 shareholders, Vandita Doshi, X and John. So the equity split up is 40%, 30% and 30%. So this is how is the equity split up between the 3 founders. Now this 40, 30 and 30 do not waste on the date of incorporation. That means even though I am holding this much, but it will not belong to me on that particular day. Understood? That is called as a wasting. So even though it incorporated on 1/1/22, this equity do not waste in founders immediately. So what do? We create something called as a wasting schedule. What do we create? Wasting schedule. Wasting schedule means what? Within 1 year of incorporation, I will be writing about the wasting schedule. Within 1 year of incorporation, that is on 1/1/23, each shareholder shall get 10% of the equity. How much they will get within 1 year? 10%. After 1 year, they shall get other 15%. And after that, the balance remaining shall vest upon that. So right now, how much they are getting? They are getting only 10%. Because up to 23, how much they are going to get? Only 10%. So out of 40%, I will be getting only 10% in 23. Then in 24, I will be getting 15%. In 25, I will be getting my balance. So all the share do not come to me immediately. Now why such things happens? What is the reason of this wasting schedule? Why founder cannot be given all of the share? Say for example, Mr. John, okay, who was a marketing expert, he became the shareholder. He took 30% of the shares. He bought at 100 rupees. How much? 100 rupees shares. Now after 2 years, he understood that this company is not going to grow. So Mr. John wanted to exit the company. If 30% of the shares are given to him, after 2 years, the market value of the share has increased. Understood? So he will be selling shares to the company not at the face value but at profit. Suppose now the value of share is 150, so company has to pay 50 rupees extra for each and every share. Understood? But now in the second year when he is going out, how much share he has? Second year means 24. Okay. So 24, he does not have all of these shares. 5% of shares are still remaining. So company will be saving on that 5%. Those 5% company will be taking at cost only. I hope you understood what is the advantage of a vesting schedule. Now we will read your theory part. Then you will understand it as a whole. Okay, so let me revise one thing for you. What is a founder's equity? Whenever any startups split the equity among its members, among the promoter, is called as a founder's equity and split up. Entire equity share is not allotted or does not vest in the founder immediately. There is a vesting schedule. Vesting schedule depends upon the contribution or any other market practices. I hope it is clear. Okay. So what is a founder's equity? It should be split among the founders based on the nature of role they are playing. Along with that, time, effort and the capital contribution. Okay. But this split up has to be done with lot of discussion. Now in this, Vandita Doshi, X and Mr. John, they decided to have 40, 30, 30. Do you think they did it randomly? No. There is requirement of something called as an healthy discussion. Why there is requirement of an healthy discussion? Because if healthy discussion is not there, not done now, after 2 years I realize, oh my god, Mr. John is doing nothing, for that is taking 30% and I am doing everything. I have given patent, for that I am getting only 20%. What is this? So whatever a founder requires from the other people, everything has to be sorted first only before incorporation of that, before entering into any agreement. So once things are sorted, once you have done with the healthy competition, everybody knows what are the needs, everything is clear, there is no scope of misunderstanding. No, most of the agreements are broken because of the misunderstanding. So when any equity is taken without any discussion, it will lead to what? Tension and unhappiness. We don't want all this in our startups because it's a business, everybody money is there, so we should take it very seriously. Hence healthy discussions are very, very important. Then vesting schedule is there. Typically vesting schedule is there for 3 to 4 years. In 3 to 4 years, founders get all the equity shares and they are owners of the shares. Okay, so when vesting schedule is imposed, the unvested shares held by founder become subject to contractual right to repurchase or transfer, often at nominal value. So if any founder wants to go out or voluntarily leave the organization, how much ever is the unvested amount. So in our example, Mr. John was there. The unvested amount was 5% of the share. So those 5% of the shares can be taken back by the company at the nominal value, that is your face value. I hope you have understood what is a founder's equity. I hope you have understood the split up, also the vesting schedule. What is the meaning of vesting? You can take a note of it, which means to give right to present or future payment, that is called as a vesting. Coming to the founders agreement. What is a founders agreement? As I told you, it's very much important to do discussion. Okay, so Vandita Doshi, John and X did a healthy discussion. Do you think healthy discussion is over? Fine. But orally if we fix everything, is it correct? What is the proof? No proof, right? So what you need to do, you need to lock that. How do you lock it? We can lock it by writing, or also recording is a valid proof now. So you either make an agreement or record it. Making agreement, even courts accept the agreement. So before your memorandum articles is there, we have one more agreement called as a founders agreement. So Vandita Doshi, John and X are sitting in a meeting. Three of them meet at a particular stage. Yes, okay, everybody agrees. When they say everybody agrees, there and there only they make a founders agreement. What do they make? Founders agreement. Founders agreement can be in any form. It can be shareholders agreement, it can be partners agreement, also known as a founders agreement, or a memorandum of understanding. MOU also can be made. So all the terms and condition on which you have started a startup, that will be written. Memorandum article comes at a later stage. I hope you understood this. So these are the founders agreement, very much required to have a clear understanding between the founders on all the key issues related to the startup, and that everything will be there. What will be the equity split up, what will be the contribution, what will be the role, what will be the duties, everything will be given. After that, about the employment contract. Whenever you are a company or LLP, you will always require an employee. So whenever employee comes in to work in an organization, it's very much important that company takes or makes a contract. So there is a contract between a company and an employee, which is called as an employment contract. Guys, when you will become a company secretary and join any of the organization, not as a trainee but as a company secretary, then they will also want you to sign an agreement. In that agreement, all the terms and conditions are written, right from your appointment up to your salary, your incentives, your duty, termination of service, code of conduct, everything is there. Along with that, there are few important clauses which every employment agreement should have. Now, what all things are important? Description of job, compensation, other benefits. Okay, these are the normal clauses. Very important clauses are non-competing clauses. So whenever I leave the organization, there will be a stipulation in that I cannot start same kind of a business in that particular area or immediately. So it will be stopping employees from setting up competing entities, generally called as a non-compete clause. Also one more clause is there, non-solicitation clause. Means I being employee of a company, I cannot take away the clients of the company and pass on to the rivals. So if I am making my own company, I am working in that company, but what I am doing fraud with the company where I am working. So I am soliciting the clients of my company and giving them other clients. This is wrong. You cannot solicit the client. So there is a term or clause called as non-solicitation clause. Also, employees cannot claim on any intellectual property which they have formed. So if any scientist is working for a company, can scientist claim it is my invention? No, because there is an agreement says that whatever inventions are made by that particular engineer or a scientist, that will belong to a company. So likewise, even startup has to protect themselves, so it has to enter into such agreements. After that, ESOP. ESOP is nothing but an incentive given to the employees. So you can put the ESOP clause. You can put the ESOP clause in your agreement or a contract. Basically, ESOP are not the shares, but it is just a discount given to employee to purchase the share. Once they purchase the share, employees become the shareholder. Now tell me one thing, are employees counted for number of shareholders? Answer is no. We don't count employees and the ex-employees. This was a bit revision we did. After that, the next one is a third party agreements. Third party agreements with what? Till now we have seen the promoters, employees coming in, but now we will require the directors, we will require the company secretaries, we will require the chartered accountants, so we will require many other people. So third party agreements. So now we are taking the services from the third party. So whenever we are taking services from the third party, there has to be a crystal clear contract between the company and a third party. What will be the contract about? A non-disclosure agreement. See, just imagine there is a lawyer. Okay, you have filed a case in the court of law and there is a lawyer who is helping you. Okay, and he is litigating on behalf of you. So you will be giving him all the information which is secret, right, which is not known to the public at large. Now tomorrow if that lawyer goes away, he is working for the other client who is your rival. Can that lawyer disclose all your secret things to the client? Answer is no. This is not a professional approach. Hence, it's very important for a company to protect its secret information. Also, when we will be working in the company, we will not be allowed to share anything happening in the company at home. Why? Because we will be a compliance officer at the board of directors level. Okay, so you know all the secret things about your company. Most probably it becomes a insider information. Insider trading is not allowed. Okay, so there is a non-disclosure agreement. So when you sign a non-disclosure agreement, if you disclose and because of that if company faces some losses, company can sue you in the court of law. So non-disclosure agreement is very important. Also one more agreement about the intellectual property rights. You should be very clear cut in your startup saying that all the intellectual property rights will be belonging to the startup only. None of the third party, none of the employee can claim any of the intellectual property right. Should protect your IPR. Also, if any of the clauses is breached, terminated or there is any dispute resolution, then you should always have very clear cut instructions in the contract. Like you can opt for arbitration clause in that, where you will say that whenever any dispute arises, we will go to the arbitration instead of going to the court of law. Okay. After that, our investment structuring should be very clear. It's big question as to how to be our investment structure. We will require a professional help for this. We will not require because we are learning all these things. But think about a layman who does not know about a private limited or a public limited. You will always need a professional to do the structuring of the capital or the investment. Okay, so investors like HNIs, angel fund, they invest at very early stage and also at the growth stage. So it's very much important that we should not liquidate our company totally to them. Okay, so if we liquidate our company, that means you give 40%, 50% stake to them, what is there in your hand? So you have to keep your investment structure very clear. The 20% shall belong to the founders, other 10% to the HNIs and rest you should keep for the series round, the funding round which we are going to see. Okay, after that the compliance management is must. Every investor likes a compliant company. Okay, every investor likes a compliant company. Nobody likes to invest in a defaulting company, and there are various compliances under Companies Act, Income Tax Act and other applicable laws to the company. It will depend upon the type of a business of a company. So we have to do our event based compliances and annual compliances very properly and compulsorily. If we do default in that, we will be having or facing the huge litigations which can happen in the court of law, NCLT. Also company has to pay huge penalties for that. So I hope you have understood what are the important aspects of a startup. Very important 10 points are there. Okay, thank you so much. You can read the notes one more time. Okay, I know a little bit it's a theory, technical things are not there, so you can remember it and write in your own language. So let's begin with the next topic, that is financing options available for a startup. Before beginning this topic, I want you to understand certain points. I know you know all these things, but still let's understand what is an equity. Okay, if you have learned your Companies Act, so you are knowing the basic of equity. Basically, what is an equity? It's a share capital in a company. You always talk about the equity share capital, paid up share capital. I have told you what is the equity paid up share capital. So company issues equity shares, and anybody who subscribe to that equity share, they shall be members of the company. Members are the owners of the company. So whoever subscribes to the equity share, they become the owners of the company. So are they going to manage the company? No, they are not the managers, but they are the owners of the company. Along with that, they get various rights, such as they get voting rights, they get right to attend the meeting, also they get right to dividend. So all these are the rights of the owners of the company. Voting rights are only available for equity shares. So whoever owns the equity share only have a voting right. Preference capital does not have a voting right. Only if their interest or their premium, okay, whatever company pays them. So that is an arrears, only that point of time they shall get the voting rights, otherwise preference share capital does not have a voting right. So only equity shareholders have right to vote in the meeting. Also, at the time of winding up, if anything surplus left, say for example, after paying off all the liabilities, 10,000 crores are still there in the company. So that surplus shall be distributed among the members of the company. So these are your equity shareholders. Even equity has certain disadvantages also. What is the disadvantage in the equity? If I am investing today in Reliance and tomorrow if Reliance goes bankrupt, am I going to get my money back? Answer is no. This is the biggest advantage of an equity. So whenever anybody is investing in the equity, if company is growing, your capital will grow. If company is not growing, your capital will be at stake because there is no term of a repayment in the equity. Whereas when we talk about the debt, when we talk about the debt capital, whenever company issues debentures, whenever company issues the debt instruments, the person who subscribes to that, the person who subscribes to that will be called as a creditor of a company. They are not owners of the company. And equity capital is very different and debt capital is very different. Debt capital is nothing but company has taken loan, that is a debt capital. Okay, so debt capital, and the person who subscribes to the debt debentures are called as a creditors of the company. Do they get the voting right? No voting rights. They are not the owners of the company, no voting rights, because voting rights are only available to the owners of the company. But in debentures, there is very important thing called as an repayment. So repayment is done along with the interest amount. So your business is running or not knowing, after 5 years, whatever, whenever is your maturity, you have to pay the principal amount along with the interest. This is the biggest drawback for a startup. So mostly startup does not go for debt. Why? Because they have to repay the money. But if business is not running, then what will happen to it? You have to pay along with the interest. Clear? Understood? So this is your equity and this is your debt. Now we'll go to our notes. Funds are a big challenge to our startup. Now this table will make you understand how and what kind of funds are good for a startup. First is a equity, then your debt, then your grants. So we'll be learning in the form of a distinction. So as far as the nature of equity, what is the nature of equity? There is no component of a repayment in that. This we have discussed. But when we talk about the debt, there is a component of repayment, that too along with the interest. And when you receive grant, the donation from the government, is government going to ask you again, be it a government or any other private entity, who is very happy with your business and want to encourage you by giving the donation. So will you not accept? Obviously you will accept. But does grant means you are giving back? No, there is no component of repayment. There is no component of a repayment in this. Clear? Got it? After that, about the risk. Now this risk we are going to see as far as investor is concerned. When any investor invests in the startup, the highest risk he is taking. Why? Because there is no guarantee whether business is going to run or not. If business did not run and company goes for winding up, there is no surplus. Can investor ask for the capital? Answer is no, because there is no repayment component. But what about the debt? Over here for investor the risk is very lower. Why? Because he is very much relaxed. Even though business runs, does not run, does not matter at all. They are very much relieved because at the time of maturity he is going to get his amount along with the interest. Okay. And what about the grant? There is no risk factor, because whoever gives grant, he knows he is not going to take that back. Okay. After that, what about the pressure of repayment? In equity, now we are going to look into the startup promoter's point of view. Does startup have to repay in the equity? No. So your startups are very much relaxed. There is less pressure as far as repayment is concerned. But yes, when you have HNIs, when you have angel investor, they have certain targets. You have to achieve that. But still, it is not enforceable. Got it? Now, what about the debts? When you talk about the debts, it's vice versa. More pressure is created. So your business is running, not running, does not matter. You have to pay back along with the interest. In grants, no effect, no pressure. You are not repaying any of the grants. What about the return to the investor? If your company will grow, the capital will grow, and that is the return to the investor. As far as debenture is concerned, the interest will be the return. What about the grants? You don't get anything, so no return on that. Now, involvement decision. Do equity shareholders have right to vote? Definitely. They have right to vote. They can involve themselves in decision making process. They can attend the meetings and vote. What about the debenture? They have less. Legally, they don't have any voting rights. But yes, because they are the investors, you cannot say investors, but the creditors of the company, there will be less involvement in the decision making. What about the donations? No direct involvement. Yes, peer pressure is always there, but no direct involvement. Now, what are the sources of these funds? From where do we get the equity? Equity we'll get from the angel investors. We are going to learn all of this. Self-financing, where promoter himself bring money which he has saved from family, friends, venture capital, crowdfunding, incubators, accelerators. So this is all the investors in the equity. What about the debt? From where do we get loan? Obviously banks, NBFCs, then you have government loans, Mudra loan we are going to learn, and Startup India. What about the other donations? Donations are given by the central government, state government, corporate challenges. If you win, you get the donation in that. So these are the sources of the capital. And I hope you have understood what are the different types of capital and which one would be best for a startup. I think equity is the best for a startup. The startup generally goes for more of equity and less of debt. Okay, so now very interesting topic we are going to start, that is the seed capital. What is a seed? My drawing is very bad, but still this is a plant. Have you seen how plant grows? We have to add seed to that. So once we add seed, then you have to nurture that. Add water, sunlight, fertilizers, whatever is required. This is how your plant grows. Now this you have to think from the startup perspective. Even your startup is same like a plant. Okay. Now whenever an entrepreneur wants to start a business, he will require something called as capital. Capital is a life, or you can call it as a lifeblood of any business. Without capital, can you do anything? The answer is no. So whenever any entrepreneur collect a capital and start business with that is a seed capital. Okay. So any capital with which it starts its business. It starts its business is called as what? It is called as a seed capital. Definitely along with the seed capital, he will require 10 other things. Like along with the seeds, plant require 10 other things. But the most important thing is a seed. So in startup, most important thing is a finance. If finance is not there, you cannot start your business. You will be zero. The seed capital is very, very important. So from where do you get a seed capital? This entrepreneur, where we will arrange the seed capital. We have various sources of that. First comes self-financing. So whatever he has saved, the promoter, the founders, whatever they have saved, they will finance that. Okay, because any investor will come, investor will ask how much you have put into the business, because if founders have not put in any money, will investor invest in your entity? The answer is no. After that, you can ask from family, friends, relatives. You can also ask from banks, small loans. You can ask, we have a scheme, no? Government scheme, collateral free loan. You can take loan from a bank. Also, incubators may help you. Incubators are there for you only. So if they are happy with your business proposal, they may give you a seed capital. So seed capital can be taken from all of this. Okay, seed capital is not a huge capital. Huge capital you will start when you are taking a series round. Seed capital is a capital with you to start a business. I hope you have understood. So it's a nurturing of finance to explore and grow. So very nascent stage you are investing a capital with which you are doing a business will be called as a seed funding, also called as a seed capital. So any of the founders who are putting into the seed capital, they have to be very careful when they are spending every penny of that. They have to think 10 times before spending that penny, because that penny very important. If your seed capital gets zero, are you going to grow in a business? The answer is no. Are investors going to rely you for the second time? The answer is no. So you have to utilize every penny of that in most optimum manner to ensure the smooth functioning. Also, you can save it for the further stages. After that, initial capital we get it from founders, family, friends, no problem at all. It also explores your business idea, and it will also tell you how your product will be viable or not viable. Seed capital is very risky. Why it is risky? When we think from the investor's angle, seed capital is very risky funding, because at that point of time it is just a seed. When you put into the seed in that pot, can you tell 100% whether plant will grow or not? Nobody knows about it. 95% your efforts are there, 5% your destiny is there, right? So it's most risky investment. But if the plant grows, if your business grows big, you will be earning big by investing less. This is the main idea of investing in the small businesses or the startup businesses. So they will have to wait and watch approach about their idea. So whatever founders or seed capital is there, it should be carefully utilized. After that, paperwork, whatever is involved in the seed capital is very less, because we have seen that we are obtaining the capital from relatives, friends, families. So less rate of interest as compared to the bank, less paperwork, very straightforward approach will be dealing by making a memorandum of understanding, MOUs, or when it is in the family only, the oral agreements also happen. So very less formalities when we compare it with the round funding or series funding. We are going to learn that in this chapter. Also legal fees required are very less. Okay, also end use restrictions are not there in this, but when you take loan from HNIs or venture capitalists, they will tell you where you can spend, where you cannot spend. So end use restrictions are there. But for seed capital, when you're taking from the relatives, you have that relaxation to use that money. Okay, so this was about your seed capital. You may get a short note on a seed capital. So very important points you have to write. If it is asked for 5 marks, write at least 6 points about less paperwork, documentation, time required is less. What is a seed capital, you can write. Also, how to attract the investors, you have to write. It is very risky option for investor, that also you need to quote. So this 4 to 5 points, if you underline it, you are done with your seed capital. So now let's start with the next topic, that is the funding procedure. So till now we have understood what is the seed capital, startup and all. So now when we talk about the funding, when we talk about the finances, broadly speaking there are two kinds of finances. One is your equity financing and second is a debt finance. Equity finance and the debt finance. This is a two category broadly categorized into the financing. So whenever there is a startup will go for more of equity and less of the debt because of various characteristics of the debt. Because in debt they have to repay even though their business does not work properly. But in equity, at the time of winding up only they are going to repay, that too surplus if any. So in equity, there is no characteristic of a repayment, but in that there is a characteristic of a repayment. So before going for the funding procedure, what are the various stages in the funding procedure? Let's understand and go to our notes. So as we discussed earlier, broadly there are two kinds of capital. One is equity, another one is a debt. So first we are going to understand what is a equity financing. Startup, as I told you, will mostly prefer the equity. Now from where they will get the equity? Seed capital, they will get it by themselves or friends, relatives. And next type of a funding or next stage, they will go for venture capitalist, private equity investor or an angel investor. So when we talk about a private equity or a venture capitalist, there are various series round, and this is a stage where a company will get huge investment like 100 crores, 200 crores it will get. So for scalability of a business, after seed capital, after HNI round, they can go for the venture capital. Okay. Now venture capitalist, do they get you on the roads? No, they do not meet on the road. You have to actually approach them. So when you approach them, you have to give them very good pitch. So what is the procedure, how to approach them, how to do meetings with them, this is all we are going to learn over here. Whenever they want to subscribe to our shares, mostly they will prefer preferred option. Okay, this preferred option are convertible preference shares and compulsorily convertible debentures. So they will opt for either of this. So whenever your company gets listed, there is a one particular clause. Whenever a startup will get listed, this compulsorily convertible preference or compulsorily convertible debenture shall be converted into equity on listing. So they will get the equity share also. This is how they do the arrangement. So what is the most preferred stock for venture capitalist and the private equity? It's a compulsorily convertible preference or compulsorily convertible debentures. Also, they will carry out various due diligence. So let's see from our notes. Say for example, there are three entrepreneurs, Mr. A, Mr. B and Mr. C. These three have started with a startup called as ABC Private Limited. What they have done? They have started with the ABC Private Limited as a startup. So already the first stage, they required seed capital. Seed capital they have arranged from their friends, relatives, themselves. They have given loan. Okay, so not a loan, very sorry, but they have invested in the equity. So seed capital is somehow managed. Now there is a second stage where they require more finance because they want to purchase the machineries, equipment, set up the industry. Suppose they are dealing in the goods, so they want to set up the industry now. They will require more finance. So after seed capital, now your round starts. So what you will do, you can approach various venture capitalists or HNIs. What you can do, you have to do meeting with venture capitalist or HNIs. What HNIs? High net worth individuals, or can also get loan from angel investors. It can be debt, it can be equity. Over here we are talking about the equity. So you have to meet your venture capitalist, HNIs or angel investor for getting investment in your company. Do you think it is so easy? The answer is no. So what you have to do, you have to approach them first of all and fix the meeting. Okay, and when they give you a date, you have to meet them, make a very good pitch. You might have seen Shark Tank India, right? What they did, entrepreneurs, by giving their foolproof speech or a pitch, they tried to influence your sharks. The same way angel investors and others are there who have a lot of money and they can invest if they really think the business is profitable. So in the meeting, now there is a meeting of ABC and your investor. So in the meeting, what all things will be done? There will be healthy negotiations. What do you have to go? You have to go for healthy negotiation. ABC Private Limited and your investor, both of them have to place forward. First of all, ABC have to say, if investor likes it, okay, it can place their own terms and condition, counter offers are made, so many things are done. So healthy negotiations are done. So once healthy negotiations are done and they reach at a particular place, it is both of them consent to certain terms and condition, it is to be locked. How? By an agreement. Now this agreement need not be so formal. It need not be so formal. It will be a preliminary agreement. Which agreement it is? It's a preliminary agreement. Generally, we can sign MOUs for that, memorandum of understanding. Because investor will say, right now we are ready to do it. I like your business. I am ready to do the investment in your company at so and so terms and condition, but I need to do due diligence first. So once MOU is signed, the next step will come as a due diligence. They will go for due diligence because investor will check everything in the company. He is going to give 50 crores, 5 crore, 10 crores to the startup, right, to a stranger. So definitely it will do a rigorous due diligence. So professionals will be appointed by the investor and due efforts will be taken by all the company, that is your startup, to give good cooperation in this investigation and the due diligence. So everything found correct or good. The due diligence was very, very good. Then they can sign something called as a term sheet. They can sign a term sheet. Term sheet is like your final agreement. Term sheet is like your final agreement. So first MOU, then due diligence, then term sheet. After that, this term sheet will also be called as founders agreement. I hope you remember this. Okay, so over here the final terms and condition will be locked. After that we will go for the contribution. Now when the contribution is an equity contribution, so in that case we'll have to enter into a shareholders agreement, which we are taking a debt. Okay, in that case debenture agreement. So it will depend upon the type of contribution investor is giving, which all documents you have to do. Clear? Understood with this? Now say for example they are contributing equity. So when they are contributing equity, we can form two agreements. Now even Companies Act 2013 has given legality to the shareholders agreement. Shareholders agreement is nothing but it's an agreement between the company and the shareholders. Apart from memorandum and articles, whatever rights are given to them, if the shareholders are the HNIs or investors, they want to put their own terms and conditions, they can put in the shareholders agreement and that is legalized. So when there is a equity, the first agreement which we have is the shareholders agreement. But this is not compulsory, it will depend upon the company and the investor. But second one is compulsory, that is a share subscription agreement. Okay. What shareholders agreement? It's an agreement between company and shareholder. Agreement between company and the shareholder, where terms of conditions of company and a investor is fixed, that is a shareholders agreement, and then company also have to give them the share, so there is a share subscription agreement. After that the private placement will be done by the company. What is private placement? This is governed under section 42 of Companies Act. In that, whenever company issues share to particular class of people, and that class of people is already known who are going to your allottees, like you have done agreement or done meeting with the investor, you know who is going to be the shareholder. So are you making an offer? No, you are making a private placement. Okay, so private placement, you have to follow procedure of private placement as per section 42 of Companies Act 2013. After private placement is done, we have to file various forms, that is pass 3 with the ROC. This pass 3 is to be filed within how many days? To file within 15 days of the private placement or the allotment of the shares. Also there are many other formalities, but this is a basic formality which every company has to do in the private placement. I hope this is very, very clear. Okay, so what we did till now, let's see. One seed capital startup got. After that, when it requires more capital, it can start meeting the HNIs, private equity, venture capitalist for the second round. Okay, this basically I cannot call it as a round because this is just a further capital it requires. So it will approach the investor, fix a meeting, healthy negotiation. Once both minds meet, they can lock that by forming a basic MOU. Once MOU is done, investor would definitely like to do a due diligence. Once due diligence is cracked properly, it may say yes to the investment, and then you can enter into a term sheet. Term sheet is nothing but a final agreement, founders agreement. After that, if they are giving equity investing, then two types of agreement: shareholders agreement and share subscription agreement. And if it's a debenture, then it's a debenture subscription agreement. Okay, after that the private placement will be done and the other formalities. So these are the basically procedure for the funding. Okay, you can read in the notes, we have discussed all of this. Now we are going to the shareholders agreement. There are certain points which every shareholder agreement has. Okay, it's not required to have, but investor mostly put all this. That is nomination or representation right. Investee means the investor will always want that they should have a reservation right, that they can appoint 2 directors, 3 directors in a company. That is a nomination or reservation right. Also, there can be a clause that all the important information will be disclosed to the investors. Nothing will be kept secret. Also, they will have a redemption right when they are having debentures or the preference shares on breach of any of the terms and conditions. They may also like to put preemption right. So whenever company is having a further issue of share capital, the first preference is given to them. Right of first refusal or offer means they have exclusive offer or exclusive right. They can reject or can take a offer. So first right will belong to them. After that, tag along right. Now what is a tag along right? Tag along right. This is a protection or benefit to minority shareholders. What happens in this? Suppose there is a company. Majority of part is held by a person, shareholder, and 15% is held by one person, okay, and 10% is held by other person. So there are 3 shareholders. Now a giant company comes to this person saying that we will purchase shares. The market price of the share is 1000. We are ready to purchase it at 1200. Okay, so shares of this giant shareholder is taken up by any of the investor. So when such situation happen, if there is a tag along rights, even the minority shareholders can sell shares on same terms like your majority shareholder. So even their share may be bought at the same price like your majority. This is a protection to the minority shareholders. Okay. Then the other one we have is a drag along right. Another one is a drag along. In drag along, it is opposite. It's not protection, but it's a disadvantage to the minority. So when any investor will be holding majority in the company, it can put this. So according to this clause, the majority of shareholders can drag minority shareholders. Okay. So if majority shareholder want to sell the company, and if they have clause of drag along, even they can force the minority shareholders to sell their shares. That is called as a drag along. After that, there is one more clause called as an anti-dilution clause. Anti-dilution clause is very important. See, right now, investor is having 10% of equity. But whenever company shall do further issue of shares, okay, don't you think this 10% will be diluted? Yes, it can go to 8%, 9%. So this investor, in order to protect his stake, he can put a clause of anti-dilution. So when any company does further issue of share capital, just to save this 10%, company will do various adjustments. What will company do? It will do various adjustment. Like for protecting that, it can issue more number of shares at the same price. Clear with this? This is an anti-dilution. So drag along, we have discussed lock-in period can also be fixed for the investor. Then put call options can also be there. Affirmative vote on certain matters, that means investor right will be there and it will be reserved in certain votes. Anti-dilution. Also investor should be given a exit option after their lock-in is over. So these are the clauses under shareholders agreement. Then private placement is done. After that, necessary forms are filed with the ROC. If because of shareholders agreement you think the articles of association is in ambiguity, there is some clause in agreement which is contradictory to the article, so you have to make the amendment in the articles as per the shareholders agreement. And the last, you have to complete all your subsequent formalities. So this is a funding procedure. This is how it generally happens. Okay. Now we are going to learn very small topic which is called as an angel investor. Okay, now what is an angel investor? Angel investor is nothing but these are the group of individuals. It can group or it can be individual also, no problem at all. So these are the group of individuals, mostly they are professionals. Okay, professionals means any particular field or a sector. Now these people are called as an angel investor who has money, who has a capital, and they are ready to help the startups or any person. Okay, so they are ready to help the startups. Now we are only looking into from the angle of a startup. So startup requires the capital, angel investor has fund. So in return of a equity stake, they are ready to invest in the startup. But SEBI has made certain amendments in that. So as per SEBI, Alternative Investment Fund Regulation Act 2012, whenever any angel investor want to invest in any entity, they have to follow these terms and conditions. So I hope you have understood who is an angel investor. He can be individual, professional or a group of professionals from a particular field. He wants to invest in a company in return of an equity stake. So what are the conditions which SEBI wants a company or an angel investor to follow? Wherever angel investor is investing, that investee company should be within 3 years of incorporation. So a company has not been in existence for more than 3 years. If it is in existence for more than 3 years, angel investor cannot invest in that. Okay, so it has to be within 3 years of its incorporation. Along with that, it should be unlisted company. So angel investors cannot invest in the listed companies, but it has to be a unlisted company. Along with that, the turnover should be less than 250 millions. The company's turnover cannot be exceeding 250 millions. And the last point, the company, that is a company in which investor, your angel investor is investing, that is not promoted by or it is not related to any industrial group which has a group turnover exceeding 3 billions. So 4 points, let us underline that. First, company should in within 3 years of incorporation. Second, it should be an unlisted company. Third, turnover should be less than 250 millions. And fourth, it should not be promoted by or related to any industrial group whose group turnover is exceeding 3 billion. So this 4 points every angel investor has to look into before investing in any company. Now when these 4 conditions are complied with, they have to see about the deal size. The deal size between the investor and company should be between 5 million to 50 million. So minimum 5 million, maximum is 50 million. Also, once angel investor has invested, they cannot take out their investment immediately, but they have to keep it lock in for at least 3 years. So investment will be lock in for how many years? It will be lock in for at least 3 years. Got it? So these are the important points about the angel investor. That's it. We are not doing PhD on it. This much you had to remember. So first thing, who is the angel investor? Second, what are the 4 conditions? Third, about the deal size, and fourth, about the lock-in period. Now let's start with the next topic, that is a series funding. I think you have heard this word series funding for the first time. No worries at all. This is nothing but one stage of a funding. Okay. So I will first make you understand what are the different stages of funding in a business. So stages of funding, very first stage of funding is a seed capital stage. Okay, this we have already seen. At this particular stage, the entrepreneur started business with the help of a capital that will be called as a seed capital. And what are the sources of this seed capital? This seed capital can be obtained by himself, that is self-financing, or it may be obtained from friends, families, relatives. This also we have seen. It may also be obtained from the incubator. So these are the various sources of your seed capital. So that is the very first stage, the foundation stage. After that, in order to buy the machineries, the raw materials, or make any arrangement, you require a further capital. That further capital, you directly cannot go to the venture capitalist or cannot apply for huge loans like 100 crores, 200 crores. What is the reason behind that? The reason is till now your product is not ready. So if your product is not ready, do you think can you get so much of loan? The answer is no. So in the series funding, we'll be getting 100 crores, 200 crores of loan. So before that, we have to make our product ready. So we have to be series funding ready in order to get that funding. So before that, we require the fund requirement. So first one is a seed capital is done. Now the second requirement can be availed from angel investors. We have heard about this in the previous video itself, right? Angel investors. You can also get money from HNI. So this stage is generally called as an angel investor stage or an HNI stage. HNI is nothing but high net worth individuals. So these people, even though your product is not ready, then also they'll be trusting your business because they think it has a huge scope for expansion. So they may invest, okay, but till now your product is not ready. Clear with this? Understood? After that, third stage, with the help of that money which you have obtained from angel investors or from the HNIs, you can make your product ready or make your business set up in such a way that you can very nicely influence your venture capitalists, because that is the first time you're getting to get a huge loan in the company. So the third stage, I can call it as a series funding round. You might have heard this word in the Shark Tank India also, right? They were telling, mostly they were saying, have you raised any funds? Is a series done? Series A, B. So this series is from A to Z. So how much ever time you are raising fund through series funding, okay, then it will be named like A, B, C, till Z you can do, but it's not compulsory to be done till Z. How much ever fund is required, that much you can raise, because for that you have to dilute your stake, right? You have to give investment in your equity. So first was a seed capital, second was the angel capital, and third one was a series funding. For this series funding, guys, please remember, for this series funding, you have to be series funding ready. You need to influence the people. If you influence the people, then only people are going to give you money. So how to be series funding ready, we are going to learn that. Okay. Before that, let's see what is the next stage after that. So the next stage after a series funding round, when do you call that your series funding is over? When you go for an IPO, initial public offer. So when we go for an IPO, it is end of the series round. Now we no longer require money of a venture capitalist because people know our product, people know our business, and they are ready to invest in the company. So we are going for the listing. We have seen so many IPOs, ATM IPO, right? Vedant Fashions IPO, so many IPO, even Nika IPO was there, right? So why people first set up business and then only go for IPO? Because I'll be investing only those companies where I will have trust. So if I don't have trust, then people will not invest. So first they create a base, after that then they go to the IPO. So when you go for an IPO, this was the last round of your series. Now you no longer require a series funding round because you have obtained or raised money through the public at large. So this is a general stages of funding. So first was a seed capital, second angel investor or HNI round, third series funding round, and the fourth one was a IPO, initial public offer. Now let's learn from our notes what is a series funding. As I told you, series funding is done from A to Z. So from series A to series Z it shall continue. In this series, preferred stock is a preference. As I told you, venture capitalists mostly would like to take convertible preference shares or convertible debenture, which shall eventually be converted into equity when company goes for IPO. This is how they protect their stake. Okay, so convertible is always preferred, which will be converted in case of an IPO or sale of a company. After that, generally they raise around $2 million to $10 million, and in this series mostly they purchase around 10 to 30% of the company. So this much stake the promoters or the other investors have to dilute in order to take the series funding route. And mostly they capitalize their amount for 6 months to 2 years. So 6 months to 2 years they will put their money in the company. It is not for the trading purpose, but it is because they want to earn out of that. So minimum month 6 months to 2 years. Now what are the sources of the capital? See, when your company is not a listed company, so we don't have any of the exchanges for the series round or angel capital or HNI round. So for that, the other way of funding is somewhere around called as a crowdfunding. Okay. In crowdfunding, what happens is any of the entrepreneur shall display his business idea on the portal, on his website, and whoever is interested in that idea, people can contribute and subscribe to the equity share. So this is one of the way by which an investor and entrepreneur can meet, because there are no other exchanges where entrepreneurs and investors can meet. Okay, so equity crowdfunding is established. Startups are very much increasing. Okay, so in this we are going to use an online platform, and all this crowdfunding they are from the USA. Okay, Seeders in UK, VC Circle, Private Circle, Let's Venture, and Tracken Labs, these are in India. Basically it has a mix of angel investors, strategic investors, and the customers. So now let's go to our series funding round. Basically we are going to learn how to start a series funding or how to be a series funding ready. Seed capital and all I have taught you. Now directly we are going to start with the first step. We have to be a series funding ready. How to be a series funding ready? Entrepreneur should have most of the factors set before he is going for series funding. So what is that factors he need to set? Very importantly, he should have promising unit of economy. At least the factory model or the skeleton should be ready. He should have revenue. He should be generating revenue because none of the venture capital is interested in putting money in the loss or the pre-revenue model. They don't like the pre-revenue model, but we always look out for the post-revenue model. Then there has to be a business model ready, systems which provide support to the business that should be efficient enough for scaling the business. Then your product should be marketable or it should be fit for the market. What is your customer acquisition strategy when that should be sound enough? And your success, have you tried your strategy? Are you having success in it? Then quality of your team. Even though your business is best, but if your team is not best, who is going to execute that? So quality of team is very, very important. So all these are the key factors which will determine whether your series funding ready or not. If you miss out on any of these factors, still you are not ready with the series funding, first go for the angel investor funding and then do the series funding. Because for series funding, you will have to prove yourself. Okay. After that, whenever you are doing any of the series round, you have to start really early. Like you will have to launch a product or start your production in somewhere around January. You cannot start that from the December. You cannot start 1 month before. You have to start at least 7 to 8 months prior. So when you want funds, you have to start searching from 7 to 8 months. Like this is the same if you can relate with your marriage. If there is a person who wants to get married and he has thought that I will get married by 30. So will he start searching at the age of 30? No, because he knows that he is going to take at least 6 months, 1 year, 2 years depending upon his choice. Yes or no? And the other factor is also there, right? The girls would also like that person. So because of that, when he wants to get married at 30, he will at least try to search by 27. So that everything is fixed till 30 he gets married, right? That is called as you have to start very early. So whenever we want to start our series funding round, you have to start searching your venture capitalist very early. Whom we have to search? The investor, the venture capitalist, the strategic investor. Do you think they are standing in a queue for investing in a company? The answer is no. You have to prove yourself. So you are only not choosing your strategic investor or the venture capitalist, but the other person will like you, then only he will invest. Understood? So you have to start very, very early. If you start early, what is an advantage? You will get to see more and more options. If you start late, you will have to compromise on that. So it's very much important to start early. Then also you have to fix your deal in two parts. Pre-term sheet work is there, post-term sheet work is there. That is going to take a lot of time, and if you don't have time, it will lead to desperation and you will end up in compromising, nothing else. And if the series A round goes wrong, no, if you don't stick to your terms and condition, all other round will go wrong. So all other rounds are dependent upon your series A round, so you have to be very sure you do that perfect. After that, the third one is leveraging your network. Have you seen a grapevine? How does if one grape is not good, it is spoiled, it also spoils the other grapes. The same like the information. If I have started a business, I tell my friends are going to tell their friends are going to tell their friends, their family. This is how your network grows. This is called as a leveraging of network. Mouth to mouth publicity is the best thing which anybody can do, because if I have used your products, I know that product and I'll tell 10 people to use your product. If I don't like your product, the vice versa also happens. But this is called as leveraging your network. So we have to keep our network expanding. Whoever has a good group of people around them, they will grow. Whoever likes to stay alone, he'll be alone forever. That's why we have to reach out to our extended network and we have to request them, please reach out to our connection and please tell everybody. Okay, spreading word of your business through your network is going to be very, very helpful. After that, the next one, practicing your pitch. Pitch means what? The speech or the way of speaking. The way of speaking is called as a pitch. Okay, so how you pitch, that is going to have impact on your business. If your business is very good but you don't know how to present it, are your venture capitalist going to understand what you want to do? The answer is no. So you have to keep a best pitch. Now just try to relate with the help of live example. Say for example, you have cleared your finals or your intern, now you are eligible to do training, right? Now you have shortlisted some 5 companies, like Tata is the topmost, you right? Then Reliance is there, then Hyundai, then we have GM Financials, okay, and the last one we have Bajaj Finance. So this is your priority list. If you get an opportunity, you'll go in Tata first, then Reliance, then Hyundai, then JM Financials and Bajaj Finance. Now, luckily, you get interview call from all of this. Okay, so now we are very excited. Okay, but what do you think? Which one you will go first? Will you go in Tata first? You should not go in Tata first. Why? Because you have to practice your pitch. You should have experience of an interview. So same like that, whenever any entrepreneurs want to meet the number of venture capitalists, he have to shortlist that. After shortlisting the number of venture capitalists, he has to check which one he likes the most. And the one he likes the most, he has to approach them at last. So Bajaj Finance will go first. After that will approach JM Financial, then Hyundai, then Reliance, and the last one is Tata. So by the time you go to Tata, okay, your interview will be outstanding. Why? Because you have experience of interview. So what did you do? You have practiced your pitch. You have understood what kind of question comes and what you have to answer. I hope you understood this. So very important, we have to meet the low priority investors on your list first. This will give you an good feedback on what you are, how you are, and you can make the changes accordingly in your pitch also, in your business idea also. Suppose if you meet Tata first as an investor, and if he rejects that, you're going to lose the most loved one, right? So it's always better to practice your pitch first before meeting your first preferred venture capitalist. So you have to treat your pitch as a product. You have to reiterate it again till the time it is great or the perfect. So pitch will make a lot of difference. After that, we have to create a fundraise momentum. It's not enough if you meet 3 to 4 investors or venture capitalists. You have to meet as many as venture capitalists as possible. You never know who will give you the best deal. If you don't create the fundraising momentum, what will happen? You will have very, very limited option. Because of that, you have to accept or approve any one deal out of that. But if you meet lot of people, lot of venture capitalists, go on talking with them, make them influence, let them come down to your terms and condition. If that happens, that is the most important thing, right? So approaching multiple venture fund at the same time is a good idea to get competitive dynamic process. Also, if you tell that we are having a talk with other venture capitalists also, they may try to come down to your terms and condition. They may agree what you say. So that's best. Okay, it is the best thing that you have approach to so many venture capitalists. Then nothing accelerates the process and you landing up a term sheet from when venture capitalists are likely to get more. So if you get one term sheet, don't be happy. You have to have talk with others also till the time you get the best deal. That means you have to create a fundraising momentum. After that, you should know what is the standard market practice. If you don't know what is the standard market practice, it would be very difficult for you to ascertain what is the best for you and what is not best for you. Even sometimes people can cheat you and go away. So it's always better to know what is a standard market practice. And it's also one of the best, you know, fight. Why best one? Because if you don't like any of the deal, you can say that it is not as per the market practice. So best, you know, answer you can give. So it is highly possible that first version of your term sheet you receive is not exactly as a founder friendly. It will not be same like you want, right? So the strongest line of defense is most accepted rationale for negotiating is it is not a standard market practice. After that, you should get deal terms very right. As I have told you that you can do various series of funding and all other series of funding round, that is your B, C, D, E, that will be dependent on A round. So if you get your A round very perfect, same like that you will have other rounds. If you have compromised in A, you have to compromise in all other rounds. If you have not compromised, you have got the best deal, you will get the best in all other rounds. So it depends on what kind of deal you are getting in A, that will decide the future of your other rounds. So foundation of all other rounds will be your series A. Okay, so you have to series A carry through future rounds. Hence, it's very important to get right the first time itself. Also, we have to engage a company secretary or a professional or a lawyer who knows about all these things, because they know when to stay firm, when to compromise. Okay. If any of the company secretary comes to you with an interview and you really don't like that deal, but company secretary says accept it, it's the best one you can get. Why? Because that person is having a experience in this dealing. Because the person has done so many rounds with so many people. So the person knows the market practice, he has experience as well. So the person can tell you what is the best, what is not best for you. Okay. So they will tell you when to be firm and when to concede. Concede means to compromise. If investor is asking something extra from you, you may give them because that's the best investor which you can have. After that, you should have paperwork in place. If your paperwork is in place, everything will be very sound. Like I have told you what are the ways of funding. First of all, the investor and the entrepreneur will have a meeting. Once they log the terms in writing, the memorandum of understanding they enter into, then your investor will always like to do a due diligence. And if the entrepreneur company is not ready with the paperwork, what will be your impression in front of the investor? Investor will think that these people are not able to keep the documentation ready. How are they going to manage my funds? So when the deal is happening, when there are discussions going on, you should have a high probability that the deal is going to be cracked, and you have to keep all the papers ready, right from the due diligence paper up to your shareholders agreement, share subscription agreement. Okay, so paperwork should be well organized, ready for the review by investor or any person appointed by them. After that, we have to raise more funds than budgeted. Suppose your budgeted fund is 50 crores. It is not required for you to raise only 50 crores, but you have to raise little 10 to 15% extra. Why? Because now we are raising fund. After 6 months, you will be putting that funds in your business, starting the production. Till that time, inflation might go on sky. So there is hike of prices for all the materials. At that point of time, can you go for another round of series? Are you only going to do series funding round or you're going to do a business? You understood? So in order to fill a gap in case of any of the emergency, it's always better to raise 10 to 15% extra than whatever is budgeted. Because the series funding round, always doing it becomes very difficult, time consuming, and it's highly distracting. It also costs you every point of time. Very clear with this? Everybody understood this? Great. So this is all for your series funding round. I hope you have understood the equity. So now our next topic is debt financing. What is the debt of the company? The debt means loan taken by the company. That is called as a debt. Till now we have seen about the equity investment. Now we are going to see about the debt investment, right? I hope you remember there are two types of financing. One is equity financing, another one is a debt financing. Now what is a debt financing? What kind of debts can be issued by the company? Company can either take loan directly or it can issue debentures or any other debt securities or any other debt securities. This can be done by your company. So when company issues debenture, whoever subscribes to that, they are giving loan to the company. So whoever subscribes to this debentures, okay, whoever subscribes to this debenture, that person will be called as what? Creditor of the company, correct? But whoever subscribes to the equity share, they are called as the owner of the company. This we have already discussed. Okay, so now debt financing, what is the effect of that on the company? There's a pressure on the company for repayment of that. So even though your business is not running good, but still you have to pay the amount at the time of maturity along with the interest. Clear with this? Understood? Yes. So now what are the options, sources of debts? We have already seen. Company can take loan from the banks or it can issue various kinds of debt instruments from to the other people. So now one kind of debt instrument is an ECB. Have you heard of this? ECB is nothing but external commercial bonds. External commercial bonds. Let's understand this. See, this is external. External means what? We are issuing to the foreign entity or any person who is there in the foreign country. So basically you are issuing the debt instruments to the foreigner and that person is giving you loan. What kind of loan he is giving you? He is giving you the commercial loan. Commercial loan means the loan which you are going to use for your business. So loan used for business. Okay, so what is basically an ECB? Let's understand this. This is our Indian startup. This Indian startup issuing ECBs. Indian startup issuing ECBs to any of the foreign entity. It can be bank, it can be individual, it can be any person. Right? So foreign startup is issuing ECBs to the foreign entity and foreign entity shall give them what? Subscribe to the ECBs and shall provide for the loan money. So at the time of maturity, it will be duty of a startup to pay them the principal amount along with the interest. But I hope you remember, can LLPs issue ECBs to the foreign entities? The answer is no. There is a prohibition, LLP cannot issue ECBs. So when any of the startup, any of the Indian entities issuing ECBs, they have to see first rules and regulations available to them. But for debt financing, ECB is also one of the option. Okay, so let's learn little in detail. So I hope you have understood what is an ECB. Indian startup issuing ECBs outside India, that is an ECB. ECB generally is a secured one. The secured ECBs are issued, so there is an always underlying asset. For that underlying asset, your trustees are appointed and all these things you will be learning in your company law. Okay. So there is an creation of charge on the asset of the company because the ECBs are secured ECBs. And these ECBs are governed by FEMA regulations. It is governed by which one? FEMA regulation. So when any party wants to issue ECB, it has to check about the FEMA regulation. So money is coming in India. So we can call it as a FDI. The answer is yes, it is called as an FDI. If you don't know, don't take tension, we are going to learn this in detail. So ECBs can be issued in two ways. First one, there is something called as an automatic route and another route is an approval route. I hope you remember this. We have seen this in chapter number 2 also. What is an automatic route? You are issuing ECB to such a foreign entity which is eligible to come for FDI without RBI approval. So this is without RBI approval. And what about the approval route? Over here, transaction cannot be done without RBI approval. So prior approval of RBI is compulsory. Clear with this? So what did we see till now? In debt financing, one of the way out to do debt financing is issuing ECBs to the foreign entity, but they have to comply with the FEMA rules and regulation. Two routes are there, automatic route and the approval route. You have to see your entity fits into which route. Clear? Understood with this? Yes, there are certain end use restrictions of ECBs. End use restrictions of your ECB. Now what are the end use restrictions? We are going to see that. Now end use restriction means what? Once maturity is done, okay, once maturity is done or whenever Indian entity accepts the ECBs, they cannot invest into particular sectors. Now where they cannot invest? First one, the amount issued or taken from by issue of ECB cannot be invested, not to be invested in the capital markets. Where they cannot invest? They cannot invest in the capital markets. Also, they cannot invest in the real estate. They cannot invest in the real estate. Also, it cannot be used for acquisition of any company in India. It cannot be used for acquisition of any company in India. These are the three end use restriction. Please remember this. End use restriction means I am an Indian entity, you are a foreign entity. I have issued ECB to you. You have given me 100 crores of loan on that. Okay. Now I say 100 crores I will pay you at the time of maturity. Okay. Now I received the money in India. Now can I invest in the real estate? No. Can I invest in the capital markets? No. Can I invest for acquisition of the company in India? No. These are the end use restriction. Clear with this? Understood? Great. Now, for the debt finance, there are two kinds of debt finance. One secured finance and another one is unsecured. This is very basic. In the secured, you have an underlying asset. Company has to create charge. Correct? But in case of an unsecured loan, no charge is created. No charge is created, hence no underlying asset. Understood? Now, forget about ECBs. You go to bank or any of the NBFCs for application of loan. So now you want loan from bank or NBFC. Will you get loan as it is? No. Are banks waiting for you? The answer is no. You have to apply. So what are the steps? How to get loan? The startup first have to make an application. First they need to make application for loan. So once bank receives application from loan or NBFC receives application for loan, what it will do? It will do evaluation, and if found correct, then bank may accept it by issuing the sanction letter. What they will issue? Bank will issue a sanction letter. That means they are ready to give you a loan. After sanction letter, are the formalities over? The answer is no. Then agreement will be entered into between the bank and the company. So agreement of loan will be executed, and if your loan is a secured loan, you have to provide with something called as an collateral security. So giving collateral security, there are various ways. You can mortgage your property. You can give your property on pledge, that is share pledge is also possible, or also hypothecation deed can be entered into. So these are the various kinds of collateral securities arrangement. So I hope you have understood the debt financing. I will make you underline certain things. In this, basically it is written what is a debt finance, what are the advantages of debt finance and disadvantages of the debt finance. So mostly of venture capital and angels we go for equity, whereas banks don't want ownership in the company because they want their investment or they want their amount to be very secured one. So they will not take the ownership, but they will give you a loan. Okay, but yes, there are very much drawbacks of that. Even if your business is running or not running, you have to pay the interest on that. Also, you have to give substantial collateral security and you have to create charge. So what are the ways, what are the formalities for loan, we have already discussed. Then we also discussed about what are the ECBs. ECB is nothing but a bank loan, buyer's credit, supplier's credit, securitized instrument which may be convertible, non-convertible partially, floating rate notes and the fixed bond. This can also be availed by your NRIs, no problem at all. So NRIs or any foreign entity funding the Indian entity. So ECBs can be assessed through two routes. It's an automatic route and an approval route wherein you will require a prior approval for the approval route. Okay, then there are certain end use restrictions. We have seen A, B and C, all three we have checked. Very importantly, we have to take care about the RBI and also the FEMA rules and regulation whenever any company is issuing the ECBs to the foreign entity. Now going to the next, credit guarantee trust fund for micro small enterprise. I hope you remember this. This we had studied in the strategic plan for the startup India. I had told you how government of India wants to help the entrepreneurs and it gives guarantee on behalf of the startups, and startups can avail a collateral free loan for up to 1 crore rupees. And for that government is funding 500 crores every year to which fund? CGT MSC Credit Guarantee Trust Fund for Micro and Small Enterprise. This trust, even though it's for micro and small enterprise, it is also helpful to the startups because startups are mostly your micro or small enterprises. So startups can get loan up to 1 crore without any collateral security. So they can avail loan from whom? Any of the scheduled bank or specified rural bank, NSIC, NEDFI, SIDB, where there is a agreement between this bank and the CGT MSC. So any bank does not have agreement with the CGT MSC, they cannot give you collateral free loan under this scheme. Clear with this? Understood? Great. So this was your debt agreement, debt funding. I hope it is clear. So let's start with the crowdfunding. So what is a crowdfunding? The meaning of this is solicitation of funds. Solicitation of funds from the public at large or from the crowd. So what is the meaning of the crowd? Crowd means it's a public at large. So this crowdfunding, it is not so famous in India, okay, because no perfect laws are made on that. It is only that SEBI had issued a consultation paper on this crowdfunding in 2014. After that, nothing is documented for this. But yes, we have seen various examples of crowdfunding which are prevalent in India. Now this crowdfunding can be of two types. One, crowdfunding can be for a non-profit organization, okay, or crowdfunding can be for a particular business. You might have seen this non-profit organization in the COVID times, okay. When you open your laptop, you go to any of the Google site, okay, there would have been a pop-up which used to tell you to contribute 10 rupees, 1 rupee, 5 rupees for the COVID patient or relating to that. Okay, so this is what is a crowdfunding. So money is taken from the public as a donation, even though the smaller amounts, but it is taken for the donation for some cause that is a non-profit. But over here, I'm not talking about a crowdfunding which is for non-profit organization. I'm talking about a crowdfunding for the business organization. So if I as an entrepreneur, I want to do a business, my company is not a listed company, but yes, I can go to the public at large because I'm a public company. Private company cannot do crowdfunding, understood, but public companies can do. So public company, if it is not a listed company, it can exhibit an idea on the website. Crowdfunding is only online mode. Okay, so you display your idea on your portal, on your website, and you tell the people to subscribe if they like your idea. Okay, so for every subscription you will give equity stake in the company. Okay, so what is a crowdfunding? For the business purpose, SEBI had issued a consultation on crowdfunding. Consultation paper on crowdfunding. Okay, this was issued in 2014. So what did SEBI said in that paper? I will highlight certain points on that. So this is how you will remember the crowdfunding. SEBI said that crowdfunding is nothing but solicitation of the funds. Now this solicitation of funds is done from multiple investors. So one investor is not there, multiple investors are there. And this is done web-based or any of the social media, but it is only online platform, it is not on the offline platform, and it is done for a specific activity or specific purpose. Specific activity or a purpose. So this is your crowdfunding. Only this much you have to remember. After 2014, SEBI did not come up with any of the provisions for the crowdfunding. But is crowdfunding legalized in India? Yes, it is legal in India. Understood? Yeah. So now going back to your notes, we have learned that what are the ways of funding. A was equity, B was debt. Now C1 is your crowdfunding. This is one of the unconventional mode of finance. Which mode is this? Unconventional mode of finance. So if question comes in the paper, write a short note on the unconventional mode of finance. Don't get confused. It is your crowdfunding only. What are the conventional mode of finance? Equity and the debt. Simple. Yes, great. And where it is written, we will just highlight unconventional mode of financing options which are now becoming popular in India. So A was equity, B was debt, C is your IPO, and D is your unconventional mode of your financing. So once A, B round are over, series funding round is over, and your company is set for the initial public offer, now your company is a public limited company, it cannot be a startup. Okay, so once it is a public limited company, it can start preparations for the IPO, because now They no longer require the funds of the venture capitalists because their business is set, so they can directly approach and raise the funds by giving equity shares to the public at large. So once they issue shares through IPO, the last round which they did for venture capitalists, it will the final round of series funding. Now no more series funding round will be there in the company. Understood? Simple. But very important, existing capital investment will make existing shareholding more valuable. See, for existing shareholders, when company is issuing shares to public at large, their shares will be diluted, stake will be diluted, but the value of the shares will be increased. So this is always a balance between the two. Also, if company wants to take investment outside India also, they want to avail the money from the foreign resident or the NRIs also, it can issue ADRs or GDRs. ADR or GDR you might have learned, it is nothing but American depository receipt to be issued if you are issuing in USA, and global depository receipt to be issued if you are issuing that in any other country except of USA. But very important, your ADR, GDR have to be listed on the stock exchange outside India. Okay. So by this you can have funding even from person resident outside India. Definitely there are certain obligations as far as your IPO is concerned. In your IPO you have to maintain a minimum contribution requirement from promoters, and promoters have lock-in period of at least 3 years subsequent to the IPO. For IPO we have to appoint various merchant banker, then we have to appoint the company secretary, compliance officers, etc., etc. Huge procedure is there. Detail of that you will be learning in your SEBI. Now going ahead, let's also learn about the incubator over here. We've already learned about the incubator. Okay, but let's finish this in this video itself. What is an incubator? Incubator is nothing but a support provided to the startups, right? I hope everybody remembers about Atal Innovation Mission. So anybody wants to be an incubator, any of the private institution, public institution, they can apply to the Niti Aayog. If approved, they will be a recognized startup, they will be a recognized incubator, and government will fund them with the money which will be for the administration of the startups, also for running the incubators. Now what is the role of the incubator? To support the startup, to help of the startup. So whenever you go to any of the incubators, be it a private, be it a public, the admission process is very rigorous. You have to pass various rounds of that. After passing various rounds, if they are satisfied, then only you will get the admission, otherwise you will not get the admission. So they take the stake for about 2 to 10%. In series round, we are giving stake from 10 to 30%. So the investment is more over there, but over here investment is not as big as your venture capital round. So in the incubator, how much will be receiving from them? An amount where we have to give at least 2 to 10% of equity of our company. So they may help us as far as office space is concerned, or any of the administrative support, or any of the legal compliances, management training, mentoring, or access to industry expert, etc. They can also help you in getting funds from the venture capitalist. Now there are also government supported institutes like IIMs, IITs, technical institute, private business incubators. This all can be a recognized incubator if they apply to the Niti Aayog. Now for how many period they will be investing in our company? They will be investing for around 2 to 3 years in our company, and the admissions are rigorous. There are certain examples of the incubators which you have to remember. There is IIM Bangalore, NSRCEL, Microsoft Accelerator, then we have IIT Kanpur, SIIC, and Sriram College of Commerce. So this was all about your unconventional mode, incubators and IPOs. I hope you understood. Now we are at the last topic of chapter number 9. I know this was little lengthy chapter, but it's not so difficult chapter. So now we are going to start with the Mudra banks. Now what is a Mudra bank? The name suggests it is a bank, Mudra bank. But have anybody seen Mudra bank around? The answer is no. Because Mudra, it is not a bank. It is not a bank, but it is one kind of a refinancing scheme. What is that? It's a refinancing scheme of a government. So basically Mudra is not a bank, but it's a scheme of our government of India. So this scheme was announced on 8th of April 2015 under Pradhan Mantri Mudra Yojana. Okay, this scheme helps the small artisans, small vegetable vendors, fruit vendors, and it gives loan to them. So it is basically for small businessmen who can take loan under Mudra, and this will be only and only business loan. They cannot take loan for their personal use. That is for education, medical, no, only and only business loan. Only and only to the small traders, only and only to the new traders. Okay, so what are this scheme about and what are the different condition under this scheme? Let's start with that. So what is the full form of this? It's a micro units development and refinance agency bank. We can call it as a bank, but it's basically not a bank. It's just a refinancing scheme of a government. It's a public sector financial institution in India. It provides loan at low rates to microfinance institution and NBFCs which provide credit to the MSME. That's why I told you it's a refinance scheme. So Mudra will be giving loans at a cheaper rates to the banks or NBFCs, and in return NBFCs and bank will be giving cheaper rates loan to whom? To the customers or the MSMEs. Now this scheme was announced on 8th of April 2013. Now why this scheme was announced? Because in a survey it was seen that only 4% of the businesses in India get the finance or the loan, and the requirement is high. Requirement is that of 5.77 crore. Out of that only 4% of people get loan under this. So they, in order to encourage the business and the entrepreneurs, this scheme was announced. But over here, the scheme is only eligible to a non-defaulting client. So if any client is defaulting, he has not paid any of the previous loan, Mudra loan will not be available to them. Okay. So who are eligible borrowers under Mudra bank? Only 4 people. Please remember this by heart. First, people who are dealing in small manufacturing units. Manufacturing unit is also covered, but it should be small and not on the large scale. Shopkeepers, okay, fruit and vegetable vendors, and your artisans. Artisans may be skilled, unskilled does not matter, but to make goods and services with their own hand, like handicrafts and all, those are the artisans. So loan can be taken by these 4 people because they are very, very small traders. Also, the other eligibility criteria says that the person has to be of 18 years of age, and it is the scheme under Pradhan Mantri Mudra Bank loan, available only and only for the commercial business purpose, so nobody can take it as a personal loan. Okay, now listen to me. If I want to purchase a motorbike for my own use, can I apply for the Mudra loan? Answer is no. But if I want to purchase a bike which is to be used for my business, can I purchase that by applying for Mudra loan? Answer is yes. So you can purchase a vehicle for the commercial purpose, it will be covered. But vehicle for the personal purpose is not covered under Mudra. It is for new businesses and small businesses only. Now there are 3 categories in this. So depending upon the category of loan or how much loan you are taking, you will be a particular client. So first is a Shishu. Shishu means very small businessman who takes loan up to 50,000 rupees. Or Kishore, who takes loan up to 5 lakh rupees and Tarun who takes loan up to 10 lakh. So maximum loan available under Mudra scheme is 10 lakh. It cannot be more than 10 lakh. So now you can understand how small these traders would be. Now what is the procedure to take a loan under Mudra? As I told you, Mudra is not any particular bank. It's a scheme. So how it happens? Government of India, they have announced a scheme called as Mudra. So there is a website of a Mudra. Okay. Now on this website of Mudra, various banks are listed. Various banks are named or the list of banks is given. Now whichever bank is nearest to your place, you can approach that bank and ask for Mudra loan. Understood? So Mudra is not a bank, but various bank arrangement is done where you can take the Mudra loan. Example SBI. SBI you get a Mudra loan. So if SBI nearest branch I shall approach, I shall ask for a Mudra loan in that. So in order to avail the loan under this, we have to contact nearest public sector or a private sector bank and apply loan under PMMY. There is a portal available of a Mudra. Now application form will be there. You have to submit the application form, and along with that entrepreneur has to attach various documents. Now what all documents are required? First, proof of ID, that is ID proof. Then residence proof, generally it's a utility bill. Utility bill should not be older than 2 months. Then applicant's recent photograph is required. This photograph should not be older than 6 months. Then quotation of machinery or any purchases, whatever you are doing, that means reason why you are taking loan, that you need to attach. Then from whom you are purchasing the machinery or the raw materials, you have to name them also. Also you have to give the registered address and the ID proof and address proof of your business. And last one, if you are from any caste, SC, ST, then you have to submit the caste certificate. So this all documents you will be submitting to the bank. So after that, bank will start the verification. For doing the verification, bank cannot ask for application fees. Generally, loans have application cost, but for Mudra, there is zero verification or application fees. So bank cannot ask for any of the processing fees or the application fees. Also, Mudra loan is a collateral free loan. Okay, so it cannot ask for the collateral security also. Now the repayment, maximum time of repayment is up to 5 years. But applicant should not be a defaulting applicant. If he is a defaulting applicant, he cannot be given a loan. Please remember this. We have understood that Mudra is not a bank, but it is a refinancing scheme. So Mudra will be financing your micro institutions will be financing your banks. Ultimately, banks will be financing to whom? The ultimate micro and small enterprises. So Mudra delivery channel is NBFC or MFIs, that is micro financial institution. Over there they can change their interest rate also. Generally it cannot be less than the RBI rate of interest. Now why the loan under Mudra will be taken? It can be for variety of purpose, but it has to be for income generation and the employment creation. So basically Mudra loan is taken by business loan for vendors like shopkeeper or service sector, that is okay, but loan has to be the business loan only. It can be for the working capital loan also. For working capital loan, very interestingly, there is a concept of a Mudra card. So Mudra card is nothing but similar to a debit card. Okay, so when you will take a loan, you will get a card, Mudra card, in that suppose you have taken loan of 1 lakh rupees. So wherever you will require, like you are purchasing machinery, you can swipe the card over there. So till the time your 1 lakh rupees is there, you can swipe as many as times. So in this, the advantage is you don't have to pay interest entire amount, but you have to pay interest on as many amount as used. So initially if you are using only 20,000, you have to pay interest on the 20,000. After that you have again withdrawn 30,000. So now you have to pay interest on the 50,000 rupees. So this is the advantage of a Mudra card. After that, they also provide for the equipment finance for purchase of machinery, but for the small units only, and also for transport vehicles, but it is only for the commercial purpose. So if you are using the vehicles for the commercial purpose, you can take loan from the Mudra, no problem at all. After that, they also provide loan for agriculture allied activities or for the farming activities. Earlier they did not give loan for this, but now they are also giving loan for the agri allied activities. Also they can purchase tractor, tiller, two-wheelers from this loan. Now there are certain illustrative list. Where do we get this Mudra? We have already seen for what purpose Mudra loan can be taken. So from Mudra loan we can purchase a transport vehicle. Transport vehicle can be anything. It is for transferring goods or materials from one place to another, or transportation of passenger from one place to another. From that we can purchase a auto rickshaw or small goods transport, three-wheeler, even two-wheeler can be purchased, or tractor, tiller, trolley, power tiller. All this can be purchased, but it has to be for the commercial purpose only, not for the personal purpose. After that, if anybody is opening any of the community or the social service, that is you want to be a community helper like salon, spa or parlor, gymnasium, boutique, gym, tailoring shop, DTP entry, repair shop, any of the shop, those are the small vendors, you can take Mudra loan for that. If anybody is doing food related sector or business, then they can take a Mudra loan for papad making, achar making, jam, jelly, agriculture produce, rural level, sweet shop, small service stall, etc. But very small level, not for the big manufacturing units. Anybody who is in the textile product can also take a Mudra loan for handloom, powerloom, khadi, chicken work, zari, zardori, embroidery, handwork, n number of works. So you are dealing in the products, you can take a loan. Business loan can be taken by traders and shopkeeper, but the maximum loan which can be taken by them cannot be exceeding 10 lakh rupees. Even the machineries can be purchased by this Mudra loan, but maximum loan cannot be exceeding 10 lakh rupees. So please remember the category of the client and how much loan can be taken by them. Also, allied activities of agriculture is done like pisciculture, horticulture, then poultry farming, livestock rearing, grading, sorting, aggregation, agri clinics. Also you have irrigation facilities, all other promoting facilities. Earlier this loan was not available, but in 16-17 they have changed, and now they are eligible to take loan under this agriculture activities, but maximum loan cannot be exceeding 10 lakhs. The last part, we are having a Mudra card. As I told you earlier, it is same like your debit card. Okay, but it is only available for the working capital. Only for the working capital portion of the loan. It is not for the seed capital or the fixed capital. Okay, so what is the benefit of this? The person will have to pay interest on only that much amount which he has used. He may not use the entire amount in one go, right? So borrower can make use of Mudra card for multiple withdrawals and credit, no problem at all. Okay, it is very cost efficient, and interest of burden is also minimum. Got it? And where can you use this? Mudra card is a total digital transaction. You can withdraw money, you can tap it anywhere, no problem at all. So you have seen the point of sale machine, right? Just it looks like a pager. You have to tap the card and your money gets debited from your account. Okay, so in that case you can use the Mudra card at any ATM, micro ATM or any of the point of sale machine. This was your Mudra. We have finished this chapter with this Mudra. So I hope you have understood your chapter number 9. I know it was not that easy because many new things we have learned in this. Okay, so please go through chapter one more time and you will understand it second time. Now we are going to start with the chapter number 9 question answers. Okay, I hope you have understood chapter number 9. I understand it was little lengthy but very important from our exam point of view. Also we have learned so many new things. So first one, Miss Ananya is a young entrepreneur, wishes to start her own startup in the field of software and information technology. Advise Miss Ananya regarding benefits that startup can enjoy. So what is your question? Benefits enjoyed by the startup. So many benefits we have discussed, 9 to 10. If this question comes for 5 marks, write 6 points. Okay. If it comes for 4 marks, write 5 points. That is okay. Understood? Next one. Logistic Private Limited, a startup, received amount of 25 lakhs in a single tranche from investor by way of note, which is convertible into equity shares. Okay, after 3 years. Understood? So this is a single tranche. Okay. Are we going to consider this as a deposit? The answer is no. CFO of company was of view that said amount is not a deposit. In light of statutory provision, explain whether the view of CEO is correct or not. What we have to write? We have to write the exemption of a startup. That is the exemptions of deposit available to startup. And what will be your answer? Whatever CFO is saying is correct. Okay. Then the next one. What is a Mudra Bank? Straightforward. Next, Niket incorporated a private limited in 2016 for carrying on business of supplying flowers to various event managers in and around Mumbai. He wants his entity to be recognized as a startup. Advise the process to be followed by him for recognition as a startup. So you have to just give what is the process to be followed. Filing a form with DPIIT, all the entire process we have to give it to him. Understood? Clear with this? Great. Now, next question. These are the solved ones. ABC Private Limited received a amount of single tranche 25 lakh rupees. So this we have already seen in the question. This is a solved answer for you. What do you have to write? Yes, the view of CFO is correct. As per provisions of companies, acceptance of deposit rules 2014, amount of 25 lakh or more received by a startup by way of convertible note convertible into equity within 10 years of issue shall not be treated as a deposit. Understood? So whatever CEO is saying, his view is correct. Next, Pawan incorporated a private limited company in 2016. The same setup is there? Yes. So, advise the process to be followed by him for recognition as a startup. So, what all things we are going to write? Up to 10 years of incorporation, he can be startup. He has to be private limited, registered partnership or an LLP, right? Turnover cannot be exceeding 100 crores. An entity should be working for the innovation, right? So what is the process? You have to just file online application with the DPIIT on Startup India portal, and if DPIIT is happy, it shall give you a certificate, that is a recognition as a startup. Then you can start availing the various exemptions available to you. So I hope you understood how to write questions. So till now we have seen that in chapter number 2 and 3 only you get technical question, that is case laws. In all other chapters, straightforward questions are asked. Now start with chapter number 10. Yes, we are at chapter number 10 now. Almost we are going to complete our part 8. Okay, so in next 2 to 3 sessions, we'll be completing our part A because only 12 chapters are there into part A. So I understand that part A is little bit lengthy, but believe me, it's not so boring, it's very interesting. Also the weightage is 40 marks. So let's discuss about chapter number 10. Chapter number 10 consists of business collaborations, joint venture and special purpose vehicle. So these three things we are going to learn over here. Basically we are going to learn what is a business collaborations, what is a joint venture, and what is a special purpose vehicle. So these three things we are going to learn in detail about the advantages, disadvantages of each of them, who enters into all these three combinations, that is joint venture, special purpose vehicle, and why do they enter into. So we are going to see the reason also for that. Weightage about this chapter, it is for 5 marks. So in exam you may expect a question from this chapter. Yes, they definitely ask one question from this chapter, and it's a straightforward question. Unlike your chapter 2, chapter 3, chapter 4, 5, they don't ask case study in this because there is no scope of case study in this. Okay, so in this particular chapter you can do the fakeology, guys. You understand what is a fakeology? Fakeology means just understand the concept and write your answer in your language. So without wasting any time, let's begin. So as I told you, the name of this chapter is business collaborations. We will just write the weightage. It is for the 5 marks. The weightage of this chapter is 5 marks. Now let us understand what is a business collaboration. Collaboration means what? Combining or coming together. So any of the businesses, okay, any of the business houses, let us write this. Any of the business houses coming together, okay, any of the business houses coming together for specific purpose, for specific purpose. This is called as a business collaboration. So by this we have understood that business collaboration needs two minimum business houses. So there cannot be collaboration by a single individual. If I am a big business house, say for example I am Vandita Doshi Limited, can I do collaboration with myself? The answer is no. I can't do collaboration with myself. So for business collaboration, at least two business houses are required. After that, they should be coming together for a particular purpose. If they don't have any particular purpose, then why will they come together? So business houses should come together for a particular purpose. You can see various joint venture, collaborations. Why? In order to meet certain criteria. So what is basically a business collaboration? Let us understand this. Business collaboration. Basically, business collaboration means two groups, two business groups, they come together, okay, they work together for a specific purpose, for a specific purpose by pooling their resources. What they are doing? Pooling their resources. If I want to give you an example, we have a Reliance, okay, and Big Bazaar. Reliance and a Big Bazaar. These are the two business groups, correct? Two business houses. Now Reliance want to enter into a retail business. Till now Reliance has done various business, right? So now Reliance want to enter into a retail business. So what he decides, instead of going to this business alone, let's take someone together who already has experience with this. So what Reliance is thinking, instead of going alone in this business, instead of taking entire risk myself, if I take someone who has experience in this field, That would be awesome. That's great. That's what the Tatas did, right? Whenever Tata wanted to enter into the insurance sector, it had collaborated with someone called as AIG, which was already in the business of insurance, right? So together they came with the product of Tata AIG Insurance. I hope you understood. So when Tata wanted to enter into the insurance business, it did not go alone, but it entered into the insurance sector by taking AIG along with that. So AIG was already in the insurance business. They came together, they collaborated with each other, and they gave a product called as a Tata AIG. Same way, in order to reduce the risk, what is Reliance doing? Reliance is doing a joint venture or a business collaboration. So Reliance is coming with Big Bazaar. Now they are forming a company, they are forming a partnership. That is not relevant right now. But what these two business houses are doing, Reliance and a Big Bazaar, they are coming together in order to serve a particular purpose. So Reliance is coming, Big Bazaar is coming for Reliance Retail. Okay. So Reliance is giving its name. What is Reliance giving? Its name. Along with that, it is also going to contribute a capital, and in return, what Reliance is going to get? The stake in the Reliance Retail, right? What about the Big Bazaar? What Big Bazaar is going to do? It is going to pool the resources of expertise. Okay, it also has a market. And what Reliance Retail will give in return? The stake in Reliance Retail. So both of this entity shall have their respective stake in the Reliance Retail. This is nothing but called as a business collaboration. What is this? This is a business collaboration. So when two business groups, they come together in order to fulfill one particular purpose for a specific purpose, by pooling their resources together with their own terms and conditions, are called as a business collaboration. Now I hope everybody has understood what is a business collaboration. Business collaboration is a wider term. Okay, business collaboration is a wider term, and joint venture, special purpose vehicle, you have your holding company, subsidiary company, these all are the concepts inside it. So when you enter into a business collaboration, it can be by making it subsidiary, understood? It can be by making a partnership, it can be by making a joint venture also. So business collaboration is a wider term in compared to this joint venture and all. So I hope all of you have understood what is a business collaboration. So now let's begin about the business collaboration. Collaboration means what? When two or more entities work together, okay, when two or more entities work together through idea and thinking to accomplish a common goal is called as a business collaboration. Okay. So collaboration provides with various advantages like solution, strong sense of purpose, reinforce the objective by coming together. So what are the different kinds of business collaborations? First type of business collaboration is a horizontal collaboration. Horizontal, we know vertical and horizontal. Vertical means straight, horizontal is a sleeping line. So horizontal collaboration means what? If Taj and other small hotels like Ramada, Taj want to capture more market, it want to reduce the competition, you want to be very strong in the hotel markets. So Taj collaborated with small hotels like Ramada, etc., etc. So what it is trying to do? It is doing a business collaboration, right? But in its own field. Okay, it is doing business collaboration in its own field. So when any business group enters into in business collaboration in then entity which is doing a similar kind of a business, it's called as a horizontal business collaboration. Now why will someone do horizontal business collaboration? In order to reduce the competition in the market, in order to gain the more market. Okay, so when businesses in the same set of functional area agree to collaborate in a way to improve their competencies is called as an horizontal collaboration. I hope it is very clear. Now the second kind of collaboration comes is a vertical collaboration. Which is the second kind of a collaboration? It's a vertical collaboration. Now what is a vertical collaboration? Standing line. So sleeping line means what? The business group having same business, right? The object of the business are the same. So it's a horizontal. Vertical means, do you think the businesses will be the same? No. Now businesses are not same. Businesses are into the verticals. Vertical business means what? What comes first? Raw materials. Do we get raw materials from the sky? Does it come from the sky? No. It is manufactured somewhere. It is grown somewhere. Right? So right from the farmers, then the manufacturer, that is the supplier comes, then manufacturer comes, then marketing comes, then ultimately the consumer comes. Just imagine a Taj hotel. Taj hotel requires 100 of AC for its room. Do you think they are manufacturing themselves? No. So when they collaborate with one of the chain, upward chain or the downward chain, it is called as an vertical collaboration. I'll repeat one more time. Wherever any of the business houses collaborate in its chain, in upper chain or a lower chain, it is called as a vertical collaboration. So basically these people will not be into the same field. In order to reduce the cost, what they will do, they will enter into such combinations. So vertical collaboration is collaboration wherein business collaborates with the company in its supply chain, either up or either down. So means the suppliers or with the distributors. So it allows to minimize the risk in the supply chain and obtain the products at the lower price. So as I told, in order to reduce the cost, business houses does this kind of an arrangement. Now the next one is intersectional collaboration. Now what is intersectional? We saw what is horizontal in the same business, vertical in the supply chain, upward or a downward. Intersectional means what? A business house like Tata, it had a very different business culture, right? The main object of Tata's, they are in motors. When they decide to enter into a insurance business, so motors, that means the main group, the main object was about the motors or the power. But when they try to enter into the insurance by merging with the AIG, is called as an intersectional collaboration. So when any of the business group which is not in your supply chain, but still you are going to enter into collaboration with them, will be called as an intersectional collaboration. I'll repeat one more time. When any of the business group is not in your supply chain, but still you are entering into collaboration with them, is called as an intersectional collaboration. Like recently, Tata acquired Air India. But do you think it is in their supply chain? The answer is no. So it is an intersectional collaboration. So when businesses from different functional areas agree to share their special knowledge for advancement of all the partners, is called as an intersectional collaboration. I hope you have understood these three collaborations. Now let's go to the fourth one. Fourth one talks about the joint venture. I have explained you the business collaboration on the same lines the joint venture is there. So what is basically a joint venture? Joint venture, we require at least two parties. Okay, so in joint venture at least we require two parties. These two parties shall come together for a specific purpose. So parties shall come together for a specific purpose and they will be pooling their resources. Okay, like I had given you an example of a Reliance and a Big Bazaar. Both of the parties pooling their resources together because they want to enter into a new business. So that is a retail business. So two parties coming together for a specific purpose by pooling their resources is called as a joint venture. So now let's see the definition. Two or more business houses form a new company. See, joint venture will be learning in detail, but when we talk about a joint venture, there are two kinds of joint venture in this. How many kinds of joint ventures are there? Two kinds of joint venture. One is a equity joint venture. In equity joint venture, we are going to form a new company. Okay, so in equity joint venture, we are forming a new company. Other joint venture is a contractual joint venture. In the contractual joint venture, we are not entering into any new company, but the best example of contractual joint venture is a franchisee. If you did not understand, that is okay. We are going to discuss this in detail. But I hope you have understood what is a joint venture. Two or more parties coming together, pooling their resources together for a specific purpose is called as a joint venture. And the next one is equity. Equity, when we hear the word, we can always think about a company, right? Yes. So company has a different and distinct legal entity apart from its business group. So if Reliance and Big Bazaar come together, they form Reliance Retail Private Limited. So this Reliance Retail Private Limited is held by Reliance as well as the Big Bazaar, but it has its own identity. So apart from its Reliance and the Big Bazaar, which are the co-founders, it has its own identity separate from its parent company. So this is the beauty of equity joint venture. So in this type of a collaboration that they come together, they do the decision making together, they hold some stake in the company. This is how it happens. So these were the 5 types of business collaboration, and this was your business collaboration. I hope you have understood, and by now you have realized that this is a theory kind of a chapter. You will find very less technical things in this. Okay, so you'll enjoy this chapter. So now let's start with a joint venture concept. So what is a joint venture? Let's revise one more time. You can repeat with me. Basically, joint venture is a collaboration of two business houses together for certain specific purpose by pooling of their resources together. Okay, so this is a joint venture. I had given you examples of Tata AIG, Reliance and Big Bazaar collaboration. So these are the few collaboration. Also Coca-Cola and Pepsi, even they have come together. So even that is a joint venture. Okay, so now let's go to our theory part. If question comes in your exam, what is a joint venture? We cannot write only 2 to 3 sentences, right? So we have to understand and what things we need to write. What you can do is you can underline important points with me. So what is a joint venture? The definition we are going to read. It is an enterprise in which two or more investors, they share the ownership. Okay, as I told you, two or more enterprises, that is business houses, they will share the ownership. As they have given their resources, definitely they will be taking stake, right? So they will be sharing the ownership and control over property rights and the operations. So the reason for joint venture can be specific project, that is one particular project, or they may decide to have a continuing relationship with each other. So it can be for one particular purpose or it can be a continuing joint venture. Both of things can be complied. But entering into joint venture is a very crucial decision because you have to choose your partner appropriately. If your partner is not correct, that is going to hamper your business and at the end your funds. So how to select a partner, what are the important points we have to take into consideration, we are going to learn this chapter. But let's first finish off with the concept of a joint venture. So any size business, they can come together in order to strengthen their long term relationships. They can collaborate with each other for long term project, or also they can collaborate with each other for the short term projects. Now how do they collaborate with each other? Can they come empty handed? The answer is no, they cannot come empty handed, but two or more individuals or the business entities, they combine and pool their resources together. Resources, I mean the expertise each one of them have. Financial resources, very important, we call it as a lifeblood of the business. The skills which each and every person has, the experience each and every person has, knowledge. If any particular person has done MBA in that particular field, PhD in the particular field, that is going to add a value of a particular project or an undertaking. So the organization they form together is called as a JV, okay, and it can be formed by whom? It can be individuals. But remember, a single individual cannot form JV. We require at least two individuals to form a JV. So individuals can form, or any of the business entities can come together, or your corporations can come together, even your partnerships can come together and form a joint venture. In joint venture, it is not necessary that only companies will be there. No, even partnership can be formed as a joint venture. Franchisee can be taken as a joint venture. Now you will say, why ma'am you are talking about the franchisee? Say for example, I am very much fond of a McDonald's and I have enough of capital. So I want to start a McDonald branch. So I need to take permission, I need to take a franchisee. So the McDonald owner and I will have a meeting together and I'll propose them that in this particular area I want to open a franchisee. He will give me his rights. Okay, so this is a joint venture entered into Vandita Doshi and the McDonald's. Is McDonald really contributing in my business? No, it has just lended me its name McDonald and also other few resources. And he has given me franchisee, for that I will be paying them royalty, along with that few sales percentage. That is a decide ratio. Even this is one of the form of a joint venture. So I was talking about there are two forms of joint venture, equity and a contractual. The best example of a contractual joint venture is your franchisee. Now moving ahead, now contributions to joint venture can be in any form. It can be money, it can be services, it can be physical assets, that is your machinery, equipments, laptops, computers, anything, or combination of all or any of them. So basically entities are coming together, pulling their resources together for a particular object. Now basically JVs are commonly formed in manufacturing, mining and the service industries. Wherever research and development is required, more and more things are coming up, the risk will be shared by the entities. So more and more they will be forming the joint ventures for that. Common joint ventures which are there in India, these are the examples of that. Indian Oil Sky Tanking Limited, this was formed, or it's a combination of Ruchi Soya and an Indian Oil IOL. Ratnagiri Gas and Power Private Limited, this is a combination or a joint venture of NTPC and GAIL India Limited. Mahanagar Gas Limited, this is combination of the BG Group, UK and GAIL India Limited. Petronet LNG Limited, this is combination of three entities, three PSUs, BPCL, GAIL, ONGC and IOCL, four entities. So these all are the examples of the joint venture which are prevalent in India. Now we are going to the next one, that is advantages of the joint venture. What are the advantages if we form a joint venture? There has to be some advantages, then only we will be forming joint venture, right? So till now I hope the concept is clear. Okay, if your concept is clear, then only go ahead with the advantages, otherwise you can watch this video one more time. Now first advantage is a risk sharing. I am telling this from the starting of the session itself. Any business entity, when it enters a new business, it will definitely want to reduce its risk, because if tomorrow anything goes wrong in the business, his entire money will be wiped off. So instead of that, if he joins hands with some other person who is already in that business, so that person have seen all the phases in that industry, so he is having equivalent experience in that, so his risk will be equally reduced. And if something happens, the first industrialist is not totally wiped off, but the equal amount of risk will be borne by two or more individuals who are coming together as a joint venture. So the biggest advantage of your joint venture is a risk sharing. After that, second advantage comes economies of scale. Whenever there is a small company, he is having an excellent product, but he is not having those manufacturing unit, giant manufacturing unit I may say, or the market where he can promote his product. Because for production also he will require huge capital, huge factory. So if he collaborates with the large entity, what will happen? Economies of scale. Large company will get the product, small company will get a entity who is helping them in promotion of its product. So any industry with fixed cost, with high fixed cost, if it merges with the large company, then what will happen? They will have economies of scale. So two companies can pool their resources together and achieve the critical mass. Then comes your market access. Anybody who is not having any experience, as I gave you example of Tata and AIG. Tata was not having an expertise in the insurance business, nor he was having any market in that. But when he collaborated, he entered into joint venture with the AIG. Not only he gained the experience, but he also gained the market access. So to know the customer or to understand the customer, it's very important. Okay, because customer psychology is very different. Why will you purchase any product? Just ask yourself. Because it is very good, it's economical, it's cheap, also it has a added value as compared to the other products. This is psychology of in customers. So every business houses understands the psychology very nicely, then only they can succeed, otherwise they cannot succeed. So understanding the customers, also infrastructure to distribute their products, and if they form a joint venture together, that joint venture will be efficient, effective and receptive customer basis. So such joint venture who understands the customer has a huge industry which can meet every customer's demand. Such industry becomes topmost industry in the market. For that, one industry will not be enough, but it has to enter into collaboration with the other one. Now when any industry want to go global, it's not so easy to go global, because global laws are there. That is the challenge. You can tell it as a hurdle or a barrier. Also, there are existing local businesses. Suppose I want to start a business in Dubai. Already local business houses are there who are providing for the same products. So why will people of Dubai purchase my product? Instead of going alone, if I collaborate with any of the Dubai business house who is ready to deal with my product, so what will advantage for me? I can go global. First of all, I can explore the global market with confidence. Along with that, the customers will also like to collaborate or deal with my products. Why? Because one of their brother, that is the resident Dubai, he is already included in my business. He is already collaborated with me. So customers will not hesitate in purchasing my product. Also, Dubai law will be very friendly with me. So if I merge with such kind of an entity, I can explore the global markets. After that, easy acquisition of other entities. This is very challenging. I'll tell you why. See, whenever suppose there are two entities A and B, A private limited and B private limited, A wants to acquire B. A wants to acquire B. So when A acquires B, all the employees of B get shifted to A, all the officers get shifted to A, their work culture, the way of behavior, everything goes shifted to A, right? So A has acquired. After acquisition, A comes to know that the way of working is very different. The officers are very different. They are not able to trust the A's officers. Officers of A, officers of B, they are not able to work together. This all disadvantages or this all problems they found out later on after the acquisition. Now tell me, when already entities are merged, is it easy to split them up again? Answer is no. It is going to cost your business, it is going to cost your time, your money, also your reputation. So always before acquisition, entities opt for entering into a joint venture. Okay, so before acquisition, entities would like to enter into joint venture. Why joint venture? Because when they enter into joint venture, both entities work together. They will come to know about each other's behavior, their nature. If found comfortable, the next step would be the acquisition. So most of the prudent, that means good business houses who really care for their resources and people, their first step before acquisition is always forming a joint venture. So if anything goes wrong, you can close the joint venture, that is not a problem. But for splitting up the merged entity is a problem. Clear with this? Understood. So JV is substantially less costly, thus less risky than complete acquisition, and is sometimes used as a first step to complete the acquisition with the JV partner. After that, joint venture is also very cost efficient, because small entities might face difficulty in setting up huge industries, huge factories. But if they get collaborated with the huge industries, then both of them will be at advantage. So, if company has planned for perfect product, but due to financial shortage there is not enough machinery or resources available. So if such company gets merged with the huge company which has all these things which first company does not have, they both can make wonders. Then the nature is also very flexible. Why it is flexible? See, I will explain you this with the help of an example. There was a joint venture between a Reliance and a Big Bazaar. Okay, this both entities had come together to start which business? Reliance retail business. So both of them are holding some percentage of stake in that. But is Reliance holding Big Bazaar? No. Reliance is doing its own business. Big Bazaar is doing its own business. So both of them are not interfering in their respective businesses. So they do their main business very nicely. This is a flexibility available. And at times they can come together for the Reliance retail and they can decide. But Big Bazaar will not be controlling Reliance, Reliance will not be controlling the Big Bazaar. The high flexibility we get in the joint venture. I hope you have understood all the advantages. Okay, so now we'll be going to the disadvantages. The first disadvantage talks about restricted flexibility. Now you will tell me, ma'am, just now we saw it as an advantage. Yes, it's definitely an advantage. But where full concentration is required for a JV project, then this becomes a disadvantage. Now what is this? Let's understand with the help of an example. Say for example, there is a joint venture, okay, joint venture formed by two entities. One is your Oberoi Sky City, another one is L&T Constructions. I'll tell you the background of this. Oberoi Sky City is a real estate company wherein it takes up the real estate projects, okay, and it buys and sells this real estate property to its customers. L&T Construction provide for the construction services. Oberoi Sky City just take up the project. They don't do construction by themselves, but they would pass on that construction work to the L&T. So there was one big project of 10 towers, 50 floors each. Okay, big project of 10 towers, 50 floors each. So Oberoi Sky City and L&T Construction thought of having a joint venture. So both of them together, they formed a joint venture in that both of them are going to deal in this construction of the towers. Now as I told you earlier, L&T Constructions provide for the construction services. What does it provide for? Construction services. So all the raw materials, you can say, all the machineries, you can say, you have so many machineries for the construction, right? All the manpower are concentrated on its joint venture project. Okay, so L&T's construction, all majority of things are in the joint venture project. But when L&T have their own projects, obviously L&T is a different entity than its joint venture. So they will have their own projects. So when there is a requirement of these machineries in their own project, will L&T be able to provide them with that? Answer is no. So when full concentration is required in the joint venture, it would be less flexible to do your own business. So entire concentration leads to inflexibility. It does not provide for the flexibility. I hope you have understood the point now, right? So where full concentration is required in the simultaneous work may become impossible. I hope it is clear. Now the second disadvantage talks about equal involvement. Where a joint venture requires equal involvement, definitely, no, when L&T and Oberoi Sky City has come together for a project, it will be expected by each and every partner that other partner gives equal involvement. But sometimes this does not happen. Suppose the promoter of Oberoi Sky City, who is also a partner in the joint venture, is not giving full concentration or required concentration to the joint venture. So there will be not trustedness. Okay. So your other partner, that is L&T Construction, he will feel bad. Why he will feel bad? Because he will say, I am giving my 50% of time, so even other partner has to give. So it is extremely unlikely that companies working together share the same involvement and the responsibility. If both the partners are responsible enough, they are joining together, giving same time and energy, that is well and good. But when any of the partner does not show this honesty, it becomes very difficult for the joint venture. After that, the cultural difference is very, very important. We are unity in diversity, right? So many different religion customs are there in India itself. Anybody who is from different culture, they have different thinking, total upbringing is different. So whenever any Indian does any collaboration with a foreign party, he is going to face lot of issues because of that. Because those people are very, very professional, but some Indians, we Indians think from our heart sometimes, right? And we keep our family, we keep our other friends and all before our business. So that is missing in the foreign entity. I just gave you one example. Other points are also there. So when there are different cultures and different management styles, there may be poor cooperation and integration, because they have different taste, different nature, different entirely very different preferences. Now going to the next, if you don't choose your partner by doing good amount of research work, your business is going to face the consequences of that. Okay, so your joint venture partner you should choose by putting lot and lot of efforts. If you have not put in the efforts, it will result to frustration, experience would be worst. You will have to lose your money, you have to lose your mindset, also you are going to lose many people in that. This is a very big problem in India. What is a big problem? Lack of clear communication. We always expect from others, but do we really tell them what we want from them? No. It is that, no, I expect he should do this much for me. So even partners do that. Even though they are doing business, sometimes miscommunication happens because they don't communicate properly. That's why in 9th chapter we have seen, whenever any deal happens, before that there is a requirement of a healthy negotiations. If healthy negotiations are missing, then what is going to happen? Frustration, dishonesty, etc. So different companies from different horizons come together, so they often lead to severe lack of communication between the partners. Then when your partners are unreliable, when you don't trust your partners, how can you let them do your business? Understood? So it is possible that partner do not devote 100% of their attention in the project, hence he becomes what? He becomes unreliable. After that, very important disadvantage is, whenever you are forming joint venture with anybody, you are creating your own competitors. Why? Because you will be telling all your strategies. You have to tell because he is your partner, right? So you will be telling all the strategies, all your secret things which you are doing for your organization. You are doing it together, that is well and good. But when the joint venture is not there, he may use that strategies for his own business. So you are making, or you are creating your own competitors. I hope you have understood what is the joint venture, what are the advantages, disadvantages of the joint venture. In the next video we are going to learn what is the strategy to enter into a JV. That means how to select your partner, what are the requirements under the joint venture. So now let's go to our next topic. As promised, we are going to learn about how to choose your JV partner, or what is the strategy to enter into a joint venture. So very important points they may ask you, that is an exam, they may ask you straightforward questions, or they may ask you little twisted in the form of a case study. Like, your friend want to enter into a joint venture, please help him with the strategies to be followed for entering into joint venture. So indirectly they are asking you the straightforward question. So very first point is identification of your prospective joint venture partner. As discussed earlier, whenever we are joining or whenever we are searching for our joint venture partner, the partner has to be very competitive with us. Can we choose a weak partner? The answer is no. We cannot choose a weak partner. We have to choose very strong partner like us. Because something which we are not having, he should be having it. Like Vandita Doshi has a very good product, but she does not have funds. She does not have market. So, can she enter into a JV with such a partner who does not have a market, neither has a fund? No, then what's the reason of a joint venture? Understood? So, your joint venture partner has to be equally competitive than you. You should have all the things wherein you are lagging. So, before choosing a partner, you have to do lot of research work. When you do research, then only you will be able to find a best partner. If you choose your partner without doing any research work, it is going to lead to a frustrating experience wherein you will lose your money, your time, your business, your mindset. Okay? So, your partner should be very strong in terms of business, in terms of technology and in terms of the resources. So he should basically would be able to complement with you. He should not be a burden, but he should be a complement with you. So when one entity is strong in economies of scale, money wise, they are fit enough. The other should be strong in marketing or the brand value. If these two entities come together, a joint venture can do wonders. So choosing a partner is very crucial job. After that, our partner should be trustworthy. We should choose such a partner who should be very trustworthy. In joint venture, you know guys, any of the business, any of the relationship depends on something called as a trust. Now what is the meaning of a trust? Trust means any kind of a feeling or any kind of a confidence in that person. So if I have a joint venture partner wherein I know that whatever happens, it's going to be standing very strong for my business. So I can rely on him. Yes, I can rely on him. On the other hand, if I don't have confidence, I don't have trust on that partner, if something happens to the business, I am going to accuse that partner. You understood? So this is a difference. So your partner should be very trustworthy, cannot be weak or untrustworthy, because that is not going to make a good joint venture. So when we have a partner very strong and trustworthy, it is going to generate enormous benefit for both of us, for partners as well as the joint venture. After that, we should develop a very strong joint venture relationship. So strong joint venture relationship starts with the trust, healthy, strong partner. When we have a trustworthy, healthy, strong partner, we have to build our joint venture relationship such a strong way that your partner relies you, you rely your partner. None of the other person, stranger, is going to create problems for you. So how to develop that? You have to maintain it, financially make it profitable. It can be intellectual, awarding, and it should be a long lasting. So how to make it very healthy? There is one way out. Very healthy negotiation can help you to make your joint venture very strong. So when your partner knows that you are going to communicate everything, people will stop assuming. So when people stop assuming, there is no lack of communication, there is no misunderstanding. I hope you understood this. After that, each of the partners should try to give equal contribution. On the basis of your role, you should be very honest in contribution towards your joint venture, be it any of the resources, be it your time, be it your money, be it anything else. So each and every partner should opt for having equal contribution in any of the field. Only and only this can lead to your healthy and strong joint venture. If it is unbalanced or if it is unequal, one partner is giving more, another partner is sleeping partner, this does not give you a healthy joint venture, but rather it can never be healthy, never be successful. After that, joint venture basically is a business. You are entering into joint venture for a business. So always we have to lock our terms and conditions. How to lock our terms and conditions? By written agreement. If you are forming a company, you can make the shareholders agreement. You can make the memorandum articles. If it is a partnership, you can make a joint venture agreement. So a written agreement is very essential for any of the businesses. So agreement between two or more parties should always be written, and it should clearly define all the terms, all the partners' rights, their responsibilities. Language of the agreement should be kept very simple. It should be unambiguous. That means it should be very clear without any ambiguity. Also very important, there should be no clashing of interest. When there is clashing of interest, The business does not happen there. It is unfair business. Then you have to limit the scope of a joint venture. I can give you very easy example for this. We had seen joint venture between a Reliance and Big Bazaar, right? So Reliance and Big Bazaar will first only will decide how much decision making power will be there in Reliance retail. Like if Reliance has 50% of the decision making power, Big Bazaar shall also have a rest 50% of power. So can Reliance take 60% of power? No. So you have to limit your work, your responsibility. Likewise, if your decision making power is 50%, your responsibility is also 50%. So everything comes to one particular percentage. This percentage need to be defined. So it is essential that limits and scope of venture should be defined in the beginning itself. Because what will happen in the later stage? Once trust is developed, the scope of joint venture can be increased with their mutual consent. Okay. After that, we should have a well-defined business model. If you have watched the show called as Shark Tank India, if you have not watched, it's available in the YouTube also. You can go through one of the episodes. It will really make you understand what is the angel investor, how do they invest, how people from the different businesses come to that, they pitch. I'm not promoting any of the shows over here, but I just, from the education purpose, I want all of you to just go and watch it. So what is a defined business model? If we have seen that Shark Tank India, all the business houses come with a very defined model. They know where they are today, in 5 years where they want to be. So their business model is well defined. How much is B2B, how much is D2C, all these terms are the business terms. So how much they will be doing directly to the customers, how much they are doing to the wholesalers. So this is what is called as a well defined business model. So your joint venture agreement should clearly define the nature of new joint venture, how they are going to propose to the customers, what are going to be the distribution channels, also about the relationship management, the value chain, the structure, the roles, the investments, income, cost, payment, each and everything which is required. Even how to take out the profits from the business, even that is to be determined, because it is also one of the way of business model. Then it should be very flexible. A joint venture has to be flexible enough. If Reliance has given you 50% decision making power, 50% time, some crucial projects comes over and it is contributing its 100% time. So don't you think so Big Bazaar has to contribute that much? Yes. This will create passion for the joint venture. Also it will create trust for each and every partner. So partner should try to be very flexible, not to be rigid. I have told I'll give 50% means I'll give only 4 hours a day. That does not give a good businessman, sense of a good businessman. Businessman needs to be very passion. Okay. Favor partners who demonstrate the same level of the flexibility. Then establishment of exit route, very important. It's very much important to have an exit route before we have an entry. If you have not mentioned how to enter into JV, that is okay. But you should mention how to exit. Because when we will exit, it's not always required that we will exit in a good note. Sometimes because of lack of communication, because of the distrust, what will happen? They will tend to end the joint venture. And if you have not written how to end the joint venture, this is a real problem, because now you don't have trust. So every time any partner initiates to end, you will feel that he is doing something bad to you. So at that point of time, deciding how to exit, where to take the disputes would be a big problem for you. Rather, you decide all of this at the entry level only. So after that, you have to just read it and just comply. That is more better, right? Yes. So this where the strategy is required to enter into a joint venture. Please remember this 8 steps very nicely, 8 points very nicely. You can create a flow chart for this or just pointers would be enough. The inner one, if you know the pointers, the inner story can be written by you. I know you are eligible for that. Okay. Now let's start with the next topic, that is formation of joint venture. I hope everybody now understands what is a joint venture. How are we going to remember? Let's revise it one time. First, two or more entities. It can be individuals, it can be business houses also. They come together for a specific purpose by pooling their resources is called as a joint venture. Now anybody who wants to form a joint venture, there are basically two kinds of joint venture. First kind is a equity joint venture and second one we have contractual joint venture. Now what is a equity joint venture? Equity joint venture means wherein a new company is formed. What is formed? New company is incorporated. So in equity joint venture, it always leads to formation of a new entity, always. So let's take an example. Same example we'll be taking. Reliance and Big Bazaar, both of them, in order to start a retail business, they incorporated a company called as Reliance Retail Private Limited. Okay, and in this company Reliance is holding 60% and Big Bazaar is holding 40%. So Reliance has given capital along with that name also, and Big Bazaar is giving expertise along with the market and manpower as well. So Reliance is holding 60% in the Reliance Retail Private Limited and Big Bazaar is holding 40% of share. This is called as an equity joint venture. Simple. In this, your Reliance Retail Private Limited has a separate entity, separate identity apart from Reliance and Big Bazaar. It can hold its own assets, it can sue in its own name, can be sued in its own name. If something happens to the Reliance Retail, is it going to affect in the Reliance or the Big Bazaar balance sheet? Answer is no, because loss is that of a Reliance Retail. I hope this is clear. Okay, so this is a equity joint venture wherein both the co-founders or more than two co-founders, they come together and they form a company in that. That is a equity joint venture. Now what is a contractual joint venture? In contractual joint venture, no new entity is formed. No new entity is formed. So in contractual joint venture, we are not going to form any entity. Rather, we are going to form a joint venture by just entering a joint venture agreement. So as the name suggests, it is only an contractual joint venture. If I want to give you an example of this, franchisee is a best example of contractual joint venture. I had explained you about the franchisee by giving McDonald example. So franchisee is taken from any company which is very famous, okay, which has a huge market. So in order to gain because of huge market, what small business houses do, they take the franchisee of the big products. Because of that, they can gain the market also, they can earn out of it, and big business houses who is giving the franchisee, they will have a huge strong base in the market because everybody will be taking their own products, right? So these are the two joint ventures, two kind of the joint venture. One was equity, another one was contractual. So now let's read them in detail. So as we saw earlier, two kinds of joint ventures are there, equity joint venture and contractual. The main line of difference between the two is, in equity always a new entity is formed, and in contractual joint venture new entity is not formed, okay, but they enter into joint venture by the help of a joint venture agreement. Now let's first see what is an equity joint venture. In this, a separate legal entity is created by two or more entities. So two or more entities, with the help of an agreement, they will be creating a separate legal entity. Then they will be providing that entity with the money or other contribution to the asset of that legal entity, and in return that entity will be giving them a stake. Okay, so like Reliance gave money and the brand name, for that it received 60% of the stake in the company, and Big Bazaar gave expertise, manpower and market, for that it received 40%. So your entity is different from the founders, that is, it is very different from Reliance and the Big Bazaar. So as I told you, it can hold its own asset. So once assets are transferred to your joint venture, it no longer belongs to anybody else, but it is that of a joint venture only. Can legally hold it because it is having a separate legal entity character. So each party becomes owner of the company by having equity stake in the company. I hope this is very clear. Now they agree together for a specific purpose. They do the contribution in the company as per the percentages, and each and every hold the decision making power as per the contributions given and role played by them. Now basically what is a equity joint venture? Profits and losses are shared among the parties. Okay, so now we are going to see basic features of an equity joint venture. What are the basic features which equity joint venture should have, or the key characteristic? If equity joint venture is there wherein both the parties are distributing their profits and losses equally, do you think it's an equity joint venture? It's not always required. So let's see what are the characteristics. There is an agreement by two or more entities to create a new entity. This is an agreement. Second, the ownership is shared by these entities, that is co-founders. The management is also shared by both the parties. The responsibilities are also shared, and profits and losses are also shared. So these are the 5 characteristics of an equity joint venture. First, there is an agreement to form a new entity. Second, sharing of ownership, sharing of management, sharing of responsibility, and profits and losses. Very important key characteristics, very important from your exam point of view. Now, there is an exception to the rule. What is an exception? We are going to see that. Listen to me very carefully. We have seen there are various characteristics of equity joint venture. Okay, there are characteristics of an equity joint venture. First one is formation of a new entity. Second one, shared ownership. You can write the points with me so that when you write, the points will be fitted in your mind. You can never forget that. Then you have shared management. Then shared profit or losses. And fifth one, pooling of the resources. Yes, that is shared responsibilities. So these are the 5 characteristics of an equity joint venture. But it's not required that all of this have to be complied. It's not required that all of this have to be complied. In certain joint ventures, they may or may not be complied. Even then it is a joint venture. Like, I will make you understand one concept, something called as an SPV. SPV is nothing but a special purpose vehicle. Okay, SPV is a special purpose vehicle. This SPV can be formed by one or more entities. Joint venture is formed by 2 or more entities. SPV can be formed by one or more entity. If Vandita Doshi Private Limited is there, I want to enter into a new business, very risky business it is. I will not start that business in my company because my company is very stable. Rather, I will create an SPV for doing that business. So only Vandita Doshi Private Limited will be holding 99% of share in that company. So it's an SPV, special purpose vehicle. But in joint venture, 2 or more entities are required. In SPV, only one or more entities are required. Right? This is the difference between the two. So sometimes, okay, now I am going to write something very, very important. Sometimes your joint venture looks like SPV. Sometimes your joint venture looks like SPV. How? Let's see that. Now, there is a company over here in India called as Technology Private Limited. There is a company in India called as Technology Private Limited. Now, this Technology Private Limited, it wants to launch one particular product relating to the technology. It's an invention. Basically, it's an invention. But for this, for launching this product, they need help from a US based company. They need help from whom? A US based company called as Techfra Limited. Okay. So when this Technology Private Limited approached Techfra Limited that I need some of your resources in my company, Techfra really liked that idea. Techfra put a proposal in front of Technology Private Limited saying that, are you interested in forming a joint venture with me? If you will form joint venture with me, I'll be giving my inputs for free. So Technology Private Limited thought this would reduce the cost. Yes, and markets also will be bigger. Why? They can go global as well. Okay, so it's a benefit of both of them. So both of them decided to form a joint venture. But this Techfra Limited, it was very smart. It said it will give its input. But right now, at the current stage, Techfra shall not invest in JV. So Techfra will not be holding anything in the JV. Why? Because till now that JV is a pre-revenue model. It only want to invest in the post-revenue. So Techfra Limited says, even though I'll be giving you my product for free, see what is the requirement of a JV? 2 partners, 1 purpose, and pooling of resources. Don't you think Techfra is complying with all the requirement? The answer is yes. There are two individuals, that is two business groups. Second, they are coming together for particular purpose. And third, both of them are giving something, right? TechFry is also giving its resources, right? Only it is not investing. So your technology private limited, it said yes to this. So there was a deal. Now what happened? Listen to me. They both of them formed a joint venture agreement. There was a joint venture agreement to form a new entity. This requirement is done. The name of the new entity will be Tech2 Limited. But this Tech2 Limited will be entirely whole, that is 99.99% of this shall be held by Technology Private Limited. It will be held by whom? Technology Private Limited. So don't you think it is looking like SPV? Only one individual holding. So apparently it looks like SPV, but do you think it's an SPV? No. Because TechFra has also given its resources. So this proves that it is not necessary every time to fulfill all the characteristics in JV. Sometimes your JV may look like a SPV. So over here, to keep its own footing, TechFra can make various clauses in the joint venture agreement saying that post revenue, if I feel that the company is profitable, I may invest. Okay, so it may take equity shares on complying certain condition, but right now only one investor is there in this. So this is not an SPV, but it is a JV. Okay, I hope you understood this. Now let's go to the theory part. When we read that, we'll understand this concept very nicely. So there are certain circumstances when your joint venture will be indicating like it's an SPV. So it's not required that 5 characteristics be fulfilled. Sometimes it is not, and that is perfectly fine. So one of the party to agreement may provide for investment but not have any say in the management. That is okay. Also, a foreign company may want to exercise management control even though it is not investing in the JV. So typically, a foreign company is providing technology and knowledge-based inputs. It may want to ensure JV is managed at per its direction. But is it contributing? No. So it may look like a SPV, but it's not SPV, but it is a joint venture. I hope you have understood what is a equity joint venture. Now let's quickly go to the contractual joint venture. What is a contractual joint venture? I said over here in contractual joint venture, we are not going to create a new entity. New entity is not formed. Just imagine students, you are taking franchisee from Starbucks. Is Starbucks going to invest? No. You are just paying the royalty for them to use that name. Right? So there will be a joint venture agreement between you and a Starbucks wherein terms and conditions will be put inside. That's it. So we are not forming any entity in this. Starbucks may not have the control on your entity also, only few control will be there. That's it. So what is a contractual joint venture? Where there is no separate legal entity formed. There is no separate legal entities formed. Two parties, they do not share the ownership because ownership will be shared by you only. You will be only owning that. But each of the party will exercise some elements of joint venture. So what is a contractual joint venture? Separate legal entity is not formed, first one. Second one, two parties do not have control. Third, parties may have some elements of control. Understood? Very important it was. After that, This contractual joint venture sometimes can be for specific purpose, very narrow time. Also, it may be for series of transactions, so even that is okay. After that, relationship is formed by contract or an agreement. So, contract or agreement is very important in the joint venture. Okay. So, how do we enter into contract and agreement? With the help of healthy negotiation, wherein the rights, responsibilities, duties, everything will be reflected in an agreement. So, best example of contractual joint venture is a licensing agreement, your technical know-how. If you are taking services from the Microsoft, are you owning the Microsoft? No. It is allowing you to use their services because you are paying something for them. That is a licensing agreement. Understood? When that is a contractual joint venture. You click on that button, no, I agree to the terms and condition. I agree means you are entering into contract. So be very careful guys when you're clicking on I agree. Got it? Technical services, then assistance agreement, franchisee agreement, all other commercial matters will be covered in that, will be called as a contractual joint venture. Now, what are the characteristics of a contractual joint venture? I gave you the best example of contractual joint venture. Please remember it's an franchisee. So, what is a contractual joint venture? Two or more parties will be having a common intention. Each party will be bringing some input, some raw materials in that. Each party may be having some degree of control. Entire ownership is not there. Ownership is only there in the equity joint venture. Then it may not be for a particular transaction but for the series of the transaction. I hope this is very clear. So, what did we learn till now? What is a joint venture? What is a equity joint venture? What is a contractual joint venture? In equity, we form a separate legal entity, a new entity. It can hold the asset, it can do everything on its own. It is not dependent on its co-founders or the founders. Also, ownership criteria is there in the equity. In contractual, there is no ownership, only some elements of control are there and new entity is not formed. I hope you have understood this much. Now, let's see what are the different kinds of joint venture we can form in India. So, first one is a company. Till the time LLP came, company was the only joint venture where foreigners were interested. Why? Because all other forms of organization have unlimited liability, but your company has a limited liability. Even after formation of LLP also, LLPs were not open for the foreign direct investment. It was in 2015 major amendments had come and post that FDI was allowed in a LLP. Till that time for foreigners the best JV option was a company. But now once FDI is allowed in your LLP, the best JV option for them is a partnership. Best JV option for them is an LLP. So, is FDI allowed in the company? The answer is yes, FDI is allowed, but they have to comply with the FEMA regulations, FDI regulations. Okay, what is a company and all? We have already seen the basics of that, so we are not going to learn this in this video. You are just supposed to read it once, that's it. What about the LLP? LLP is a firm registered under LLP Act 2008. Till 2015 FDI was not allowed, but in November 2015 it opened the gates for FDI. Now a foreigner can also form a joint venture, that is LLP, in India. What about the venture capital fund? I have told you there are various kinds of trust or the funds. These venture capital or a foreign venture capital trust or a fund, they should be registered with our SEBI. If they are registered with the SEBI, they can do 100% investment in the Indian entities. But what is the prerequisite for that? They should have investment, they should have registration with the SEBI. After that comes your trust. What is a trust? In chapter number 7 we have seen What is a trust? It is one of the non-profit organizations. But those organizations we are not learning here. In those non-profit organizations, joint venture is not formed. It is prohibited for the foreigners. So foreigners cannot do FDI in the trust. Understood? But there are certain trusts which are registered with the SEBI. Now which are those trusts? Real estate investment trust. Then we have infrastructure investment funds, alternate investment funds. These are SEBI registered trust, and in this 100% of FDI is allowed subject to FDI regulations under FEMA. Okay. Last, other entities. So except of this company LLPs and the registered trust with the SEBI, no other entity can be formed by foreigners because FDI is not allowed in them. So foreign companies are not allowed to use any structure other than those which are mentioned for the equity based joint venture. Yes, contractual based can be done, no problem. Equity based joint venture cannot be done except of company, LLP and the registered trust with the SEBI. I hope it is very clear to all of you, right? So now we are going to see there are certain restrictions on the FDI policy. So let's first understand what is an FDI policy. See, whenever there is a foreign exchange, what is a foreign exchange? Indian currency is going out by converting into a foreign currency, or foreign currency is coming into India by converting into an Indian currency. So when there is some foreign exchange over there, which law is applicable? This we have seen in chapter number 2 also. FEMA is applicable. Under FEMA, there are two types of investment. First is a foreign direct investment, FDI is a foreign direct investment. Another one is a ODI. ODI is an overseas direct investment. So in foreign direct investment, what happens? Foreigner comes in India for investment. So foreigner wants to invest in India. That is a FDI. What happens in the ODI? So vice versa. India is going out to invest in the foreign country. That is the overseas direct investment. So over here restrictions we are going to learn is about the FDI restrictions. About ODI we are going to learn in chapter number 11. That is in the next chapter. So let's quickly see what are the restrictions under FDI policy put by our government of India. All of the restrictions are not there. The details of FDI you will be learning in your FEMA. That is your part B, group 2. So first restriction is for citizen of Pakistan or Bangladesh. Citizen of Pakistan or Bangladesh. If any citizen of Bangladesh or any citizen of Pakistan, they want to invest in India, first they have to take approval of RBI. So they have to always come by approval route. They are not allowed to invest by a automatic route. Now what is the approval route? What is automatic route? This we have already seen in chapter number 2. Right? So citizen of Pakistan, citizen of Bangladesh, if they want to invest in India, they have to first take permission of RBI, only then they can do the investment. So prior approval of RBI is compulsory. Also, there are certain sectors wherein they are prohibited from the investment. So this Pakistan and Bangladesh citizen, they cannot invest in the following sectors in India. Now which are those sectors? Defense, that is our army, atomic energy, And the third one, space. So they are not allowed to invest in defense, atomic energy and the space because they are very important for our country, and these countries basically are always in the position of war with us. So we have to be very, very alert for that. Okay, so I hope you have understood the first restriction of FDI. If citizen of Pakistan or a Bangladesh, they want to invest in India, first they have to take prior approval of RBI. So they can only come by approval route, and they are prohibited from investing in defense sector, atomic energy sector and the space one. Got it? The second restriction we have is regarding citizens from Nepal or Bhutan. Citizens from Nepal or Bhutan. So, NRIs is non-resident Indians. People who are Indians but they are not resident in India but they are resident in Nepal or Bhutan are called as NRIs of Nepal or Bhutan. So whoever are NRIs from Bhutan or Nepal, these NRIs can invest in India. They can invest in India but only on repatriation basis. Which basis? Repatriation basis. Now what is repatriation? Repatriation means wherever is a source of money, ultimately money should go there only. That means if any of the NRI of Bhutan invested 10 crores in India, the maturity was after 5 years. So when the money got matured, 10 crores along with the interest coming around 11 crores say for example. So when 11 crores got matured, can they invest that money in India? The answer is no. This 11 crore has to be taken back to its country. That is called as a repatriation basis. So whatever amount is put in India, they have to taken back once the process or the business is over. It cannot be invested in India. So NRIs from Nepal and Bhutan, they can invest only and only on the repatriation basis. So what is a repatriation? Funds to be taken to its original country. That is called as an repatriation basis. So first condition is repatriation and second condition talks about it should be in free foreign exchange. We cannot put any rates. That means you can only deal in US dollars. Okay, you cannot deal in any other currency. So that is a free foreign exchange. So first restriction is repatriation basis. Second restriction is only and only in free foreign exchange. This is for NRIs from Nepal and Bhutan. After that comes a third restriction. Third restriction is about your FII. That is foreign institutional investor. Foreign institutional investor. Now this foreign institutional investors does two kinds of investment. First is FPI, another one is FDI. So first one is FPI. FPI is nothing but it's a foreign portfolio investment. What is it? It's a foreign portfolio investment. And the second kind is FDI. FDI just now we have seen, right? FDI is foreign direct investment. So one was foreign portfolio investment, another one is foreign direct investment. The difference between these two is, in this foreign portfolio investment, they are just interested in the return. So they want to make their portfolio very strong. So they are interested only and only returns. But what about FDI? They are not just interested in the returns, but they want to control the decision making power. What they want to control? The decision making power in the company. So this is the difference between the FPI and the FDI. Got it? So FPI and the FDI. So over here we are going to look about the FPI. What are the regulations for FPI? So when any foreign institutional investor does FPI in any of the Indian entity, how much they can invest? The individual limit is restricted up to 10%. What is the individual limit? One FII can hold 10% of FPI in Indian entity. This restriction cannot be there for FDI. Why? Because in FDI we create the subsidiaries, wholly owned subsidiaries, wherein minimum investment required is 50% or more than that, or sometimes even 99%. So this is just for the FPI. So individual limit is 10% and the aggregate limit. Aggregate limit means in one particular Indian entity how much FPI can be there. It is total of everyone's holding. Whose FII is holding? Who is holding as an FPI? Please remember, not FDI. So aggregate holding not exceeding 24% of capital in Indian company. What is the limit? 24% of the capital in the Indian company. This is the limit. This limit, this 24% limit, this can be increased. This 24% limit can be increased. How? We have to follow a procedure for that. What we need to do? We need to follow procedure. What is the procedure? First, we have to convene a board meeting. Who has to convene? Indian entity has to convene on this. So board meeting, board resolution. Second, general meeting, special resolution. And third one, we have to take prior approval of RBI. Okay. So any Indian entity, it wants to have more investment of FII as a FPI, it needs to follow these 3 steps: board meeting, board resolution, general meeting, special resolution, and prior approval of RBI. If these 3 things are complied with, it can have more investment of any of the FII in the form of FPI in this. Now, how much can be increased by this procedure? They can increase this limit of 24% up to the sectoral cap. Now, what is this sectoral cap? Every year, this sectoral cap changes as per the RBI. Sectoral cap means in an Indian company which is in particular sector, say for example insurance sector, how much foreign investment is allowed? This is called as a sectoral cap. So now the sectoral cap for insurance has increased from 49% to 74%. So the sectoral cap for insurance is 74%, right? So in an insurance Indian company, how much foreign investment we can have? Up to 74%. This is called as a sectoral cap. I hope you understood this. Now the next restriction, 4th one, We have FVCI. Now what is FVCI? It's a foreign venture capital institution. Foreign venture capital institution. Now if this FVCI is registered with the Sebi, if this FVCI is registered with the Sebi, then they can invest 100% in Indian entity. How much they can invest? 100% in the Indian entity. There are no other prohibitions for them. But what is the requirement? They should be registered with our SEBI. I hope this was clear. Okay. So I hope you have understood all the restrictions. Let's revise all of them one more time so it will be very easy for you. The first one we saw about the citizen of Pakistan and Bangladesh, only approval route, no automatic route, and they are prohibited from investing in sectors like space, atomic energy and defense. The second we saw about Nepal and Bhutan. So NRIs from Nepal and Bhutan can invest in India, but only and only in free foreign exchange and on the repatriation basis. Third, FIIs, as far as FPI investment is concerned, the individual limit which an Indian company can hold is 10%. Aggregate limit is 24%. This 24% can be increased to the sectoral cap by following 3 steps: taking board resolution in board meeting, special resolution in general meeting and prior approval of RBI. Last point was about the FVCI. The registered FVCI who is registered with the SEBI, they can invest 100% in the Indian entity. So that's all with the FDI restrictions. Now let's start with our next topic, that is LLP as an SPV. What is SPV? I have explained you earlier also. It's a special purpose vehicle which can be formed by any of the business organization for a special business or a special purpose. Now SPV can be formed by one organization also, but for JV we require 2 organizations. Now we are going to concentrate on an LLP. Now let's recollect what is an LLP. It's an entity which is registered under LLP Act 2008. It's same like partnership firm with a limited liability concept which is having a corporate status. Okay, this we know about the LLP. Now LLP can be formed as per the 2008 Act. So this concept came in 2008. But after that it was not allowed to receive the foreign investment. So FDI route was closed for the LLP. Subsequently, it was realized by our government of India that if we open the doors of FDI for the LLP, it would bring in huge FDIs. Why? Because the foreign parties, they like to invest in India, but the organization or entity is very rigid entity, that is your company. Because foreigners know that it's very easy to form a company, but it's very difficult to wind up a company. In order to pave a way for FDI in 2015, that is in November 2015, Government of India opened the FDI gates for the LLP. Okay, so from November 2015, LLPs welcomed the foreign direct investment. After that, we saw huge FDIs coming in India because LLP was very simpler as compared to the company. When I compare a company and an LLP, I would definitely prefer LLP over the companies. Why? Because the formation is very easy, less compliance as compared to the company, less cost of maintenance as compared to the company, and if we have very less creditors or no creditors, we can wind up the LLP very faster. So all this has paved the way to huge FDI through LLPs. So your foreigners really like the LLPs to be invested. So LLP complies simplicity of partnership and advantage of limited liability. This is a combination of two, a golden combination I can say. So as I told you earlier, 2015 was a turning point. Foreigners were allowed to do FDI. Foreign companies are not permitted to invest in the partnership firm. Why? Because our FEMA does not allow that. Okay. Also, it was not allowed in the LLP till November 2015. But suddenly, November 2015, foreign companies were allowed to invest in the LLPs. So, SPV can be formed. I told SPV can be formed by one or more individuals. So, foreign company and Indian company can form an SPV, okay, as an LLP, and it's very easy to be wind up as compared to the company. So now we are going to see what are the advantages of using LLP as an SPV. How questions will be asked in this? They can ask you straightforward question or little twisted question. How twisted? Twisted I mean they may ask you XYZ wants to form LLP, XYZ who is a foreigner wants to form SPV in India. Please advise as a company secretary which is the best form of organization for an SPV. Then you have to think about the LLP and tell advantages of LLP. Understood? The answer is same, but only the question will change for you to just confuse you. So what are the advantages of SPV? As we have discussed earlier, incorporation cost is very low as compared to the company. There is flexibility in rules of management and governance because management and governance basically depends on an agreement. It's not that difficult to change your agreement. So management and rules can be changed very easily. Partners in this can be anybody. It can be individuals, it can be company, it can be body corporates, anybody. So your companies can be the partners while the individuals can be the designated partners. This is how there is a segregation of ownership and the management. Maintenance cost is also very low as compared to the company. Why? Companies have to convey in the required number of board meetings. They need to do the general meetings. AGM is compulsory every year. They need to file certain forms every year. It is event-based compliance, also the regular annual compliances. So, in comparison with the company, LLP is more cheaper. After that, all the LLP need not get its accounts audited. Only those LLP whose contribution is exceeding 25 lakhs and whose turnover is exceeding 40 lakhs, only those LLPs have to get their accounts audited. Otherwise, it's not compulsory for all the LLPs to get the accounts audited. In the same lines, if we keep the company, be it a OPC, be it a private limited, be it a public limited, it needs to get its accounts audited, irrespective of the turnover, irrespective of the capital. Also, LLP don't have to pay the DDT, that is dividend distribution tax, because the income is not taxable in the hands of the partners. Winding up of the LLP becomes very easy when we don't have creditors. So when we don't have creditors, we can go for the voluntary winding up. In that, NCLT interference is the least. You have to first finish off all the formalities and then just file the form for the winding up. But when you have the creditors, you have to go by the NCLT route only. After that, investment in LLP is allowed in both ways. Wherever you have 100% FDI, there you can go by automatic route. Where you have limited FDI, you have to go by the approval route. So basically these are the advantages of LLP as an SPV. Okay. Now let's start with the next topic, that is documents required for the joint venture. I hope you have understood till now what is a joint venture, what are the kinds of the joint venture, and now we are going to learn about the documents. Just imagine, just think of two entities, ABC Private Limited and another one is PQR Private Limited. So these are the two entities. These two entities are interested in forming a joint venture. These two are totally strangers. Do you think they will meet in the first time and they will enter into joint venture agreement? No, it does not happen like that. Because in joint venture there are various stages. So the first stage in the joint venture is a familiarization stage. Familiarization stage. At this stage, both the entities shall meet each other. They will indulge in healthy negotiation. Okay, so there will be meeting between the two entities and they will enter into a healthy negotiation. What is each and every person's business model? What are their expectations in the JV? What is a clear cut plan of both of them? Where do they see their JV? So very healthy negotiation happens between the two parties. Also they discuss about the resources they will be pulling together in the joint venture. This is a familiarization stage. So these negotiation can lead to various terms and conditions between the parties. At this particular stage, do you think they will enter into any agreement? The answer is no, because nothing is formalized. But yes, when they agree at a particular point, they will always want to log the terms and condition, and then there can be a document called as MOU, that is Memorandum of Understanding. Why MOU is very important? This is important because whatever parties have agreed, it needs to be locked so that they can further step into. MOU is not a formal document, but it is just a document to log the terms and conditions so that none of the party can backstep. Okay, understood? So that is an MOU. So MOU generally is entered into a familiarization stage. After that, once the MOU is entered into, each party would like to do something called as a due diligence. Okay, so due diligence is another step which we also call it as an engagement stage. So the second stage is an engagement stage. At this particular stage also, everything is not finalized, but yes, they are taking one step ahead. That is the engagement stage. Okay, in this particular stage they will be making or deciding or holding more of the meetings. They will be doing the due diligence of each and every party, collecting the resources, etc. So documentation will be at peak at this stage. The last stage, once everything is finalized, okay, now they want to enter into a joint venture agreement. So this is a final stage. The last stage, also called as a final stage. So final stage, various documents can be entered into, like joint venture agreement. If it's an equity based joint venture, then formation of a company, okay, then shareholders agreement, debenture agreement, so many documents are there. So please remember three stages of joint venture: familiarization, engagement, and the final stage. At final stage only we make the formal documents on which we pay the required stamp duty. Till then we just enter into MOU or the term sheet, that's it, nothing else. Okay, so let's go to our notes. Now, as I told you, first stage is a familiarization stage where both the parties try to know each other. Okay, they attempt to know each other. Then the second stage, as we discussed, is an engagement stage. Same happens in the marriage also, right? Arranged marriage. Yes, you can take that example. It's very good to understand. So at this level, the commitment is still not very firm. When you are engaged, you are very informal, right? Just and fiance. It can be broken any point of time. Yes, it's very easy. But once you are married, can you break that? You can, but little difficult, right? The same way, once you enter into a joint venture, it's very difficult to break it, because in marriage you have invested for your marriage, you have fed your relatives, you have given many gifts, so even there also you are losing your money, then your time, everything wasted. Same in the joint venture also. That's why before finalization, before getting married, it's always better to go through the familiarization stage and the engagement stage. So in the engagement stage, still we are not very firm, but yes, in the final stage, when each other, two of the parties, now forget about the marriage, don't come to the joint venture now, both have an understanding that terms and conditions are locked, both are happy with each other, they can enter into a joint venture agreement. So these three stages have different documentation. As discussed earlier, we have something called as a MOU, just mostly happens in the initial stage. When does it happen? Initial stage. For the due diligence and all, you need something called as an MOU. So it's a brief document, but it does not have more of legal jargon. So in MOU, what it states duties of both the parties and the roadmap, how are they going to deal with each other. So these are the main elements of your MOU. After that, in engagement stage, what happens? Parties will have little higher amount of resources, and there will be a well drafted legal agreements. For that, you can also take out the due diligence agreement for this. After that, once everything is finalized, you can start with your joint venture documentation. Joint venture documentation takes a lot of time. So joint venture agreement can be there. Shareholders agreement, if you are entering into LLP, then LLP deed is to be prepared. This has to be prepared, drafted very nicely. A layman, a businessman cannot draft such deed, but they will always need a company secretary professional or a lawyer to draft these agreements. That's why at the final level, we are taught how to do drafting. 100 marks paper is there. So we are going to learn that in final level. So basically in India, most of the equity joint ventures are a private limited company or a public limited company. But when you don't want equity, you can also have a option of an LLP. LLP is more preferred over than companies. In this drafting, your articles are very important, because article states the inner rules and regulations of the company. So when it states inner rules and regulations of the company, you have to be very sure what all duties, responsibilities you are putting on each and every founders. Got it? So it is advisable to devote time and attention to the articles. Please do not accept the standard shelf draft which is available on the Google. Google is not going to help us every time. We have to use our brains, we have to use our skills, because skills is the only thing by which we are known as a professionals. Okay, and we have to be very careful in drafting our articles or the company's document when our client is a foreign national. Okay, now we are going to see what are the essential features which we require to put in shareholders agreement. SHA means shareholders agreement, or the joint venture agreement, or the LLP partnership agreement. So basically this is not a government, so basically this is not a document, okay, for the government, but it is a Working document, like India has a constitution drafted, so it consists of rights, duties, fundamental rights of each and every citizens, duties of its officers. Same way, your shareholders agreement is also the working of your company. Like whoever is investing in, they will put their own rights, that what are the rights of investor. Definitely company law has given the rights to the shareholder, but when your investor is huge, he's putting 100 crores in your company, will he take the normal rights of company law? Obviously not. So shareholder agreement is not an agreement for court you are making, but it is for maintaining a good relationship between a company and its investors. So whatever additional documents or additional points they need to put as a right, it can be put into the shareholders agreement. So it should be drafted with the business essentials and the focus. Now, what are the key questions which every entrepreneur is bound to ask when he joins hand with another entrepreneur? This all you need to put in your SHA. Now, key issues which we have to keep in mind whenever we are drafting a SHA or a partnership agreement are follows. Very important from your exam point of view. Students, please do this carefully. Just read it twice or thrice. In exam, if it comes, do your own psychology. Psychology, I do not mean you have to write the movie's story and all. No. You have to just imagine the concept and write in your own words. In this chapter, you can do it. So what is the first point? Business of a new company or LLP you should keep in mind. Manner, extent of resources, who is putting what resources, how we are allotting the shares or what are the provisions for the transfer of the shares, what is the constitution of board of directors or designated partners in case of a LLP, how is your decision making process, whether it is majority or it is special resolution, then decision making power by chairman or a managing director, each and every person's right, duties, responsibilities. Then who is responsible for managing the finances, managing the marketing and managing the production. So each and every person should be given a duty in each and every sector. What is a dividend distribution policy? If investor is there, investor would definitely like to distribute the dividend, right? Then what are the terms of office of the directors? Their appointment, reappointment, their remuneration, everything has to be fixed. Valuation of company, who will do at the time of separation, how it needs to be done. And if there is any dispute, how to solve that? Are you going to the court of law or you are going to the alternate dispute mechanism like your arbitration, conciliation, etc. So these are the key points which everybody should keep in mind whenever we are drafting SHA, that is shareholders agreement, or a PA, that is a partnership agreement. Now we are going to see what are the essential components of a joint venture agreement. Essential components of joint venture agreement to be by hearted, only 5 points are there. So we don't have any legal format for them. None of the law gives you a legal format. But as a standard practice, we have evolved a format. So everybody has to comply with that legal format. If you see any other format, generally it is not acceptable. So the format is relating to different parts of an agreement. Any agreement you take, any agreement you have to draft in this way only. So the very first part comes the description of an agreement. Which kind of agreement it is? We write, no, this is an LLP agreement or this is an partnership agreement. That is called as a nature of agreement or what kind of agreement it is. Otherwise, if you have a sale deed, you can write this is a sale deed. This is a hypothecation deed. This is nature. Second part, we have full description of your parties to the contract. In case of a sale deed, who is a buyer, who is a seller. In case of LLP agreement, who all are the designated partners, who are the partners, everything with their detailed name, address will be given. Third, we have the recitals. Recitals means before formation of this particular entity, example LLP was formed, what was the position before? That means if Vandita Doshi and Mr. X has entered into an LLP, Vandita Doshi had given her property to the LLP. So we will write over there, whereas the property A belonged to Mrs. Vandita Doshi. Vandita Doshi has transferred the property A to the LLP, hence LLP is the owner of the property. So you have to say in the recitals what was the position before formation of LLP and after formation of LLP what is the position. So both of them you have to give in the recitals. So there you will get the exact intention of the party is what they want to do. After that, D part comes as a operative part. In this operative part, basically it's like your articles where rules, regulation, the working of the LLP or any of the partnership deed happens. So you'll be defining rules, then constitution of new entity, business of new entity, the investment, rules relating to loans, what activities can be undertaken, and role of each party, and constitution of the board, names of the chairman, MD, WTD, their rights, duties, their remuneration, milestones, etc. This is the operative part. The last part is the legal aspects. In this legal aspects, you will be writing if you want to change this agreement, how are you going to do the amendment in that? By majority resolution, by special resolution, how are you going to do it? So you have to write the amendments over here. Then what is the duration of a joint venture? You have to mention the duration of the joint venture. Along with that, you have to mention if you want to terminate the joint venture, how any party can proceed with that. If there is any dispute, where you need to go? Do you need to go to arbitration or conciliation, or you want to go to the court of law only? Then confidentiality, non-disclosure agreement. This we have seen in chapter number 9. I hope everybody remembers this. What is this non-disclosure? Non-disclosure talks about any partner or any person dealing with the entity. They knows the secret information because they are working with the entity. They cannot disclose this outside. This is a non-disclosure or a confidentiality agreement. After that, non-compete clause. Whenever any partner shall leave the organization, it cannot start with a similar kind of a business in the particular territory. That is a non-competing clause. Indemnification. If LLP or partnership suffers losses because of any partner, partner's responsibility shall be to indemnify the LLP or the partnership. And last, how to do the execution of each and every point which is given above. These are the main essential elements divided into 5 points. Please remember: A. Description, B. Parties, C. Recitals, D. Operative part, and E. Legal aspects. Very easy to remember. Great. So this was all about the documentation. Now let's start with the next topic, that is an SPV. I have explained you what is an SPV earlier. Okay. Let's understand this one more time. What is an SPV? Now there is a group company called as a Tata Group. There is a company called as a Tata Group. Now this group, it wants to enter into an insurance business. Which business they want to enter? Insurance business. But they are not sure whether this business will be profitable for them, because already there are players in the business, that is insurance business, many players are there, so they are not sure about it. And this Tata Group company is very healthy company. It's a very healthy company. It is enjoying huge profit. So business is running very well. Now they want to do diversification and enter into a insurance business. So what it plans? It plans to form an SPV. It plans to form an SPV, that is special purpose vehicle. So in order to start with the insurance business, it incorporates a company called as Tata Insurance Private Limited. Okay, it incorporates a company called as Tata Insurance Private Limited, wherein Tata Group invests capital. So Tata Insurance give them a stake of 99.99%. So basically this Tata Group is a holding company, and the Tata Insurance is a wholly owned subsidiary. So what are the observations from this? We have observed that a business entity for doing very risky business, they want to do the diversification or they want to do a risky business through a new entity. So they have formed a new entity in that. So there is a parent company, there is a holding or a parent company. So do we require two or more? No. SPV can be formed by one entity or more. It's not compulsory only one entity should be there. No. Even Tata Group and Reliance Group can come together and form an SPV. That is also perfectly fine. Okay, but the name given is SPV, Special Purpose Vehicle. So holding or a parent company is compulsory for the SPV. Now, tell me one thing. If this Tata Insurance Private Limited proves to be failure, it failed. So when they failed, there are huge losses. So is this losses going to affect the balance sheet of this Tata Group? The answer is no. Tata Group will have no effect of losses incurred by its subsidiary, that is an SPV. So what is the third point? Losses or failure of an SPV does not affect its parent company. Okay, so even though SPV goes bankrupt, that is not going to affect its parent company. So any of the organization, any of the companies, when they want to do very risky business, what they will do? They will always incorporate an SPV and do through that, so that even though business fails, the parent company is saved. The balance sheet of a parent company remains healthy as earlier. So even though your SPV goes bankrupt, it is closed down, it is not going to affect the parent company and vice versa. If something happens to the Tata Group, it is not going to affect the Tata Insurance Private Limited, that is its SPV. So I hope you understood the concept of an SPV. For joint venture, we require two or more parties, but for the SPV, only one is enough. Along with this advantages, there are various other advantages like tax advantages we have. So all we are going to see. So let's go to our notes. Now in SPV, what is an SPV? It is formed for special purpose. For your information, if you know about Mumbai Metro was a SPV between our government and the Reliance. Okay, so this was a concept of a SPV which was entered into between government and our Reliance. Okay, so it is formed for a special purpose. So once special purpose is over, SPV comes to an end. Simple. But joint venture, it can go forever also. Yes. Joint venture can be for specific purpose or continuing purpose. SPV is for specific purpose only. Okay. So this scope, that is scope of this kind of entities or companies are very limited. So they will be only achieving their specific purpose, nothing else. Okay. So once their purpose is attained, they will definitely close down the operations. They will not continue with the operations like your joint venture. Okay. Then SPVs are normally the subsidiary companies whose obligations are secured if parent company goes bankrupt. This we have already discussed. But SPV should be formed only and only for the lawful purpose. You can do the speculative business with this, that is okay. Speculative means risky business, that is okay. But you cannot form an SPV for illegal business, that's wrong. Can I form SPV for making bombs? Answer is no. Okay, so SPV can be formed only and only for the lawful purposes. So SPV cannot be formed for the unlawful purposes not supported by the law. So SPV basically it's a association or business organization association for participating in the business or the SPV. So it can be formed through whom? Limited partnership or trust or corporations or limited liability corporations like your company or any other entity. So SPV basically it's an independent body, it's an independent ownership, management, funding, everything independent. Insolvency of an SPV is not insolvency of a parent company. Please remember this. It also helps company to securitize its asset. What is securitization? I am going to teach you. It also creates a joint venture. It also isolates the corporate asset. So asset of a parent company are different and assets of the SPVs are very different. They both cannot be combined. Or they also perform their other financial transactions. Now, have you heard of a smart city project? Smart city project is taken by our ministry, that is Ministry of Housing and Urban Affairs, Government of India. It wants to have a number of smart city. This is a smart city mission which is entered into by the ministry along with each and every district level government. So this is a collaboration of two where they will have a plan for SPV. They will appraise that, approve, release, fund, implement, manage, monitor, operate, evaluate the smart city development. So this is a collaboration of central government, state government and your union territories board. So SPVs can be a limited company over here which will be incorporated at which level? City level. So each and every city will have a different SPV for a smart city project. Now if anything goes wrong with the smart city project, any of the city project fails, is it going to hamper your ministry? No, because SPV is very different. I hope you understood by now. Now let's see what are the benefits of forming an SPV. Why will anyone form an SPV? So SPV we form, biggest advantage, we are going to separate the risk and the capital we are going to free up. So anything happens to SPV, it is not going to hamper your parent company. So you call it as a parent company or sponsoring company, they will be risk free of becoming insolvent because of your SPV. SPV also allows securitization without disturbing the managerial remuneration. Now coming to the benefits, first one is ownership of asset. SPV allows ownership of a single asset by multiple parties. So many parties can own the single assets of an SPV. There is minimum statutory requirement. That's why over here the interference is less. The compliances are very cheap and very easy to set up an SPV. If you want to form a wholly owned subsidiary as an SPV, what you have to do? Just enter into a agreement. Okay, after that you can incorporate a company, that's it. If you are only single individual who want to form an SPV, no need to have an agreement also, right? After that, the documentations are also very clear. SPV have to do only specific purpose or specific objects. They will not do all other activities. So documents are very, very clear, and SPVs are prohibited from doing so many activities. This control will be kept by whom? Your parent company. After that, SPV has various tax benefits. What are the tax benefits? We are going to see that. After that, it provides a legal protection also. So if your SPV fails, it is going to protect your sponsor by legally. So Reliance can anytime say that, no, that was a project very different, I am not involved. So it's a distinct legal entity apart from its sponsors or a parent company. From accounting reasons also, it's very much benefit to incorporate an SPV because the debts of your SPV are not reflected in the balance sheet of the sponsor. So the balance sheet of the parent company remains very healthy in eyes of the shareholders or the stakeholders. Answer is yes. But yes, we cannot take disadvantage of that. Okay. It also helps to separate the risk and free the capital as well. Okay. It helps in separating the risk and freeing up the capital. Because of that, many insolvencies can be controlled. Then it allows the securitization of the assets also. Now what is a securitization? I'll tell you that. Even if you don't understand, that is okay. Now what is a securitization? Just understand this. There is a bank called as an Axis Bank. Now what does your Axis Bank do? Lending and borrowing. So Axis Bank has lended 10,000 crores. How much? 10,000 crores to someone high net worth individuals. And high net worth individual is going to repay this money after 10 years. Okay. Now, don't you think that 10,000 crore is locked? Yes. Now, Axis Bank cannot do lending of this, right? So, over here, the capital is locked. In order to free up this, in order to free up the asset, Axis Bank incorporates an SPV. It incorporates an SPV called as Axis Finance Limited. Axis Finance Limited. So, what it does, the main business over here will be securitization. Okay. So, what did Axis Bank does? This receivables, this is receivables, right? This will be received after 10 years. This receivables, it transfers to the SPV. So Axis Bank transfers the receivables to SPV. Now this SPV, what it does, with the help of this receivables as an underlying security, the help of receivables as an underlying security, it goes to the capital markets. It goes to the capital market and it issues debt instruments. It issues what? Debt instrument, and these are the secured debt instruments because the underlying security is your receivables. Understood? So Axis Finance gave this money, okay, in the form of security, debt security, to the people at large. Now, these people who subscribe, okay, these people what they will go? They will give money to the Axis Finance. How much? 10,000 crores. Right? 10,000 crores will be given by public at large to the Axis Finance Limited. Now this Axis Finance Limited gives this 10,000 crores to the Axis Bank. So Axis Bank got his money back before 10 years? Yes. So this is a securitization. Now there will be question in your mind, ma'am, why Axis Finance Bank does this? Why Axis Bank cannot do that? The reason behind is, if this issue, if this securitization fails, it is going to hamper the balance sheet of Axis Bank. So Axis Bank don't want to take any risk and it transfers this receivables to the Axis Finance Limited. I hope you understood this. With the help of this receivables as an underlying security, it issues in the capital market in form of a debt instruments, people pay them immediately. Now when the due date will come, these HNIs are going to pay to the Axis Bank. Axis Bank shall pay to the Axis Finance, and Axis Finance is going to pay the public at large. If something happens in between, HNIs don't pay, then what will happen? These receivables are that of Axis Finance now. Understood? So Axis Finance can sue the HNIs directly. They need not go to the Axis Bank for that. With this confidence, public subscribes to this fund. I hope you understood what is a securitization. The securitization helps the companies or the banks to free up their capital, because the capital is locked, no? That's why it is helpful to free up the capital. This is your securitization. Now, why we form an SPV? Yes, before that you would like to take down this, or you can take a screenshot of this, no problem at all. Okay. So, now let's go to the purpose of the securitization. Why SPV is formed? SPV is formed to allow a parent company to do highly leveraged or speculative business without endangering their entire company. So if SPV goes bankrupt, it is not going to affect your parent company. Then SPV, they raise funds from the market, or when government regulations specify creation of a SPV. Also SPV is created for large scale project. Okay. So wherever you want to do large scale project, the investment is huge, you generally go with the SPV also for the securitization. Then I have told you what is a main securitization. So total asset of bank of financial institution is loan and receivables. So this loan and receivables will be your underlying asset, and SPV is allowed to raise the debt on that. This is what I have explained you, right? Yes. Now, by securitization through SPV, risk involved in activities separated from the general business of the market. Then indirect acquisition of also happens by making an SPV. Now how does it happen? I am going to show you that as well. Please pay attention over here. Now this we are going to learn as a tax benefit. This is a tax benefit. So there is a company called as ABC Private Limited. This ABC Private Limited want to purchase this factory. This asset it wants to purchase for its use, but it does not purchase directly. Rather, it incorporates an SPV. It forms an SPV. Okay. Now this SPV purchases the factory. So it buys the property on mortgage. So by taking loan, it purchases factory. So SPV takes a loan. Now when it takes a loan, whatever installment they have to pay, this is tax exempted, right? So from the income of SPV, the installment money will be deducted. It will not be taxable. Clear with this? Now this factory, okay, this factory is given to this ABC Private Limited on lease. Okay, this factory is given to ABC Private Limited on lease. And who has given? SPV has given. So ABC Private Limited has to pay something called as a rent to this SPV. Now this rent which is paid by ABC Private Limited, even that is tax exempted. Correct? So whatever ABC pays to SPV, suppose 50,000 per month, that 50,000 will be deducted from the income of ABC. So don't you think two tax benefits are there? First benefit is on the installment and second benefit is on the rent. In order to gain this benefit also, main parent company does not purchase the asset directly, but it purchases through the SPV. I hope it is clear. Okay. So SPV can be used for acquiring asset indirectly for purpose of a tax saving. So sponsor takes the asset on the lease of its SPV. Expenses incurred as rent is allowed as deduction. Clear with this? Understood? So these are the various purposes why SPVs are formed. I hope you have understood what is the SPV now. And now we are going to see how to form or establish an SPV. Before that, I would like to tell you what is the difference between the company and the SPV. Do you think both are the same? Some of the characteristics of company and SPV are the same because generally all the SPVs are company. Okay, generally all the SPVs are the company. So let's see what are the common things in them and what are the differences between them. So SPV is an artificial person, company is also an artificial person. It has a legal character, company also has a legal character. Then there is an independence of members and they will be subscribing shares of an SPV. So SPV is different and members are different, right? Existence is legal existence in the eyes of law. SPV can sue and be sued in its own name. Even this is the characteristics of an company. Companies Act have to be followed by an SPV. So when companies have to follow the Companies Act 2013, yes. So these are the same or the common things between the company and the SPVs. Now, SPVs can also be a partnership firm. Okay, so we cannot say that all SPVs are companies. Okay, because SPVs can also be a partnership firm. Clear with this? Yes. So now there are certain difference between the SPV and a company. SPV is for special purpose or a specific purpose, but company can be for the general purposes, right? Company can be formed for the general purposes. Then SPV does only limited operations. Whatever is the aim of your parent company, only that much activity will be allowed in the SPV. Other activities will not be allowed. But in company, it can do all the things which is mentioned in the memorandum and which is permitted under Companies Act 2013. So I can say scope of SPV is very narrow. So memorandum of SPV is very narrow. It is not wide. Whereas memorandum of company may be broad enough to cover so many activities in this. So these are the points of difference between the SPV and a company. Now let's understand how to form an SPV. For an SPV, very important thing, there has to be a sponsor or a parent company. So what is the first requirement? There has to be a promoter company or a sponsor company which will free up their asset and give it to the SPV. So it's hive-offs or separates its asset into an SPV. So SPV is formed for isolation of its asset, like the receivables of Axis Bank were transferred to the Axis SPV, right? So this is called as a freeing of its risky assets. Because of that, parent company can be risk free of getting an insolvency. So performance of new entity is not affected by ups and downs of the parent company. Even though something happens to the parent company, that is not going to have effect on the SPV and the vice versa. Also, very few risk is there. Why? Because the property is belonging to the SPV. Like in the example of securitization, the receivables of 10,000 crores were transferred to the Axis SPV. So that anything goes wrong, Axis SPV can directly go to the court of law. So the risk is very minimized, and because of that it leads to confidence among its investors. So here there has to be a difference or distance between the sponsoring company and SPV. If your sponsoring company goes on dominating by having relationship of a holding company, then there is no sense of a SPV. It will be like your normal subsidiary company. Understood? So there has to be the distance, otherwise it will be a mere subsidiary which is not an SPV. So a good SPV should be able to stand on its own feet. It should be independent of a sponsoring company. Unfortunately, this does not happen. Holding companies create SPVs, that is subsidiary companies. They transfer all their risky asset there. They do the manipulation with the depositors. Thereby, depositors will face lot of issues. The one of the example was of Enron SPV from USA. So in US, there was an SPV called as a Enron. So the parent company of Enron used to transfer all its risky asset, all its bad debts to Enron SPV. Thereby, it led to huge crash in USA because all the depositors' money were there in Enron SPV, and the parent company balance sheet was clean sheet. So whoever is investing, nobody knew about the debts of the parent company. This is one of the disadvantage of an SPV. This should not be done. Yes, obviously then corporate veil will be lifted, and Enron SPV was called as a part of the parent company only. Okay. Now, SPVs are very much preferred for raising fund in the infrastructure sector. Infrastructure sector requires huge fund like building of bridges, roads, gardens, other amenities. For connectivity, infrastructure is very important. For building this, you require huge funds. So SPVs are preferred by all these infrastructure public sector companies. Okay, so there are different organizations like IDFC, that is Infrastructure Development Finance Company. You have Power Finance Corporation, Indian Rail Finance Corporation. These are the infrastructure finance company which raises fund for development or infrastructure project. So these infrastructure finance company, they mostly prefer SPVs. They make the SPV for raising fund. So if that project goes wrong, funding goes wrong, nothing will happen to its parent company. Okay. So SPV which they form, they will be a government company only. Okay, and they will add to long term funds for the infrastructure project. The same kind of project they are going to make for the smart city mission at the state level. So every city level there will be a SPV which will be a limited company, either private or a public limited, where central government, state government, ULB shall be the nominees on the board of directors. Okay, then this SPV will raise, plan, monitor, everything will be done for giving effect to the smart city project. So this was one of the example. Also there will be a private public partnership, like there was a private public partnership in the metro, Mumbai metro project, like the government, city level and the Reliance, they had a partnership for this metro project, the same system they want to make for the smart city. I hope you have understood this concept. What is the joint venture, types of joint venture, business collaboration we have seen, advantages, disadvantages, SPV and the requirements of SPV. That's it with this chapter. I hope you have understood this. It was a very easy chapter as compared to the other chapters. Now in the next chapter again we are going to some technical things, that is your FEMA. It's not so difficult, but yes, it's definitely interesting. Now let's solve certain questions of your chapter number 10. So let's solve this unsolved questions and then we will go for the solved one. So the first one, Roshan, an NRI in Nepal, is interested to invest in shareholders and convertible debentures of Indian company. Advice on can he undergo his investment? So when he is resident of Nepal, that means he is an NRI, correct? So can NRI do that? We have to look into the policy of FDI for that. I hope everybody is remembering that policy of FDI. So that is your answer. Okay? Yes. Apart from that, every equity based joint venture gives birth to a new entity. Discuss in brief different types of entity which are permitted by Government of India to form a joint venture. So over here you have to give description of different types of entities. Okay, like for example, if we want to form joint venture, then partnership, LLP. Okay, so all this we have to give along with how they can be funded. So over here you have to write what are the different types of entity which are allowed for a joint venture. We have already seen that. After that, what is the why concept of SPV has gained more importance on India? Basically, you have to write the benefits of the SPV over here. Okay. Then explain in brief what are benefits of SPV. Same kind of question. Next one, Kinetic Automobile Limited, an Indian entity, is in process of drafting a JV agreement for forming a JV with a foreign company based out in London to expand its business outside India. Explain the key points to be considered while drafting such joint venture. So basically the question is only this much. What are the key points to be considered whenever we are drafting any joint venture agreement? Okay, I hope you remember key points. I had marked for you that this kind of questions do come in exams. Okay, now we are going to see the solved ones. Every equity-based joint venture gives birth to a new entity. The answer is yes. Discuss in brief the different types of entity which are permitted by Government of India to form the joint venture. So let's see what they have written. It always gives birth to a new entity. That is correct. And as far as different types of entities for JV, we have company, we have LLP, we have venture capital, trust and other entities. In other entities, basically foreigners are not allowed to invest. Is it clear? Great. Then, promoters can avail numerous benefits by incorporating a SPV. So here we have to write what are the benefits of the SPV. Again, the straightforward question comes. Then joint ventures can be extremely valuable and chances of failure can be reduced to a great extent if strategically formed. Comment on important strategies of joint venture. This is also straightforward. We discussed around 7 to 8 strategies. I hope you remember. So all those strategies you have to write. Done? Okay, so these are the simple questions asked in the paper. Thank you so much all of you. We'll be meeting in the next lecture with the new chapter. Till then, goodbye.